bench. Yes.
Is that that?
No. No. Next circuit. Yes.
Only restoration application.
Yes, mention with the next circuit.
Let it be.
No, no. No further addition. Yes, Mr. Akash.
This also, the matter was heard on the last circuit. It was directed to be placed on 20th September, subject to the convenience of
Inconvenient to the court.
My lord, I had mentioned this matter.
It's all are well matter. Most of them.
Mentioned this matter yesterday as well. My lord, I'm under compelling circumstances. I'm mentioning again, my lord. The petitioner is practically on his deathbed.
On his?
On his deathbed, my lord. He's suffering from
Hello.
severe cardiac problem.
Yes. Yes. You.
No, my lord, this is for bail. Actually, on 13, my item number is 27 and 31, but I don't know. 31 is heard and granted bail on the same case.
Cite that before the next circuit? No, that is not a reason. It has gone out of the list. No upgradation.
Your Honor, your lordship,
No, then.
your accused petitioner is always
You.
On last day, there were two matters.
Correction of our order. This bench. Handover. Yes.
Your lordship, the accused petitioner is suffering from pulmonary tuberculosis and he is suffering from various medical ailments, your lordship.
Please mention before the next circuit. Yes.
Lordship, this matter, grant interim order was granted to the accused petitioner on medical grounds. Now, Lordship, on last occasion, there
For inclusion.
for inclusion in the list.
Mention before the next circuit.
Lordship,
3 days are left. No.
Lordship, may I be
Lordship,
No further mentioning. Please let us call on the list. No. Call on the list. Maybe. Yes. Call on the list. Yes, Mr. Chaudhary, what is that?
Yes, my lord.
What happened yesterday? 3 p.m.
It was not taken up.
The order was shown.
No, because
Automatic.
the other matter was going on.
Right. Yes, Mr. Chaudhary, let us hear the matter on merits.
Lordship,
We'll decide the appeal itself.
yes.
Just be precise, both of you, please.
Yes,
do
yes, I'll
it.
be very precise, my lord. I have a 3 folds of argument, my lord.
Right.
My lord, one is first and foremost, the learned trial judge
Yes.
has traveled beyond the scope and ambit and its jurisdiction because the nature of the writ petition, which has been disclosed by the writ petition, it is a public interest in nature, my lord. Then I will show you, I'll demonstrate, my lord, on the each and every paragraph, which what they have written. This is number 1, my lord. Number 2, the after filing of a charge sheet,
Yes.
in view of 173 subclause 2, my lord, the writ court loses its jurisdiction because if any grievances with regards to the undertaking the investigation which is not properly carried out, then 173 subclause 8, that my lord I will come out. This is my 2. Number 3, my lord, there is neither in the judgment, my lord, in the order by the trial judge, nor in the writ petition disclosed that the investigation has not been carried out properly. So, my lord, there is no imperative or anything has been shown that yes, the other investigating agency, the CBI or the other institution like ED should be given the investigation to be carried out for that purpose, my lord.
First, tell me, Mr. Chaudhary, what is the interest of CID in this?
Interest
What is
of-
your locus standi? I mean,
My-
suppose that has been done. Apart from your name being tarnished as an investigative agency,
My lord.
what else? And what interest can you have personally? The
My lord,
CID.
my lord, CID.
It is the state of West Bengal's appeal.
Yes. state of-
What interest stake can the
Malad-
state has?
Yes, my lord.
Unless you're trying to protect somebody.
No, my lord. None.
We are being very candid because that is the impression,
Not-
first impression.
No, we are not even lordship is sees that within the four corners of this records and the law permits.
No, on law, you are right. You may have a point.
Yes,
I mean, it's an arguable case, all the 3 points.
I even iota of any interest, my lord. I want this.
You want justice.
Through this investigation, truth should be revealed, which has been revealed, my lord.
Great.
No further by way deployment of other.
No, we get your point. Mr. Chaudhary, what was the crux of the matter? The initial writ petition, what was that?
Yes, Mila.
What was the release
Initial
shot?
writ petition, what
Yes.
is in the writ petition?
In a nutshell, please give us.
Yes, they have canvassed
Hmm.
that one Rindan Mohila Samobai Somiti.
Hmm.
They have in the name of in the form of a bank,
Hmm.
they used to collect the money from the depositors.
It's a registered cooperative society.
Yes, as per my investigation, is a registered cooperative society.
All right.
The document which has been seized, Mala.
All right.
And then thereafter, they used to the other persons, they avail the loan.
Hmm.
But my lord, as your lordship knows, and within the if it is cooperative society, then only the members can avail the loan, my lord.
Hmm.
No, the outside are not within the can come within the scope of that for availing the financial assistance.
That depends on your articles.
That is depends on.
Yes.
So, my lord, that is in nutshell. So, since 2000.
So here the loans were given to outsiders, or what is the scope of the writ petition? Who is the petitioner?
It's given to the thousands of people as per as has been canvassed. in
What is the cause of action for the petitioner in the writ?
Yes.
What is that? As per the disclosed cause of action?
As writ petitioner only said that we are the depositors
Hmm.
and we did not get back the money.
So they say there are irregularities in that.
Irregularities in that, but in a within the compass, my lord, what they have argued
Hmm.
that the thousands of peoples are affected, mass public in general are affected, and for this reason, for the money trail, this investigation has not been properly carried out.
So that's your PIL argument.
That is the petition, my lord. That is the
That is your PIL argument, the
Yes.
first argument,
what
that
is-
it's in the nature of a PIL.
yes.
All right.
Then in the prayer in the writ petition, my lord, what they have said, first prayer was that a report in the form of affidavit be submitted before this court to enabling the court to understand in what extent such investigation has been carried out.
Investigation was already going on.
Yes, my lord. CID, the moment writ petition has been filed, that time investigation was carried out. It was going on.
It was already going on when the writ petition was filed.
Yes, my lord.
On whose complaint?
Complaint, there is a writ petitioners.
The writ petitioners themselves had complaints. CID was carrying out an investigation.
Yes, my lord. Initially,
Yes.
the local police station has carried out in 2000 on the basis of a complaint.
When did the CID take up the investigation? After or before the writ? After the writ petition was filed.
No. In
Before.
2000 itself, my lord.
Good.
After 3 months.
Why
of
did the CID take it up at the first instance? Police was doing it. Why
Police
did the
was-
CID take up?
CID after 3 months, my lord.
Why?
Because the local police, they understood and made a request. That is
It is of a larger nature.
larger interests are also
Very well,
there.
very
So they are not even equipped with it, and the CID is trained to some extent.
Right.
That's why the CID had taken over the investigation, my lord.
Very well.
And
Yes.
there is no allegation that CID has not undertaken this investigation in a proper way. Now, this is the number one prayer. Number two prayer, second prayer was that a committee be formed under the supervision of the retired London district judge for the progress of the investigation, and in alternative, the CBI or ED, any agencies will be given such responsibility for causing such inquiry. This was the prayer and the writ petition. This was the whole in nutshell. Initially, the my lord Justice Sengupta, that what the order was passed, that a report be called for to understand in what extent the investigation has been carried out, and the state responded that we have almost completed the investigation in a comprehensive manner. We can submit such investigation in a form of a report, my lord. That is the beginning of that, my lord. Now, my lord, later that I will come later, my lord. Let us examine the writ petition first, then I will come to this the report, my lord.
Mr. Chaudhary, please, can you start with the order first? Then we'll go back to these things.
But the order will come little later, my lord.
Whatever you were. Yes,
My
fair
lord,
enough.
my lord, then all your lordship.
No. Let us start with the writ petition, because if you see the order, we can go back and there may be something striking in the order. We'll be looking into the materials in that
Then
perspective.
come to the order.
Because
very good.
whatever is against you has to be in the order primarily.
Yes, lordship.
So let us see that first.
Lordship.
15th of September. No, the first order was dated 24th of August, probably. You said. Yes, got it.
Thank you.
Oh, memo te
This is
ask karo.
of page 23, my lord. Can application.
Yes, in the memo we are
Same,
saying.
same.
Right. Please refer to the internal pages if you like. Yes.
Yes. Miller, the first paragraph and the first paragraph total in toto is the reflection of the story of the writ petition.
Mr. Chaudhary, let us just go through the entire order.
Entire order?
Yes, first entire order, then we'll go into the
Lordship,
your documents and all.
That will be better, Lordship. I have gone through a report filed by the CID, West Bengal, in respect of this matter, where one Alipurduar Mohila Rindan Samobai Samiti has failed to return the money to the petitioners who are depositors. From the report of the CID, it appears that there were 21,163 members of the society. It was not even a cooperative society, though it has used the words Samobai Samiti from giving the very name of the said Samiti, whose secretary and chairman are parties of this writ petition as respondent number 7 and 8. The cheating started. It has been alleged by the petitioners the money deposited by the members of the society shall be not less than 50 crores, Mala. Where from they have got it, I will come later, 50 crores. And this amount of money has given as a loan to different borrowers whose names are not known even after the CID investigation. The matter for last nearly 3 years. The borrower took the money, never returned it. Therefore, the said organization could not return the money to its members, including the petitioners, when they needed. The CID has not been able to bring out any substantial fact related to this matter, though they have investigated the matter for nearly 3 years. This is clearly a case of siphoning of money of the members from their deposit to the unknown borrowers, and now the organization is defunct. I direct the petitioners to add said organization one, a party respondent in this matter. From the facts and circumstances of the case, where a huge amount of money has vanished in the blue, I think this is a perfect matter now on failure of CID to bring out the most relevant facts, the names of the borrowers, etc. My lord, kindly mark it, I will come later. Names of the borrowers. If there is any at all, or the persons who have cheated the petitioners and others and the persons behind them as masterminds, I decide to hand over the investigation of this matter to CBI, my lord. This is the only observation. And also to ED to know the conspiracy of cheating a large number of depositors of the said organization, large number of depositors. And ED is directed to investigate for the money trail, and both the parties, CBI, ED, would start their investigation from tomorrow, that is 25th August. After receiving a copy of this order, and they shall have fullest liberty to interrogate, if necessary, interrogation after taking any person in custody whosoever are involved in this matter. CID's investigation shall remain stopped from today. By this time, my lord, we have brought to the notice the charge sheet has been filed. I direct the petitioner to add CBI Eastern Region Zone and also Enforcement Director of Eastern Zone to make party respondent to serve copy of this order upon them by this evening on 24th August 2023. The report given by the CBI, but ought to have been CID, my lord, shows their lackadaisical attitude in investigating the matter. And from the report, I have been shown CID has tried to fix the responsibility on some petty officials of the said organization. Well, how the learned judge has come, the petty officer, I do not know. And not the main culprits, or with whose blessings the culprits, those culprits were working in the cheating the huge amount of money of the poor people who are the depositors. It is very surprising to know that the Rindan Samiti, as name of the organization suggests, does not have the list of the borrowers. So what the CID or any other investigation agency will do, I'm coming. This matter is marked as part in art. Next part is very interesting one. It will be heard from time to time by this court from the principal bench when the parties, including the investigating agency, can attend the hearing through video conferencing, and if they think this court should come in the circuit bench at an important juncture of this proceeding, they shall have the liberty to pray for that by way of mentioning, and after obtaining the leave of the Honorable Chief Justice, if granted, I would be ready to come on any Saturday to hear out this matter in the circuit. CBI ED will file separate report before this court on 12th October 2023.
Yes. Now what you are placing?
Yes, my lord.
Yes.
Then in the next sequence, my lord, then I am coming. The moment we have seen this order, my lord,
No, you are going to place your writ petition
I'm
and all.
coming later, then this,
Whenever. Yes.
the next order I'm coming then.
Right.
Then, my lord, what happened? We have seen that despite, because there was a 3 consecutive days hearing took place on 21st August, 22nd August, 23rd August, then 24th August, the judgment order has been passed. In 22nd August, when the matter was taken up, when the report of the CID in a form of affidavit was shown to his lordship, then we said that there is a further instruction that is reflected in the order. Further instruction is required because by this time, charge sheet has been filed. On the next day, on 23rd August, the investigating officer has, by way another way of supplementary affidavit, submitted that the charge sheet has been submitted, which has not been reflected in the order. Then what happened? Then we have taken out the CID, particularly had taken out recalling and the modification of the said order within the very limited scope, particularly in the parent order by recalling application. Their lordship knows.
I think your report has been annexed to this application.
Yes,
The report which was one of the basis of justice, the
Yes.
learned Singh judge.
yes,
Very good.
yes, ma'am.
Yeah.
Now, my lord, the recalling application was shown and filed in the circuit bench on Monday, last Monday. The Tuesday, Wednesday, Thursday, we could not move the matter by way of mentioning because the learned trial judge did not sit in the court. Then on Friday, my lord, I sent my learned junior. He sought to intervene in the matter and mentioned the matter that we have filed a CAN application, my lord, pending before the circuit bench Jalpaiguri, which is required to be listed, my lord, and he has taken my name. The AAG will appear and argue in this matter. Then the lordship has seen the yesterday, this order has been passed on the threshold, rejecting, imposing fine, and the CBI to take over the 3 days. This is the order passed, and your lordship has examined the order yesterday.
Have you ascertained whether you have handed over the records?
Yes, I have asked. I'll come. I have not handed over. I have not handed over. I have a copy. What happened then? I am also referring because without wasting time.
No, take. Yes.
Then, my lord, the CBI went to the residence of the public prosecutor, district public prosecutor of the Alipurduar district, shown the order and said, "This is the order passed by the learned judge. You please hand over the case diary." Then the handover and the handing over and the taking over such report has been prepared, which has been forwarded by the learned PP of the state district, Mala, which I will place on the last one. May I place it there?
That was probably in compliance with the order, Mr. Chaudhary.
Yes, my lord.
What else could the CBI do? I mean, if there's an order, CBI has to take it.
Has to take it because this is also, I have, my lord, kindly see, this is the
So it was taken from the PP.
only order.
PP was representing the CID, wasn't he?
PP actually the special, it has been designated as a special
Public
special act, a special court. He is in charge of the special.
So why do you say the CID has not handed over? I mean, under compulsion of a court's order, definitely, but it is the CID through the PP who has handed over. And
PP,
what else?
Definitely the moment charge sheet is over, charge sheet is filed.
Hmm.
PP has no role and CID has no role even. Because it is the
Now, there was a direction on you to hand over the
it is
records. Records must be lying with somebody. It was with the PP.
record with the court. We have a duplicate.
PP
copy.
handed over all certified copies.
All the duplicate copy of this.
Duplicate
Not
as in
original CD.
duplicate as in which sense?
Original CD.
No, duplicate in which sense?
Duplicate sense is
No.
the photocopies of the original.
Achha. So the scissor list reflects that, Mr. Chaudhary, that those are not originals.
This is not a Caesar list actually.
I'm not a scissor list exactly. I did
The handing over the document.
right.
It shows that the original from the
Apparently, the case records are yes, very good.
This is the documents which they have taken out.
So let us come to the merits.
Yes. Now, kindly see the writ petition once. Writ petition, my lord, at page 28, starts from page 28 of our candidates.
So we'll be using this color coding. This for you and this for him.
Red should be for CTI, my lord.
28. No, it will be easier to remember. Yes. Page 28.
Page 20.
28 is just a
Yes. The main starts from 38, my lord.
30.
Originally.
Right.
38. First paragraph.
Yes.
I
Yes.
was not planning to read, I just converting you. My lord, the
Yes.
paragraph 1,
Right.
kindly see the third line.
Oh, Mr. Mujumdar is also there. All the culprits are there. The usual culprits. You're the main one, right?
Brother, the elder brother.
Yes, he's the main culprit, actually. Yes. Yes, Mr. Chaudhary.
Elder brother.
Yes. Let us continue.
My lord, the deep-rooted scam, second line,
Hmm.
wherein hard-earned money of several thousands of individuals, started third line, residing in and around Alipurduar. Next, after 3 lines, my lord, despite institution of a first information report and registration of a criminal case,
Hmm.
the respondent authorities have deliberately failed and neglected to initiate any appropriate steps for taking the matter into a logical conclusion, once ending with a charge sheet, and had further failed to trace the money trail wherein several crores of rupees belong to the public
Hmm.
have been siphoned off. Next, my lord. Paragraph 5. The third, last paragraph 5, last 3 lines, my lord. Disburse various categories of loans stroke financial assistance and had been alluring the public in general to avail credit facilities from the state Somiti. Now, from the top of the said paragraph, after third line, my lord, kindly see, at all times, the State Somiti had canvassed itself to be a society, an authority of bank, and had encouraged the public in general to deposit the money in the State Somiti.
Hmm.
Now, my lord, 6th paragraph, second line. Said entity, several citizens who belong to lowest strata. Then, my lord, 4th line. Representatives in availing small loans from the said society. Then, my lord, paragraph 7, next paragraph. From top 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10th line, my lord.
Hmm.
In view of such activities, don't you got it? Said
Yes.
Somiti, the innocent citizens staying in and around Alipurduar had been induced to believe. Then, my lord, after 3 lines, 4 lines, some of the customers of the state Somiti has also availed loans and financial assistance. Then, and power authority to disburse loan, financial assistance, and or accepting public deposits.
Hmm.
Then, my lord, paragraph 8. Paragraph 8, 1, 2, 3, 4. Who can elude small depositors in a larger scale. Then, my lord, last line, which shall amount to several crores of rupees. Now, my lord, paragraph 9, 1, 2, 3, 4, 5th line. Being demanded by the depositors. This is the first time only it has been canvassed, the petitioners or the depositors. When such information as regards their inability to repay within the locality, several hundred of depositors immediately approach the Somiti and its office bearers seeking refund of their principal deposit amount during January, February. Then this committee immediately collapsed and the office bearers were residing in and around Alipurduar immediately fled away, defrauding, thereby duping and defrauding several thousands of its depositors. Then, my lord, they himself stated, after 4th line, the immediately newspaper clipping and several complaints, first information, the local police, Alipurduar police station, complaints on 5th March 2020, the Alipurduar initiated case being number such and see on the same day, on 5th March 2020. Under the provision of 406, 49, pursuant to such first information, relevant documents were seized from the premises of the said Somiti and subsequently individuals named 1, 2, 3, 4, 5, 6 were arrested by the local police. Then, my lord, paragraph 10, second line, the authorities could not trace out the money trail as to how such huge amount of public money has been siphoned off. Now, my lords, third line, there have been no substantial progress in the investigation as to who had orchestrated such an organized fraud and how such huge chunk of money have been siphoned off. the investigating authorities also could not figure out the masterminds who are behind such crime. My lord, under 161 statements, the statements have been recorded. They could have said this is the person of the mastermind. Under their BS, this fraud has been committed. My lord, if this, because we have annexed the charge even. But I am coming then. Paragraph 11.
Who are these persons who have been named in the
They are
FIR?
they are the manager of the society. They are the loan officer,
Achha.
loan or whatever. The loan
They are the officials of the society.
officials,
Hmm.
and also, my lord, we have sought for a permission for a sanction against the two government public servants.
Achha.
That I'll come, my lord.
Yes.
Considering the gravity of the offense, the investigation was subsequently handed over to the criminal investigation department, West Bengal. However, my lord, it is a suo motu, my lord. We thought it. There is no such any prayer or any intervention of the court.
Right.
Now, my lord, no fruitful outcome is yet visible for best reason not to respond authorities. Then there are reasons to believe that the investigating authorities are hand in glove with the key persons who have organized the said crime in a systematic and well thought manner.
Hmm.
Then, my lord, paragraph 12, the petitioners further respectfully submit that irrespective of the progress of investigation, my lord, irrespective of the progress of investigation, larger public interest requires that the trail of money as to how the amount deposited by the thousands of depositors had been collected by the said committee without having any lawful authority, and how such huge amount of deposit has been siphoned off, and the manner in which the said money has been subsequently utilized requires to be traced out. Well, then the paragraph 13 said the money should be recovered, should be trailed, and should be redistributed, and investigation should be carried out in a fair, transparent manner to identify the actual culprits who had orchestrated such a fraud and a massive level and further directions and all that. And then, my lord, is a ground after a prayer which I have seen. So, my lord, if you yeah, my lord, my junior is rightly, last line of the paragraph 13, traced out and recovered in the best interest of the justice and public interest. So, my lord, the whole petition is in a nature of a public interest litigation, but each and every line and each and every paragraph which has been demonstrated, and then it has been culminated into this writ jurisdiction, my lord. So that's why I said, taken as snatch the jurisdiction of the Honorable Chief Justice, who is the only jurisdiction having power vested upon him to take.
Mr. Chaudhary, suppose a private interest that, I mean, there are elements of public interest also. I mean, why should the court's hands be shut out just by saying that it's a public interest litigation? I may have a private interest which has components of public element also. So why can't the single judge take it up?
My lord,
This is not an absolute bar. The Chief Justice is the master of the roster. He takes PIL matters.
my lord,
But this is not an absolute bar. I mean,
not absolute bar, but if
writ court, if the writ court feels there are individual cause of actions also, as well as a public element involved, what is the bar in the writ court? I mean, going into the matter.
public element in
This is only on your first point. Public interest,
my lord, there is a public element involved, my lord.
Maybe, yes.
Yes, my lord. Then
There are individual causes, Mr. Chaudhary, where public elements are involved.
but individual clauses, my lord. Kindly see here the writ petitioners are 11. What I have understood from the investigating officer, their deposit of the amount hardly 4 to 5 lakhs. Hardly 4 to 5 lakhs.
To them, that may be their entire lifetime savings.
A limited scope.
That may be the lifetime savings, Mr. Chaudhary.
In a writ petition, how can they can ask that the amount to be recovered for whole depositor to be redistributed, and for that investigation is required for by a separate agency.
All right.
This is the reason.
Right.
Well, the second point.
Charge sheet has been filed, writ court loses jurisdiction.
Yes, ma'am. Well, I will come that last second point which I have taken out, that there is a true reflection of the investigation. There is no iota of bias or element of any sorts of latches. So there is question does not arise for transferring the matter for an investigation by subsequent agency.
Right.
Malad, then kindly see the order of Malad Justice Sengupta, as I said, order dated 14th June 2023, page 237, Malad.
Yes.
Malad.
This report was the second ground of taking away the evidence. Apparently, the report was not satisfactory to the court.
This is the basis of that.
Very well, please.
Malad, that the petitioner, and kindly see the last line, the petitioners are in a position to submit a comprehensive status report. It
No,
is-
Mr. Chaudhary, please let us read from the first line here. The ground of Justice Sengupta. Because
Learned
learned
counsel,
yes.
Malad,
Please.
sorry,
No, please. You.
learned counsel appearing, actually I'm cutting short because their lordship has.
No, we get that. We are only highlighting the relevant portions.
I will only, not beyond that. Learned counsel appearing on behalf of the petitioner submit that although the investigation of the present case was earlier handed over to the CID, West Bengal, they also have not done enough to unearth truth. Only some employees of the earned concern were arrested. Employees. The kingpins piece have not yet been hauled up. Learned counsel appearing on behalf of the state submit that investigation is going on that team. Several witnesses have been examined and documents seized. The investigating agency is awaiting sanction because some government officials are involved. The petitioners are in a position to submit it is not a petitioner, it should be a state, Malad. It should be a state. Are in a position to submit a comprehensive status report. Latest status report regarding the investigation be filed in the form and affidavit on the next date of hearing. Malad, this is the report now. Next 239 page. Malad, straight away I will take up the relevant part, Malad.
Show me your best parts. They'll show their best
I will
in
show
the report.
their best parts, Malad. And my best parts is
And we'll find out because nothing will be left after that. We'll read out the spelling
that's
mistake.
right, Malad.
Yes. Which are your part.
242, Malad.
Right.
242, first page is the gist of the affair. Malad, I am not, that is the gist of the affair, Malad. Page 243, I will start from that.
Yes.
Clause 2, Malad.
Right.
Top. Investigation by the district police, A. Heading A is the arrest. So district police had arrested these 3 persons, Malad. Then, Malad, kindly come to the B column is a seizure. Then your lordship will see the documents seized by the district police till serial number 19 at page 246. Various documents, Malad. 246. Serial number 19, 1 to 19. Then, Malad, C. Statements recorded under section 161 and 164, Malad. 9 statements of 9 witnesses had been recorded by the district police, which include the various accounts holders, office staffs, and agents of Alipurduar Mohila Samabay Indian Samiti. This, lordship, got it?
Got it.
The statement of 8 witnesses, beneficiaries, had also been recorded judicially under section 164. So total 8 plus 9, Malad. Then collection of important documents by the local police, D. Then, Malad, it said there are around the 1, 2, 3, 4, 5, 6, 7, so many detailed inquiry conducted, such and such, it has been recorded, Malad. Then third, next page, Malad, order of assumption by CID West Bengal now. The investigation of the case was assumed by CID WB as per orders by time such and such number dated 24th September 2020, Malad. In I inspector such and such took up the investigation on 26th September 2020. Then, Malad, the column 4 under the heading A, arrest. Then thereafter CID had arrested 3 persons. Who are they, Malad? Accountant of Alipurduar, that Samiti. Then cashier. Lordship, got it?
Got all 3, yes.
Yes. And then the Priyobrata Chaudhary, assistant accountant, Alipurduar. Then, Malad, Caesar description, Malad. Such a huge investigation has been undertaken, Malad, from serial number 1, 2 at page till, Malad, it goes till 278. from page 248 to 278 showing the description of seizures of the document. 275 listed items have been seized, my lord, date-wise, column-wise, which is evident. Then CID recorded 161, 164. My lord, kindly see. After taking over the investigation, the statements of 39 other witnesses have been recorded as on date. No, here no 164. Constable already done. Then collection of important document, my lord. My lord, kindly see the certified copy of inquiry report by the ARCSS Alipurduar, detailed inquiry conducted. Then in this way, my lord, it goes till 29, page 282, item number 1 to 29. The collection of important document, page 282, my lord. Then, my lord, freeze putting on hold bank accounts. My lord, kindly see the, again, my lord, the around 20 bank accounts have been seized. Sorry, my lord, freezed. Sorry. Then, my lord, F under the column bottom, collection of deeds, land registered in the name of the accused persons. Then the details have been given. Next page 285. My lord, 285, then G, submission of prayer for sanction order against accused government officials. The prayer for obtaining sanction under section 197 subclause 1 subclause B CRPC against the accused government official, namely Sushanto Pal, special officer Alipurduar, has been sent to the registered cooperative societies Kolkata, West Bengal for sanction. Sri Vishwajit বিশ্বাস, auditor of the director of the cooperative audit Kolkata, orders yet to be received. Reasons for pending conclusion, that has been stated there. This report was affirmed on 1st August, 1st August 2023. Then, Milord, in page 290, reason for pending is said. Page 290. Then, Milord, page 291, against whom the charge sheet is ready, it has been demonstrated.
When did you seek the sanction to proceed against the government officials?
When?
When?
My lord,
Let us just, you have mentioned somewhere, you placed.
my lord, I am coming. I'll give you.
You did place it, yes.
12th May 2023. My lord, kindly go 285. 285 page.
Right.
12th May 2023.
And you took over investigation?
Took over investigation, my lord.
That is also there somewhere.
Huh?
24th of September 2020.
2020.
Right, yes.
Then, my lord, this report, which was placed on the very first day, then the my lord junior state advocate sought for a time for further instruction, which has been reflected in the order dated 22nd, my lord. On the ground of seeking further instruction, matter is adjourned. Then, my lord, this page 293, Annexure E series, that is the supplementary status report, page 293, my lord. Supplementary status report.
This was also filed before Justice Sengupta.
Not Sengupta, my lord. It is just Abhijit Gangopadhyay, which has been sought to file.
Oh, Justice Sengupta directed the report.
Directed the
All the reports were filed before Justice
Gangopadhyay.
Right.
Not before Justice.
Here I have this
Yes.
report, according to me, my submission is, this report was not placed before, even before the order.
My lord, I will.
That is my question actually,
I will-
because it's a supplementary report.
Yes,
My lord,
had that been produced, there should have been a slightest reflection in the order. Because
my lord,
once the
That is why you were asking Mr. Chaudhary, yes.
my lord, I am.
but that doesn't render the order bad, will not.
No, otherwise it's
That's
not that. We are just wanting to know whether it was before the learned single.
Why? Because respectfully, I am submitting, when any judicial proceeding of my lord Justice Abhijit Gangopadhyay, his live streaming proceeding is switched off.
We have
So
no
that's
issue
the, I
with
don't
that.
have any.
That's the judge's choice.
Demonstrate that what was.
That's the judge's choice. Mr. Chaudhary, let us not comment on these things.
Why I am saying when.
Let us not comment on these things.
I'm not commenting.
We take serious exception to this.
Malad,
If your insinuation is against Justice Gangapathy personally, we are not agreeing with you.
No, Malad,
We are sorry.
what happened?
We have our own things, but no. We have a style of operation, Mr. Chaudhary, but don't even try to make any insinuation against any particular judge.
I have.
We have nothing against any particular judge.
Malad, no, but even I don't.
Not even against the advocates. No.
Malad, I don't even. Malad, why I say
No.
that
There is no basis of this statement of yours.
because Malad, kindly see, may I hand over the order of this 22nd August
Yes.
2023 and 20.
Let us be on the facts of the case, on the
Yes.
merits of the case only. Yes.
Malad, the 22nd August.
Please hand over a copy to them also, Mr. Chaudhary. Whatever you hand over to us, just give a copy so that there's transparency.
What they are doing, tell them.
This does not reflect that anything was filed in court.
No, anything is filed, Malad. Malad,
No.
why I am saying 22nd, then this is the
Mhm.
the further instruction of this client to clarify.
Right.
Then the 23rd, this matter is heard today and further hearing of this matter will be taken up tomorrow 11:30 AM. Malad, this report, this supplementary report, that has been signed on 23rd August. Malad, kindly see. On
Signed on 23rd August, maybe. Was it placed on
Malad,
record?
It has been placed, Malad. Justice Gangapathy did not hear, Malad. My
Where have you stated that?
Huh?
In your the present application,
It's not even urged in the memo of appeal.
where have you stated that?
Yes.
That it was placed but not looked into by justice by the learned single judge.
Huh?
Who was that?
No, recalling it. I cannot follow.
Not even taken as a ground. in the
Please take your seat.
Just a second, just a
We
second.
won't be prejudiced either way. We are only on the facts of the case and we'll decide on that.
Grounds.
No, not only the grounds, because you have to state on facts also, because this is
There
something
is
which
a
transparent.
I am just pleading.
That-
Malad,
It has to be on oath in
Malad,
your
I have
application.
pleaded, I have pleaded. I'm just.
Yes. You have stated in para 15.
That was not.
A further supplement.
The honorable judge is not stated. They are stated
Malad-
that it has been submitted.
Malad, submitted, then thereafter lordship, which what is.
No, that is
going to
different. That is,
Consider, not going to consider.
that's not in
We
your.
cannot say what we have done, we can say what we have done. Paragraph 50 and the grounds are also. Malad.
Anyway, then let us look into that supplementary.
Yes, Malad.
Let us come back there.
Yes. Then.
Submission of charge sheet, that was the main thing of that supplementary.
Only the charge sheet has been submitted, that has been brought to the notice, otherwise it would not been allowed. Because when the 1st August 2023, it has been affirmed, that time charge sheet has not been filed.
All right. Good.
Then when it has been filed, it is the duty to bring to the notice of the honorable judge.
Definitely, yes.
Now, Milord, this entire the status report, and then Milord, the page 296 is my charge sheet, Milord.
The submission of the charge sheet, then Mr. Chaudhary was admittedly during pendency of the writ petition and after the first order of Justice Sengupta of the direction.
Yes, Lord.
Right.
Yes. Then Milord, the page 296 to Milord,
Yes.
the till
The charge sheet,
charge sheet. This is the copy of the charge sheet, Milord.
right.
In the charge sheet, I will just highlight the very relevant points, 2-3 points.
Absolutely.
Then I'll come.
Yes.
Then in page 299, Milord, this is the page 299.
299, yes.
Say second paragraph. Thereafter, the investigation took up. Then the third paragraph, after taking the investigation, what happened, that has been reproduced. Malad, page 306 kindly.
306, yes.
Yes, my lord. Note, kindly note, my lord. This is to notate that the amounts withdrawn from these checks, but the above referred checks, my lord, have not been reflected in any register of the Somiti. And the accused staff member also do not have any feasible explanation as to where the money withdrawn via these checks were utilized. Then I received the order of learned ACGM for regarding prior defreezing the, that is not relevant. Now kindly come next page, 307. Moreover, second paragraph. Moreover, Lordship got it. Moreover, from the seized inquiry report and the statements of the members of the said inquiry team and the ARCS Alipurduar, it could be revealed that an inquiry team was formed as per the order of the ARCS, one of the government, Alipurduar, my lord, comprising of auditors of Cooch Behar range and cooperative inspectors of Alipurduar. The said committee conducted the inquiry of the Alipurduar Mahila Satensa Somiti from 11/2/2020 to 13/2/2020 and submitted the said report to the ARCS Alipurduar on 22/2020. It could be revealed that manager Triptikona Chaudhuri, accountant Rina Sannal, assistant accountant clerk Shampa Bhattacharya, cashier Udita De Mahato, and loan clerk Sanjeev Das were fully responsible for defalcation and the embezzlement of the funds of the Alipurduar Mahila Somiti. My lord, next, kindly come the last paragraph. In course of the investigation, all the available relevant records of the Somiti were seized from the said seized records and interrogation of the respective staff in charge of the said registers. It could be revealed that none of the records of the Somiti were computerized and that the entry book keeping procedures were carried out manually. The staff did their works very casually and in complete violation of the norms of a registered financial institution. Moreover, none of the registers maintained by the Somiti were authenticated by the competent authorities, which goes to show the involvement of the concerned authority. On perusal of the loan ledgers, it could be revealed that the registers was not updated and the entries were incomplete and also lacked authentication. Hence, the exact amount of loans issued could not be ascertained. Moreover, on demand, the manager and the loan clerk were unable to provide the authentic and updated list of the overdue borrowers. In course of the investigation, the bank account is the Alipurduar Mahila Somiti were also collected and accused are also interrogated on the relevant point. It could be revealed that the huge amounts were repeatedly withdrawn from the bank accounts of the Somiti by the loan clerk Sanjeev Das. As per the instructions of the accused Triptikona Chaudhuri, manager of Samavai Somiti. However, the said withdrawals were not reflected in the books of accounts of the Somiti, and the said accounts were misappropriated with the connivance of all staff. The manager, Srimati Triptikona Chaudhuri, accountant, Srimati Rina Sannal, assistant accountant, Srimati Shampa Bhattacharya, cashier, loan clerk, Sanjeev Das. Then, my lord, the amount was stated. Then, next, similarly, next paragraph. From West Bengal State Cooperative Bank, Alipurduar account number such and such, the following amounts were also withdrawn. Total amount was, my lord, 4 lakhs, just shown. Then, my lord, the total investigation with regards to the amount which has been withdrawn, it is stated. Then, last, hence, my lord, it is seen that the manager, Srimati Triptikona Chaudhuri, the special officers, Sri Sushanta Pal, and the chairperson, Srimati Upasana Sengupta, were all responsible in the withdrawal of the money from the Somiti's account, which has no reflection in any of the registers of the Somiti, as a result of which it is not clear till date as to how this money was disposed of or spent. However, their action against the said accused staff proves their involvement in the corporation misappropriation of public money. Similarly, the concealment of evidence by C. Vishwajit Vishwas, SAG 1 Cooch Behar range, who submitted the audit report of the Alipurduar Mahila Samavai Somiti such and such for the financial year ending 31st March 2017 without the mention in such repeated irregularities with respect to the fact that many vouchers, debit, credit were not signed by the manager, cashier, and accountant for a long time in complete violation of the norms of a registered financial institution. Therefore, the prayer for adding section obtaining such and such is gone, my lord. Then, my lord, 1, 2, 3rd paragraph. Further, during the course of investigation and on up-to-date examination of the bank accounts of the Somiti, it is seen that 45,95,000 is being withdrawn from the West Bengal State Cooperative Bank, Alipurduar, account number such and such. An amount of which 4 lakhs has been withdrawn from the West Bengal State Cooperative Bank, Alipurduar, account number such and such in the year 17 and 18. Details of which have been given above. The total amount 49 lakhs 95,000 only, which includes the amount of rupees 37 lakhs 70,939 only, as per the audit report, have been withdrawn from the bank, 2 banks account belonging to the Somiti and do not have any reflection in the registered book account of the Somiti, and the said amount was embezzled by the accused persons. Page 310, my lord. Then during the course of investigation, I submitted this. Then, my lord, since the investigation of the case in respect of the above noted 6 accused person have been completed, and the evidence collected during investigation all show that a prima facie charge such and such has been well established against them. Hence, I do hereby submit charge sheet in such and such and such and such, name of the such and such, and with also with a.
But regarding the government, 2 government officials involved, you have asked for permission to submit supplementary charge sheet.
Yes.
And you have not done it as yet, which is reflected page 310.
Sanction has not come.
When did you ask for the sanction, you
In
said?
May 2023.
Only after the writ petition was filed.
1 year.
When was the writ petition filed?
So, my lord,
So you grew wiser after the writ petition was filed.
that's always generally. We wake up after
That can be one of the reasons for shifting the investigation from you.
My lord, but
Because there is a perception, has to be a perception, since your purse strings are with the government of the state. You may be influenced. I mean, you may not be influenced in this particular case, but there is a possibility always. You cannot rule it out. You may be justified in arguing that, yes, that cannot be the presumption that always CID, this is an independent body supposed to be. Now, in recent times, we are seeing neither the CID nor the CBI, depending on the purse strings, they are not independent in certain cases. Maybe they are used also by the governments. But in this particular case, why did you wait for so long to file, to take steps against the government people?
Millard kindly.
And these are also not higher up people. We don't say that there is a pressure, there has to be a pressure on you
There was
to involve ministers and all in every case. No, may not be.
no.
But
Even
why this dilly-dally against them?
should not be swayed on the basis of any external.
No, we cannot. Neither the court can nor you can.
No. Millard, always all the investigating agency, it is.
But why this against the government officials so long?
Too long, Millard. But in May
Too long.
2023, Millard, you kindly understand the huge documents, because this CID, Millard, the person of the inquiring officer,
Yes.
even diligently he has performed. Diligently. Maybe in delay in recommending for obtaining a sanction. But for that reason, it cannot be vitiated, my lord. Kindly see his willingness, his performance. Now, my lord, in this juncture, my lord, now I will demonstrate both the points. Malad, in 2010, 3 SSC 571, Malad. This is a 5 judges bench, Malad. May I hand over the judge? 2010. Cost of the Malad, the straightway, this is the judgment, Malad. The straightway the paragraph 70. Last paragraph, last paragraph, 70. Last.
Sparingly used.
Loss. Before parting. Married.
Yes.
Before parting with the case, because this was the case from the state of West Bengal. Your Lordship knows it is a very well-known case that Committee for Protection of Democratic Rights West Bengal, whether the under the Delhi police, the CBI has the power that judgment.
Right.
Before parting with the case, we deem it necessary to emphasize that despite wide powers conferred by Article 32 and 26 of the Constitution, while passing any order, the courts must bear in mind certain self-imposed limitations on the exercise of these constitutional powers. The very plenitude of the power under the said articles requires great caution in its exercise. Insofar as the question of issuing a direction to CBI to conduct investigation in a case is concerned, although no inflexible guidelines can be laid down to decide whether or not such power should be exercised, but time and again it has been reiterated that such an order is not to be passed as a matter of routine or merely because a party has leveled some allegations against the local police. The extraordinary power must be exercised sparingly, cautiously, and in exceptional situation where, now this is an exception, whether it falls within that has to be tested by Lord, where it becomes necessary to provide credibility and instill confidence in investigation where the, or where the incident may have national and international ramifications, where such an order may be necessary for doing complete justice and enforcing the fundamental rights. Otherwise, CBI would be flooded with a large number of cases and with limited resources may find it difficult to properly investigate even serious cases, and this process lose its credibility and purpose with unsatisfactory investigations. But here, this is even suppose now even the separate two institutions, investigations to be carried out. CID is also or any other police agencies are the investigating agencies. It is to be their duties to be performed very rationally, diligently, and seriously, If it is because even the CBI, even the ED, even the CID or any other agency, even there must be some iota of evidence, there is an impartiality, there is a bias, or the person is incompetent to undertake such investigation and had not performed the duties casted on him, the statutory duties. Then only the question will come. Today, London Trial Judge has delegated this investigation to the institutions where the CBI and the Enforcement Directorate. Enforcement Directorate for the prevention of money laundering and the foreign exchange regulations. This is for these purposes. This ED has established, and they are the specialized role for these purposes. Now the CBI, the same role with the CID. Now kindly your Lordship will examine whether the CID investigation by a person has not been carried out properly within the guidelines guided by the Honorable Supreme Court. Then only question will come. Kindly see the order your Lordship has seen. There has not been nothing that has been mentioned in the order that the investigating agency could not perform their statutory.
Two things have been mentioned: delay of 3 years and your report.
With regards to money trail.
These are the two bases. Those are reflected in the order.
Money trail, 3 years, and the list of borrowers.
That too, yes.
List of borrowers. The list of borrowers will not be in the event. The Samiti, society, they do not have How I can bring, because even the CBI will investigate whether they will be able to bring out the list of the borrowers which has not been maintained.
In your charge sheet, you have mentioned something. Ultimately, you have detected there at 21,000 or something. Some number has been given after members, looking into members, not the list of borrowers. You have said they don't maintain any list.
Yes, they could not provide, and even they have maintained the list in a very carelessly. So the documents which are available, we have collected, So this is Malad, the one judgment, Malad, with regards to that, how the investigation can be handed over to the other agencies, Malad. Now, Malad, the next judgment of 2013, Malad. তুই যা যা বলবি তাই তাই দেখিয়ে দেবো।
Yes.
আমাকে এখন তুই প্রবলেম দেওয়া শুরু করে দিস তো দাঁড়া শুনতে দিও মানে 2013-12 SCC page 480 Milord. Milord, let's stay to paragraph 13 Milord.
Yes.
The issue involved herein is no more res integra. This court has time and again dealt with the issue under what circumstances the investigation can be transferred from the state investigating agency to any other independent investigating agency like CBI. It has been held the power of transferring such investigation must be in rare and exceptional cases, where the court finds it necessary in order to do justice between the parties and to instill confidence in the public mind, where investigation by the state police lacks credibility and it's necessary for having a fair, honest and complete investigation, and particularly when it is imperative to retain public confidence in the impartial working of the state agencies, where the investigation has already been completed and charge sheet has been filed. Now, ordinarily, superior courts should not reopen the investigation and it should be left open to the court where the charge sheet has been filed to proceed with the manner in accordance with law. Under no circumstances should the court make any expression of its opinion on merit relating to an execution against an individual. Paragraph 17, Milord. Next, I will refer. In view of the above, the law can be summarized to the effect that the court could exercise its constitutional powers for transferring an investigation from the state investigating agency to any other independent investigating agency like CBI only in rare and exceptional cases such as where high officials of state authorities are involved or the acquisition itself is against the top officials of the investigating agency. Malad, in this here, nothing is applicable. Thereby allowing them to influence the investigation and further that is to so necessary to do justice and do instill confidence in the investigation of where the investigation is prima facie found to be tainted stroke biased. Then paragraph 22 last, Milord. In sum and substance, firstly, the facts and circumstances of this instant case do not present special features warranting transfer of investigation to CBI, and that too at such a belated stage where the final report under section 173 subclause 2 CRPC has already been submitted before the competent criminal court. The allegations are only against the then RDO such and such. Malad, this is the reason. So, Malad, my respectful submission, Malad, the moment I have tried that from the very day of inception by way of section 151, then FIR has been initiated till the completion. Each and every process has been exhausted, laid down from 154 to 173 of this court, Malad. And in 173 subclause 2, the report in a final form has been submitted. Now, Milord, it depends upon the magistrate. Magistrate may take cognizance under section 190 or may refuse it if he sees that investigation has not been done properly. Then under section 173 subclause 8 has not been precluded for referring the investigation by a further investigation by any agency or any person.
First section you said was section 190.
154, Milord.
So 150, after that you said some 190 or something.
No, 154 to 173, each and every stage we have complied.
Yes.
Then 173 subclause 2, the report has been filed. After that, it is the magistrate to take cognizance under section
Right,
190. And at the time of taking cognizance, the cognizance court taking may refuse.
Right.
If he sees that, or on the basis of an application event from the complainant, that the investigation has not been carried out,
Maybe reopened.
even when reopened, then the cognizance will take
That is
173 subclause 8.
Right.
Now, my lord, here the writ court jurisdiction, that if writ court jurisdiction, it is said, time and again, my lord, I have given, that in a rarest rare occasion, when it is imperative to interfere, when such process has been exhausted. Now, Lordship, kindly, my respectful submission again. Suppose this entire charge sheet has been placed or to be placed at the time of cognizance. Now, the court, cognizance court, taking court, shall examine each and every document. Now, your Lordship, and even we can see the prima facie. There is no scope of intensive research in this regard, but the criminal court having jurisdiction to undertake such intensive research, then only will come to a conclusion of a logical conclusion. And
Mr.
then,
Chaudhary, at the same time, you cannot stall the process of court because after the report was directed, only after that charge sheet was filed in your case. That ipso facto, you cannot use that itself as a tool to say that no charge sheet has been filed, therefore the investigation cannot be reopened, because that process happened only after the matter came to the writ court. The first direction was passed by the first and single judge that a report be filed. After that, you cannot just, by filing a charge sheet, you cannot close the scrutiny by the court. Like that cannot itself be an indicator. I mean, although you have a good ground here, in this case, charge sheet has been filed.
I have demonstrated when I have initiated my investigation, and when almost 80%.
So you say that had no nexus with the filing of the writ petition. It not
date wise, my lord.
Good.
Within the period of 3 years, even they wouldn't have filed the writ petition. We would have come up with this
natural culmination.
natural culmination.
Very
It is not that prompted or under the threat of writ petition, we have closed the investigation. It is not like that, my lord. Had it been in a cryptic manner, the investigation would have been ended. Your Lordship would have said, under the threat, you did not undertake an investigation, and on the basis of the writ petition, you have concluded the investigation. It is not. But a series of documents, series of witnesses, series of the 161, 164 statement has been recorded. So, my lord, it is not a process of one day, my lord. Your Lordship knows even the criminal investigation, how, because even for recording 164 statements, my lord, so many, the paraphernalias are there to be complied with.
Right.
So, my lord, in this juncture, my lord, so my respectful submission that the moment the charge sheet is filed, the investigation can be reopened by the even, my lord, the court, competent court, where the cognizance would be taken, my lord. Oh, yes. Yes. Well, lastly, I will demonstrate that in the prayer of the writ petition, they said the CBI or the ED, my lord, the investigation should be undertaken, my lord. My lord, in a Sakyaribasu judgment, my lord, it is well known, reported in 2008, subclause 2, my lord, may I hand over the judgment. My lord, paragraph, this is 2008, volume 2, SCC, page 409, my lord, paragraph 10. My lord, it has been held by the CBI versus Rajesh Gandhi, such and such, no one can insist that an offense can be investigated by a particular agency. We fully agree with the view in the aforesaid decision. An aggrieved person can only claim that the offense he alleges be investigated properly, but he has no right to claim that it be investigated by any particular agency of his choice. So now, suppose now even it has not been disclosed in the writ petition.
They said any central agency. They did not choose any particular agency.
No, CBI or the ED,
or any other central agency.
Can you see my
Page come, take your seat, Mr. Ghosh. We can read English. Please come to page 49.
Yes, sir.
C. The end of that says the last portion to forthwith handover and transfer record to the CBI, Enforcement Directorate, or any other central agency. So they don't have any choice. For further, they say central agency, they could name CBI,
Any other.
any other. They want a central agency because apparently the insinuation is that the state is involved. I mean, in some way or that.
What further they say NIA. It is not a case of NIA.
They did not go to that extent, but any other central agency also involves NIA.
Because CBI and ED, they have spelled to it. Malad, now the question is, even any other central agencies, then which court?
No, anyway, so this argument of yours is not proper that they wanted CBI in particular or ED. They say any central agency, including CBI, ED, whatever they could name, I mean, apparently. So they did not choose any agency.
That is a more in a confined manner, has given a narrow scope. And then
But the next paragraph is also there.
landed trial judge even has
156.3 is also considered here.
considered here.
You
Because
have
that's why I'm coming, because now the question is over
Yes.
by your 173 subclause 2.
Right.
Otherwise, my lord, this 156.3, the magistrate has the power to monitor the investigation event. Writ court should not.
Mr. Chaudhary, the difficulty in these is, you are right. Ordinarily, the word ordinarily has to find place in the somewhere in the judgment, because there is no absolute bar to the writ court judicial review. There cannot be. Now the question is whether that such a case of such elevated plane has been made out. Where this is not an ordinary case, 156, 1 to 173, those are not sufficient. So we have to involve some central agency. So your argument has to be on that. This cannot be an absolute bar.
No, there is no.
But yes, you are right. Ordinarily, yes.
No, I am not. I said it to be the weight is to be given. Malad, this from the
Yes, yes.
weight is to be given.
True.
Malad, kindly see in the petition,
Yes.
in the order, in the investigation,
Hmm.
it has to be demonstrated that it has not been carried out properly.
Hmm.
There was a lackadaisical attitude of the investigative agency. The word used by the learned trial judge, but it speaks otherwise. So, Malad, it is not a rarest of rare case. It has not been construed by the learned trial judge.
Hmm.
Then it should be treated as a rarest of rare case. So, Malad, in this backdrop, 15 and what order? 15 and order already said, don't.
50?
My judge already examined. Yes, Malad, sorry.
Very well, yes. So that's all.
So more or less, this is the Malad, this argument, Malad. So there is no scope even, Malad. We have even your lordship feels that further investigation is required. My agency is ready to undertake by any superior through any superior agency, Malad, superior officer.
Who is for the ED and who is for the CBI? Mr. Mujumdar, you are for ED as well as the CBI.
Malad,
Central agency.
one point shall I, which I have forgotten, which your lordship at
Yes,
least,
before they start.
just because you lordship kindly see yesterday when this order has been passed on 15th 9 2020 and even the parent order, well, thereafter because we have challenge, because the by way of even recalling application, even by way of filing an appeal, Malad. So the document, suppose now we have not handed over us any document, but we have made a request. We have made a request to the central agency in view of this order on 16th September 2023. That this is the order has been passed, because I must be candid, the order has been passed and charge sheet has been filed. We have a copy of a duplicate copy of the said charge sheet. We can hand over. This is the request letter we have issued to the CBI.
So as of now, copies are with the central agencies. Copies have been handed over through public prosecutor they have taken,
Yes.
but the originals are lying in the criminal court.
In the
Yes.
grateful.
Mr. Mujumdar, we'll hear them first, the petitioner, because you cannot have any interest in particular apart from the question of law. Very limited, right? So let us hear the petitioner first. Right.
Answering to the first question,
Yes,
the nature of the litigation.
right.
But my short answer to this is, Miller, there are 11 petitioners in the writ petition, and by way of annexing all relevant documents, it has been demonstrated that they were the depositors in that particular society or committee, whichever way we look at it. Now, that documents itself shows that having been a depositor, each one of them, 11 one of them, this and they being the writ petitioners, in by no stretch of imagination, this litigation can partake the character of a public interest litigation. Because public in the sense means the multiplicity of individuals.
Mr. Ghosh, if you say that for 11 investors, why should the central agency, any central agency be appointed? Then there will be a floodgate will be opened then. The CBI will file a public interest litigation. Please don't engage us.
Yes.
That will happen next, actually, Mr. Ghosh. Because for 11 people, probably they have filed something actually, I mean, not a public interest litigation, but in certain cases, they have filed applications. They are short of manpower. They are also being rebuked by us. Obviously, we will.
Here what has happened.
But why then should this central agency, why should 11 investors?
I'll demonstrate that from the report
Yes.
itself, from the CID.
Yes. It's a catch-22 situation for you. If it's not public interest litigation, your personal interest, why should you seek for central agency for this? Why is not the CID sufficient?
Here Millard can look at it from a different angle.
Hmm.
Maybe these 11 petitioners are espousing the cause of the all 20,000 depositors because each one of them is situated or equally circumstanced.
So it remains a catch-22 situation.
Yes.
Very well, we get it. Yes.
Now
They are also espousing their own causes.
causes as well as the causes of all the depositors.
Very well.
Now, Millard, there are other things also, Millard, an addition of party application is being affirmed, Millard, today. Millard, another 70-75 parties are being added to that. That's a different aspect. I'm not going to that. Now, Millard, the second, where Mr. Chaudhary concluded regarding my prayer, short, Millard, choice of agency. If Millard kindly takes my prayer, Millard has already gone through that.
Yes, seize any central agency.
Yes, no. Prior to that, Millard, there is something more.
Yes.
And Millard, page 49.
49.
Yes, commanding the respondent authorities and any one of it, thereby constituting a committee, preferably presided by retired judge of this honorable court to oversee the investigation and to initiate any further action that may be required for trace out the money trail and for recovery of the money so siphoned off or in the alternative.
All right.
Or in the alternative. So I have left everything before the honorable court.
Right.
In the interest of justice, substantial justice. Whatever is required to be done, let there be a discretion be exercised. Now, Millard, I'll go to the most clinching part first. That is the report of the CID, which Millard has already gone through it, but some of the things has not been pointed out. Millard, which I will try to just appraise your lordship. Millard will take from page 242 onwards.
Yes.
Millard, the gist of the FIR Millard has seen. Immediately thereafter, 3 persons were arrested: manager, loan clerk, chairperson. Seizures.
Right.
Now, though the list of seizures is quite long, but if Millard goes into the items, Millard would find these are the passbooks, deposit received of the depositors.
Yes, you've seen that. Yes.
Now, by reason of the sheer
Number.
in any island of Alipurduar, there are a dozen of depositors of this society. So this volume of numbers Millard does not take anywhere forward. Now, the most important part, page 246. And Millard, I am placing this to persuade your lordship to make a view or to form an opinion that in fact the CID has not even independently exercised its mind at all. They have done in a parrot-like manner under dictation of someone whom we don't know. Why I say this? Now Millard would take page 246, collection of inquiry reports, important documents. The inquiry report from the ARCS Alipurduar in connection with the detailed inquiry conducted by Sri Bindraman Chandra Burma 234 from 11th February 2000 to 13th February 2000.
During the police period.
Yes. So these 3 persons, they were an inquiry committee formed by the ARCS. They conducted an inquiry where misappropriation of funds has been found against the staff of the Alipurduar Mohila Rindhan Samabaya Samiti Limited. Now Millard sees the names 1, 2, 3, 4, and 5. 5 persons have been named in the inquiry report by the ARCS. Once the CID takes over, only these 5 persons were arrested subsequently. CID takes over on 26 September 2020. Immediately thereafter, in December, only these 5 persons were arrested. No further arrests. Now Millard would turn over to page 248. And Millard would find that what I am saying at page 247 under the heading arrest, which states the name, Millard would find only those names who were pointed out by the ARCS. These are the persons, CID hauls this up, arrest them. So my first limb of submission on this is there was no independent, transparent, fair, impartial investigation even done by the Central Investigation Department. Now Millard would turn over the next page, and from 248 onwards, Millard would find from 278 are Millard the seizures. Again, Millard, which I have said as a while back, 275 items, but all Millard, mostly the documents, certificates, etc. of the depositors.
Hmm.
279 onwards, they have said that they have ascertained several bank accounts and have freezed them. The question is, whose bank accounts were those? Only those 5 persons who were named by the ARCS and initially arrested by the police. So even after collecting these 275 documents, including ledgers of the bank, your investigation did not go any further. You have restricted yourself in those 5 persons, and whatever you have done till the end of your submission of charge sheet is only against those 5 persons and no one else. You ought to have gone a little beyond that. 282, freezing, putting on hold of bank accounts, same, of those persons only. Next, tracing of properties. They have traced out, and finally they have said that 4 decimals of land of a particular individual and 1.85 decimals of land of a certain individual can be traced out. These lands belong to those 5 persons, one of them. And what they have done, only a prayer has been submitted, Millard, page 285, second paragraph, to the additional district sub-registrar, so and so, for preventing transfer sale of the plots of land registered in the name of Rina Hon'ble, measuring 4 decimals, measuring so and so decimal without prior intimation to the investor. I don't know what does that mean. Now
that is also after the writ petition.
After the writ petition, everything. Now, Millard would find there are very interesting observations in the report at page 286. 286, first paragraph. The last line, moreover.
Yes.
Moreover, 286.
286, the second paragraph.
First paragraph, last line.
Right.
Moreover, in course of the interrogation of the accused staff members, they gave vague statements and accusing each other for misappropriation. So my intention is, kindly see, your lordships must see this, that how the investigation has been intentionally kept confined within a particular circle. Now, Millard would just take the next paragraph. Moreover, from the seized inquiry report and the statements of the members of the said inquiry team and the ARCS Alipurduar, it could be revealed that an inquiry team was formed as per the orders of ARCS, I have indicated this earlier, comprising of auditors of Kuch Bihar range and cooperative inspectors of Alipurduar. The said committee conducted the inquiry and submitted the said report on so and so date. It could be revealed. Millard then again find the reiteration of the said.
So you say entire thing is on that pre-CID, ARCS, that report, that committee,
Yes.
those 5 persons, and entire thing relating to those
Yes.
and staff members.
Yes.
That is your.
Even after CID took over. it
Even
was
after CID took over.
Yes.
So no independent investigation.
No independent investigation. Now, Millard, the second line, it was also revealed that the most of the account registers and other related registers were not maintained properly and lacked authentication by the staff of Alipurduar so and so committee. Moreover, some vital registers could not be produced by the accused before the inquiry committee. It was revealed that several transactions of the committee with the West Bengal State Cooperative Bank Alipurduar from the year 2017 onwards were not reflected in the accounts book of the Samiti. Moreover, it could be revealed that many vouchers were not signed. The next line, moreover, the audit report of so-and-so for the financial year so-and-so has also been ridiculed by the said inquiry committee as it was conducted in spite of such irregularities. He had prepared the audit report in the absence of authenticated records and he did not report the faulty cash transactions which have not been reflected in the books of accounts of the Samiti. Now, what would appear very clinching to your lordships is in the reasons of delay, they have stated one ground that they are waiting forensic audit of the account. Now, after 3 years of investigation, having found out that nothing is there, even the audit report, I don't know on what basis they have concluded that the audit report is forged without conducting any independent inquiry on that or an independent audit of that. It is an opinion of the investigating officer who is not a certifying authority of the audit. Even after 3 years, they did not care to have a forensic audit done of the accounts. And the two government officials who are being projected before this court to justify that CID has done a wonderful investigation. Those two persons, government officials, have been hauled up on the ground that they have manipulated the audit. Now, I raise a question to myself. Without even conducting a forensic audit, without even knowing whether the audit was proper or not, you have implicated two government officials only to justify that you have done a beautiful investigation. They are no way involved, I would say. The next paragraph, the last line. This, my lord, was the lines which were placed before the Honorable Single Judge.
I'm sorry, we missed out the page.
Page 287.
287.
In course of investigation, a paragraph starts. The last
Yes,
line
yes,
of that.
yes.
Look, those were the lines which were placed before the Honorable Single Judge to persuade that something more requires to be done in this case. Why I said this? Hence, the exact amount of loans issued could not be ascertained. Moreover, on demand, the manager and the loan clerk were unable to provide the authentic and updated list of overdue borrowers. Look, this is what is the most clinching thing in this entire
I'm sorry,
case.
but this is page
Look, page 287
287.
of the
Yes.
report.
Yes, which part?
The second paragraph in court, it starts
In course of
yes,
investigation.
the last line. Hence,
Oh, all right.
last line of the paragraph.
Yes, yes. Exact amount of.
Yes. The raised parts have been placed before your lordship, more or less. I will straight away request your lordships to skip over to page 289.
289.
The second paragraph starts with during the course of investigation. The accused staff members of the ARCS Alipurduar could not produce a certified detailed list of 1. Shareholders or depositors, deposits, borrowers, as a result of which the accurate number of victims or accurate number of money embezzled could not be determined. However, from the statements of the number of witnesses and as per the last audit report, the audit report which they themselves say is falsified, unauthenticated, they're relying on that. As of 31st March 2017, the total number of members of the society was 21,163. Now, a question has been raised that the Honorable Single Judge has recorded a figure, 50 crores, to assess, to have a primary view of the scam. How that figure has been arrived at. I must be candid. A question was put to me. According to you, what could be the total amount that has been embezzled? I candidly submitted that if we take 21,000 depositors.
No, page 289 mentions that figure.
Yes, but
49,95,000.
correct.
So that is round about
Yes,
50.
my response was, let us take an average of only 25,000 per depositor, it comes to 50 lakhs. And Millard must keep this in mind for the time being, that who are the members of this society? Persons who are small vegetable sellers,
That's
maids.
that is staring at the face from the outset, in fact.
Yes.
That consideration has to be there.
Correct.
Nobody can dispute that.
Correct.
And also that there has been embezzlement, there has been
Correct.
several misappropriations. These two things are a given.
Yes. Probably.
We'll continue after 10 minutes.
Yes, no.
So how long will you submit? I mean,
My lord, 15-20 minutes. at best.
so we'll come back and continue.
Yes. So, Millard, I was just pointing out from page 289.
Hmm.
Now, Millard, can kindly skip over to 290.
Right?
That this will clearly bring out that there was an admission on the part of the CID that they have admitted that they have reached a dead end.
They have?
Reached a dead end. And nothing further can be expected of them. Why I say this? However, an exact amount of the money embezzled can only be ascertained by carrying out a forensic audit, and a prayer for the same has been sent. Now, when it has been sent to whom, when an outcome is expected, we do not know. Next, during the course of investigation, the bank details and immovable property details of all the accused persons were analyzed in depth. But this is very important, Millard, but the end use of the said money could not be traced till it should be date or something. However, efforts are continuing to unearth the money trail. Reasons for pending: to carry out forensic audit. The case is pending for submission of charge sheet for want of sanction against these two persons. And Millard, the next Millard would find the names of the persons who have been finally charge sheeted, the three which was originally arrested by the police, and the others named by the ARCS. There the report ends. Now, Millard, this report, which has been Millard annexed with the stay petition, is claimed to have been signed on 1st August 2023. 1st August 2023. A copy of which was served upon me during course of hearing of the writ petition is Millard signed on 2nd of August 2023, and the signature is also different. A copy of this which was submitted to me before the Honorable Single Judge when this was placed before the Honorable Single Judge. I'm not on this, Millard. These are small things, Millard. I don't know what was this.
Could have been larger, but because it was filed, nothing hinges before 24th of August.
Yes.
That's why, I mean, there's.
Now, the supplementary report, Millard, which they claim to have placed before the Honorable Judge, to which I disagree, at page 293. This Millard would see, Millard, this has been claimed to have been signed on 23rd of August 2023. 23rd of August 2023. Kindly marks the date.
Yes.
The order was passed on 24th. So, on 24th, when the Honorable Single Judge was considering the matter, the material which was before the Honorable Single Judge was the report dated, the earlier report, 1st August or 2nd August, whatever it is, Millard, was before the Honorable Court. The supplementary report, they say that it was placed, I say it was not placed. But even assuming that it was placed, at best, the only case would have been a distinguishing factor, submission of charge sheet, non-submission of charge sheet. But the quality of investigation, the substantive contents of the investigation, there was no change in between 1st August and 24th August. Now, Millard, the observations that has been carried in the report, Millard would find, Millard, in verbatim, those have been stated in the charge sheet also. Millard would see that Mr. Chaudhary has pointed out the relevant portions at page 307. That was the exact portion which I thought I should point out to your lordships. It could be revealed that the manager, accountant, assistant accountant, cashier, loan clerk were fully responsible for defalcation and embezzlement of the funds of so and so.
This is also a part of the.
This is the charge sheet. So, Millard, my point that I'm trying to drive home is that it has been intentionally, deliberately, and willfully kept restricted to few persons, even though they themselves, on the one hand, they are admitting that they could not trail the, they could not figure out the money trail or the exact amount of embezzlement or the very vital documents, that is the list of borrowers to whom the money has been given. There could not have been any reason to reach a conclusion in a closed mind. So, on an overall assessment of materials, Millard, therefore, my respectful submission is that the entire investigation has been done in a very technical manner, without independent application of mind, and without considering the fact that this is an issue which required a little more efforts from the investigating officer, in view of the fact that 21,000 depositors are affected, and my lord, the amount we don't know.
Great.
Now, my lord, the next leg of my submission is today. Pursuant to the Honorable Single Judge's order, as on today, when your lordships are considering this appeal, the facts are, charge sheet have been submitted, the CID is now a functus officio. As of now, until there is a reinvestigation or reopening of the case by the jurisdictional magistrate.
Yes, we are thinking in that line also. I mean,
Yes.
how far this can be implemented even.
Yes. Now, my lord,
Hmm.
CBI, after taking over the investigation, has registered a FIR yesterday. I would not say an FIR has been registered because 2 FIRs is not permissible. The Alipurduar PS case number has been re-registered in their own records to do further investigation.
That is to be saved from contempt.
Yes.
Obviously, obviously, they have to
Yes,
comply with the
yes,
order.
yes. Even they have, my lord, despite the order, my lord, there has been a substantial delay in between.
What will be the effect then, Mr. Ghosh, according to you, of this order of the learned single
My
judge?
lord, the
And
answer-
it will be a toothless order then.
my lord, the answer lies in 2018 5 SCC, where my lord, the Bimal Gurung's case, where the Supreme Court in very clear terms has stated that in exercise of powers under Article 226, even after submission of charge sheet or even after commencement of trial, reinvestigation or
That was not specifically directed, Mr. Ghosh. The difficulty is
Yes.
reinvestigation. If you have to direct, you have to be very specific. There are certain ingredients of that under the Criminal Procedure Code.
Yes.
We were thinking about in that line also.
Yes.
If a reinvestigation was directed, the scope would be different.
Now, my lord, here what has happened, my lord, the supplementary report
Hmm.
that was not even considered by the Honorable Single Judge. That has created the difficulty. Now, if it is in the facts and circumstances, if milords are convinced
Hmm.
that an
Actually,
investigation.
the writ petition itself is pending.
Yes, yes, writ petition is pending. That scope of modification or subsequent facts by a supplementary affidavit can always be done.
So even if you win, we are
Yes.
taking the borders, margins of both sides,
Yes.
because even if you win the case, I mean, this appeal they lose, even in that case, it can be,
Yes,
can
yes.
always be directed to
Yes,
the
yes.
trial judge, learned trial judge, to
Yes.
consider this aspect of the matter, whether a reinvestigation is necessary,
Investigation is justified.
which will be obviously upon hearing both of you.
Investigation, which one will look at it?
Whichever
Both of them
way,
are
there is a nomenclature, yes.
Both of them are permissible.
Right,
I just
both are,
raised the judgment for my satisfaction.
yes.
আরে আমি আনিনি, বইয়ে নিয়েছি। তুমি বলো জানো সব। তুমি বলো জানো, প্যারা 49 to 50 page, para 49.
Yes.
The second line, the petitioner has relied on the judgment of so and so, where this court had held that the commencement of a trial and examination of some witnesses cannot be an absolute impediment for exercising the constitutional power vested in the High Court, and this court to ensure a fair and proper investigation. Para 25, whereof Millard has been quoted. Millard, paragraph 50. As per law laid down by this court in the above case, when the power can be exercised, even after commencement of the trial, there cannot be any fetter to the power of this court in transferring the investigation even after filing of the charge sheet. But in view of the facts and reasons as stated above, present is not a case where this court may exercise jurisdiction under Article 32 to transfer investigation in large number of cases in masse registered against the petitioner or other members of TJ. So, though it was not done by the Honorable Supreme Court, there is no doubt with this proposition.
Even in the power, there is no doubt.
There is no doubt. This was upheld in Dharampal state of Haryana, and Millard knows Mithilesh Kumar Singh also.
Dharampal is prior.
Yes.
Dharampal has been quoted here.
Yes.
Yes.
Next, Millard, the Mithilesh Kumar Singh, and Millard subsequently Millard in Mithilesh Kumar Singh, the Honorable Court was on the point availability of power and the exercise of it. The court did not express any doubt that whether the power was available or not. The question was whether it should be exercised or not. And I am on both. It is available and it should be exercised. And now, Milord, I know, Milord, I am pouring through mugs of water in the ocean, but still, Milord, for my satisfaction, Milord, one judgment, Milord, I wanted to place regarding scope of intra-court appeal. Milord, I know, Milord, is running short of.
No. The intra-court appeal is important here.
Yes, Milord, I just wanted to place this, that in an intra-court appeal, Milord, time and again, it has been made very candid by the Honorable Supreme Court and our court also, that when a judge has exercised the discretion, unless.
Yes, in those judgments, a prayer was made that was refused in all the cases.
Yes, unless the court comes to a finding that the exercise of discretion
Perverse.
was absolutely perverse. Absolutely
Perversity is the general test.
Yes. So that Milord, I don't want to burden your lordship.
No, please burden us. Cite at least one judgment so that your arguments can be recorded. Just formally at least cite one of the judgments.
And Milord, till we find out that, Milord, I would just, Milord, the judgment which has been placed by Mr. Chaudhary, that is, Milord, 2010 3 SCC 571 para 70. I will just, Milord, my purpose is to just emphasize on the word instilling of public confidence.
Yes,
Instilling of public.
that is also there.
This is the word, Milord, which the Honorable Supreme Court has.
Or national and international.
Yes.
Or national and
Yes,
international.
there was a or
You are
in it.
pointing out also at that point. It's right. It's there. Both are there.
Yes, Milord, I'm not just placing, I'll just read out the paragraph on intra-court appeal. Milord, it also, Jano tumi, wonder and tops.
Yes.
This is the 1990 supplementary Supreme Court cases 727. Milord, in such appeals, the appellate court. will
We are
not
sorry,
interfere.
1990.
Milord, supplementary SCC
Yes.
727.
Right.
This is Milord that Wonder Limited and.
Yes.
In such, para 14, in such appeals, the appellate court will not interfere with the exercise of discretion of the court of first instance and substitute its own discretion except where the discretion has been shown to have exercised arbitrarily, capriciously, or perversely, or where the court has ignored the settled principles. So and so. Milord, one more, Milord, 2002 1 SCC 100. Milord, para 12. Para 12. This, Milord, I am placing with the purpose, Milord, that even though very elaborate reasonings, etc., are not there in a order, still, Milord, sometimes, Milord, orders are required to be looked from different perspectives. Milord, the second line, Milord, third line, time and again, this court has reminded that the power conferred on the High Court under Article 226 and 227 of the Constitution is to advance justice and not to thwart it. The very purpose of such constitutional powers being conferred on the High Courts is that no man should be subjected to injustice by violating the law. The lookout of the High Court is therefore not merely to pick out any error of law through an academic angle, but to see whether injustice has resulted on account of any erroneous interpretation of law. If this last line is very important, if justice became the byproduct of an erroneous view of law, the High Court is not expected to erase such justice in the name of correcting the error. So, Milord, considering the facts and circumstances and the materials which were available before the Honorable Judge, and in view of the Milord specific findings which are recorded in the report which was placed before the Honorable Judge, and considering the magnitude of Milord, the embezzlement and has happened and its ramifications on the society, and Milord, to instill public confidence in larger public interest, Milord, handing over of the investigation, Milord, has been done justifiably. And Milord, accordance with our prayers, Milord, probably Milord, the question of adding Prevention of Money Laundering Act and Milord, encroaching the properties, etc., Milord, would something which might prop up subsequently. And these things, Milord, the CID probably Milord has failed to do and would not be able to do. That's all.
Yes, Mr. Mujumdar, you want to add anything? Formally add something, yes.
I'm very only one thing that I have to start with, my lord, was the judgment that has been cited in the bar is West Bengal, State of West Bengal versus Committee for Protection of Democratic Rights and AB running. My lord, the honorable courts were considering whether to transfer or not to transfer. But we today stand in a different position. The matter was transferred.
So we are to exercise discretion.
Pull back or not.
Here exercise has been done by the learned single judge. What is the scope of that? There's very limited scope, I mean, at present, unless a reinvestigation is all right, very well. So your the investigation becomes well.
And my lord, yesterday I have just document before my lord regarding that we have taken over the business and we
Right.
have already initiated it.
Can I have a copy of that?
Yes, please. Mr. Mujumdar, please hand over copies to both of them. During the course of the day, please do that at least.
My lord, direct side.
This is a public record. First information report, in any event you are handing up to court, I mean, there is nothing secret about it.
Milord, just to interject in Mr. Majumdar's submission, Milord, I was conscious to go through the language because I was doubtful whether what language has been used. Milord, it was rightly submitted by Majumdar, Mr. Majumdar, that Milord, it's just a renumbering of the case which has been done for the technical taking over thing. That's all.
Exactly.
But the question which was troubling me is whether a second FIR would be permissible. That's why, Milord, from that angle, I read the language.
Please ask your learned junior to circulate copies during the course of the day to both of them, so that there is no doubt on that front. Yes, any reply, Mr. Yes, Mr. Chaudhary, let us not discuss your WhatsApp.
Intentional idea.
So any answer to this? I mean, he has pointed, Mr. Ghosh has pointed out several aspects of the matter. So you stick by your original arguments, obviously.
I will add, even Mr. Majumdar's client is undertaken an investigation is tantamount to a further investigation.
Yes, that's true. That they have, yes, there.
Further investigation. The further investigation after filing a charge sheet, that is which I have pointed out, my lord. This is I stick on that it can be done after filing of charge sheet by the original court. This is number one. The next point, Mr. Ghosh has cited the judgment with regards to a Bimal Gurung's case. In the said judgment, my lord, and even the judgment which I have referred, the court has to see the magnitude and the impact upon the society. My lord, in other way, if I suppose say the CID or the general police had undertaken the investigation and it has been snatched away, then in the other way, it will impact upon the society. They will not pay respect to the general administration or the police administration. See, they are failure, or they cannot. Their purposes cannot be served unless the other institutions intervene. This will give a broader aspect or broad impact upon the society, my lord. So that's why in Bimal Gurung's case, the case has to be seen. Because in the case, while deciding the Bimal Gurung's case, my lord, there was a international and even the national aspects were involved, my lord, while deciding the matters of the Bimal Gurung's case, my lord. Now, the question of intra-court appeal, your lordship has dealt with numerous judgment, my lord. The question that to be tested the order of the learned trial judge, whether the order is perverse or not, whether the perverse within the four corners of the law, within the said integrated questions. Now, the last judgment which my learned friend Mr. Ghosh has referred, that even a non-speaking order, my lord, this is the reason even Supreme Court in number of occasions has deprecated. Because it has in the perspective of while delivering the order or passing the order, it should be demonstrated and covered in fullest extent. So, my lord, these judgments sometimes prompted the learned judges even to understand the in the ratio of such aptitude. This is my respectful submission, my lord, and
So we'll pass our orders day after tomorrow.
Thursday. Grateful.
Thank you. Hearing is concluded in the matter. Judgment is reserved. তার আগে একটা লাইন অ্যাড করে দাও on consent of parties, the appeal itself is taken up for hearing along with the connected applications. We'll decide the appeal itself because nothing will remain.
Yes, Lord. That would be
Thank you. No,
grateful, Lord.
thank you. এটা একটু ঢুকো, এটা একটু ঠিক করে রেখো, হ্যাঁ, এটা পয়েন্ট গুলো খায়, হ্যাঁ, স্টেপল করে দাও, তাহলে ভারী যাবে। থ্যাংক ইউ।
Item number 2, my lord, I beg to appear for the appellant. Firstly, my lord, my learned friend will be requesting to take it up at 2.
2 or 2 tomorrow?
2 p.m.
2 p.m. আর কিছু নেই তো? Very 2.
Yes, grateful.
The 2 at 2 p.m. দেখো, তুই মেনশন করে রাখ। তুই মেনশন কেন জানো? কি কারেকশন সেটা? What is the correction?
My lord, the correction is that the PS case number, Mepiligons PS case number, it will be 50 instead of 60, my lord. There is the order, my lord.
আচ্ছা, in the caption of the order dated June 16, 2023, comma, the police station case number shall be read as 50 of 2022 instead of 60 of 2022. Full stop, let such inadvertent error be corrected accordingly.
Grateful, my lord.
Thank you. Not today.
Item number 5, I beg the pardon.
What is the correction?
Lordship, paragraph number 16, Lordship. Lordship, their third court has been written, but it will be second court Siliguri in connection with CR NDPS. NDPS court, second court. Paragraph number 16 of the judgment. Learned Judge Special Court NDPS second.
In paragraph number 16 of the order dated July 27, 2023, comma, the court shall be the special court within bracket NDPS bracket closed, second court at Siliguri instead of third court, full stop. Let such bona fide inadvertent error stand corrected accordingly. Yes.
I beg to appear.
What is the correction, please?
In the second paragraph, the section has been stated as section 363 and 374 of the IPC.
Yes, yes.
Section 12 of the POCSO Act, Your Lordship, it would be 6 and 12 of the POCSO Act.
It would be section?
Section 6 and 12. Read with section.
Very well. In the second paragraph of the order dated August 20, 2023, comma, the relevant sections should be read as sections 6 and 12 of the POCSO Act 2012 instead of only section 12. Full stop. Let such inadvertent error be deemed to stand corrected accordingly. Thank you. If it is, you have filed a CRAN for this correction.
Yes, Your Lordship.
As a CRAN such and such is accordingly disposed of. Affidavit of service filed to be kept on.
Grateful, Your Lordship.
Thank you. আগেরটা তো একই হবে দুটোতেই CRAN 1 of 2023 is accordingly disposed of. আগেরটাতে এটাতে। Yes, Mr. Banerjee, what is the correction?
Lordship, on 14th of September, the petitioner's application for anticipatory bail was allowed. Kindly see paragraph 4 of the
Yes,
order. It is stated that bond of rupees 1,000 with one surety of like amount each. One of them will be local, each Lordship. One.
should you make it two sureties? In the order, in paragraph number, can you obtain two sureties? We'll make it two then.
Because he surrendered to the court below and court below.
One surety. Achha, very well. In paragraph number 4, comma, although it was mentioned that the petitioner shall furnish a bond of rupees 1,000 with one surety, comma, erroneously the expression within double inverted of like amount each, comma, one of whom double inverted clause was recorded. Full stop. Let such superfluous expressions be let such superfluous expressions stand deleted from the said order. Full stop. Let the order dated September 14, 2023 be stand corrected accordingly. Thank you.
My lord, here, my lord,
No.
mistake has been done from my part.
Yes, what
This
is
is
it?
the first appeal, but my lord, it has been registered as FET instead of FMAP, my lord.
It's a first miscellaneous appeal actually.
Yes.
It's an appeal from an order.
Yes, your lordship, order 39 Purvan.
The learned counsel for the petition appellant submits that the appeal has been captioned as FAT instead of FMAT, comma, whereas it is an appeal arising out of an order and not a decree. Full stop. Hence, comma, liberty is given to the learned advocate on record for the appellants to correct the cause title of the memorandum of appeal accordingly. Full stop. The office shall reclassify the appeal as FMAT instead of FAT. Please carry out that correction during the course of the day. তারপর অডিট এটা ইয়েতে ডিপার্টমেন্টে বলে দিও যেটা কারেকশন। থ্যাংক ইউ।
Great.
Not
My lord, in
today.
item number,
In item number 9, my lord, I am for the.
You are appealing?
Yes.
my lord, in
Yes.
9 and 10, my lord, in
Yes.
one matter, I am for the respondent, that is in 9, and for 10, my lord, I am for the appellant.
But in this matter relates to, my lord, a
But,
selection
my
of
lord, the
LPG
difficulty
distributors.
is, yes,
What
my lord, but
Selection
the
of LPG
difficulty is,
distributor.
Yeah, Ms. Chakraborty, what is the difficulty? Finish that first.
yes, my lord, I have some personal difficulty, my lord, I have to rush to hospital due to chemotherapy of my mother-in-law, my lord.
Yes, what do you say? Mr. Nag,
My lord, and my
Well,
lord, this is a, my lord, this is a.
what is the
big
application
matter, my
about?
lord.
What is the application? Let us hear. Yes, what is the application?
My lord,
My
they
lord, the
have filed
application is
stay.
for stay application.
Yes, Ms. Chakraborty, you are there. Why not we grant the stay? What is the appeal about?
My lord,
My
this
lord,
appeal
the
is, my lord, this
appeal
is
is-
relates to a selection of LPG distributor. When
Yes.
this selection process was initiated in August 2017. Now
Right.
this of this selection, one of the LPG distributorship selection was done through online application after and thereafter through draw of lots. Now what had happened in the first draw of lot, the candidate who was selected was ultimately cancelled. His selection was ultimately cancelled because for non-fulfillment of the eligibility criteria. Thereafter, there was a second draw of lot. Now, in the second draw of lot, the writ petitioner got selected. Now, as per the selection brochure, there is a provision because only the online applications were made. no documents in support of the credentials were submitted. Only after the draw of lots, when somebody is selected, he or she is called for submission of documents in support of credentials. So in this case, that had happened. The writ petitioners was granted an opportunity after selection through draw of lots to for submission of the documents in support of the credentials. Now the writ petitioners failed to do so within the stipulated time, which is there in the selection procedure. Now thereafter, as per the provision of the selection procedure, another opportunity is to be given to the candidate, and accordingly another opportunity was also granted. Now, even after the second opportunity granted to the writ petitioner failed to submit the requisite documents. And as per the selection procedure, if the documents are not filed within the stipulated date, then in that case, the selection will be cancelled. And according to the selection of the writ petitioner got cancelled, and thereafter the third draw of lots was conducted amongst the remaining candidates, in which one person was selected. Now, after the third draw of lots, because the third draw of lots happened in December 2018, and the cancellation of the writ petitioner's candidature happened in November 2018. Now, in December 2018, a third draw of lot happened. And thereafter, in January 2019, the writ petitioner writes a letter to the Indian Oil Corporation saying that in spite of having opportunities to participate in the selection process, he could not. So accordingly, one more chance be given to him for filing the documents. So we said that no more chance can be given because in view of the third draw of lots, another candidate had already been selected. So challenging that cancellation, but the writ petition was filed.
Mr. Nag, where is the question of any stay? Because you have already complied with that order.
No. In the writ petition, the
writ petition, the learned single judge was pleased to observe, in view of the above, the company is directed to proceed with the redraw from the stage when the selection of the first successful candidate stood cancelled. You did that?
No, because we did not, because we filed the appeal, because it was never, our case was that it was never the case of the writ petitioner that she was not aware of the selection process. If you notice, kindly sees one letter, one letter which is the letter of January 2019, which the writ petitioner has written. Kindly sees the letter of at page 54 of my stay application.
Page 54, yes.
Yes. So in this letter, the writ petitioner is saying that the third paragraph, that I had been selected for getting the license of IOC by way of lottery conducted by your authority concerned. That, sir, I have received a letter from senior manager such and such, dated 18 December 2018, wherefrom I could know that my candidature has been rejected due to non-submission of requisite documents and FBC fee such and such only, and documents for FBC fee after getting selected for the same location, as well as reminder letter dated 12th November 2018. That, sir, due to my illness and in spite of my willing to avail the opportunity offered by you, I could not avail the same, and I have got sufficient credential for having the license of IOC, including required land in the location where the said IOC LPG gas is likely to be started. All the medical papers in support of my illness are enclosed herewith, and documents in support of my prayer are also enclosed for your perusal. Now, by this letter, it is the writ petitioner has admitted that he has got these intimations. It is also an admitted fact that she was selected through a draw of lots. So all these points are admitted. Now, this letter has also been referred by the learned single judge at page 243. Kindly see page 243, the impugned order. Impugned order starts from page 236, and if you notice, kindly see page 243.
Yes, 243.
243, the third paragraph. The The letter dated 18 December rejecting the candidature of the petitioner was surprisingly sent to the by registered post with acknowledgement due card. The envelope containing the aforesaid letter was posted on 20 December 2018. The reason for change in the mode of communication has not been addressed by the company. Thereafter, analysis. The petitioner by a letter dated 3rd January 2019 simply prayed for extension of time for making the payment. She never raised the allegation of non-receipt of intimation to pay the security deposit. She neither raised allegation of not being informed prior to holding of the redraw. The company ignored the request of the petitioner as a fresh draw was conducted and a third party was selected. So it is an admitted fact that she was always been communicated. She was aware of the draw of lots. She was aware of her selection as well as she was aware of
But
the.
Mr. Nag, the prayer you are making now, that would tantamount to allowing the appeal.
No,
That
my
would be
lord,
allowing the appeal.
no, this your losses can hear out there because very short point is involved, my lord. A very short point is involved.
Because there is no scope of stay of that. I mean, even if we stay that order, I mean, that
No,
is
I
neither.
may not proceed from the stage where I stop.
If then, Mr. Nag, we have to hear out the appeal, you have to fix a date for that. We cannot hear. Stay. If all the documents have been annexed, we can take the consent of Ms. Chakraborty, we can fix the appeal for hearing. But
This is all the
not
documents
possible.
are annexed, man.
Yes, Ms. Chakraborty will hear will fix the appeal for hearing, but it has to be before the next circuit then. We cannot hear you out
Yes,
and
ma'am.
decide the appeal
And my lord, the
within few days.
difficulty is this, my lord, it is a huge voluminous petition, my lord. My lord,
Ms.
online,
Chakraborty, you
my
have
lord,
to
it is
answer
a-
only one question. Why should the order be justified? Because you have admitted that yes, you knew about the draw. You were faulty on the count of producing documents. You were given three separate opportunities.
my lord,
You failed.
my lord,
So why should it be
my
recalled
lord.
from that date? Answer that
No, my
right
lord.
now. Do it.
Yes, my lord, my lord. May I, my lord?
Yes.
Yes. My lord, the procedure is to draw through draw of lots, the suitable candidates will be selected by the IOCL. My lord, in the fast draw of law, my lord, each and every procedure has been described in the brochure, my lord. At the time of publication, my lord, they have also issued the brochure, and they has to follow the brochure of the procedure, my lord.
Yes.
My lord, in the fast draw of law, someone else selected. My lord, thereafter, my lord, as per the procedure, she failed to deposit the security amount. And thereafter, the second draw of law, it was held in September 2018, my lord. And there the allegation started from the writ petitioner Lokmi Bashkar, my lord. My lord, the advertisement issued for issuance of LPG distributorship, my lord, Gramin LPG distributorship for the reserve category, my lord, SC, ST and OBC category, my lord. And petitioner also belong to a ST category. And she is a woman, my lord. She is a woman and she applied for. And my lord, in September 2018, the second draw of law conducted by the IOCL. And after selecting in the second draw of lot, my lord.
Yes.
Yes, my lord. My lord, as per their brochure or the procedure, my lord, they intimated that they will intimate to the selected candidates either by SMS or email or later, my lord. But in this case, my lord, the agitation or the allegation of the petitioner, my lord, they never opted such any other options either to SMS to the number of the writ petition or to email or any hard copy, my lord, to intimate the petitioner that she has been selected in the second draw of law. And neither they published that the result of the second draw of lot, that the petitioner was selected in the second draw of lot. And this point also taken into consideration.
But Ms.
at the time
Chakraborty,
of
during the
hearing.
pendency of the appeal, they have permitted you to deposit your documents to consider you.
No, my
You
lord.
failed.
No, my lord.
You're denying that.
No, my lord, during pendency of the appeal, we have, because by the impugned order.
Very well,
the-
Mr. Nag will direct you to file informal paperbooks with the documents which are already on record. Do it, and immediately thereafter mention before the appropriate bench.
All the
Well,
documents
they
are there in the
might
stay
fix a
application,
date.
my lord.
The act order, the nature of the stay sought for in the present application pertains to the merits of the appeal, and if the said prayer is granted, comma, it will tantamount to deciding the appeal finally without giving an opportunity to the parties to be heard on the same. Full stop, hence, comma, let Mat 5 of 2022 be heard along with Can 1 of 2022. Full stop. Informal paper books shall be prepared by the appellant at the within a fortnight from date, Mr. Nag,
My lord, my lord.
within a fortnight from date, and shall be filed immediately thereafter. Full stop. The relevant copies of the same shall be circulated among the learned advocates for the parties. Full stop. Liberty to the parties to mention for inclusion in the list before the appropriate bench after the appeal becomes ready for hearing. Full stop. The lower court records be dispensed with in view of all the relevant documents being already annexed to the stay application as well as the memo. Service of notice is also
Then
dispensed with.
both the,
Yes. Are
then both the appeals be heard.
Very well. The appeals be treated otherwise ready for hearing, comma, apart from the filing of paper books. যেটা appeal বলেছি appeals করে দেবেন. Appeals.
And the
File a composite paper book. Mr. Nag, should he direct a composite paper book to be filed?
Yes, my lord, if a copy of, because I have not been served with a copy of the stay application of the memorandum of appeal of the other appeal. If a copy of the
Memo I have served.
তাহলে একটা লাইন অ্যাড করে দিন, যেখানে পেপার বুক বলেছি যেখানে কম্পোজিট করে দিন, আর a copy of the stay application along with the annexures filed in connection with, what is your appeal number, Ms. Chakraborty?
My lord, the second one, my lord, the
Ms.
list
Nag, what is the
not-
other number?
My lord, MAT 55, my lord, of 2021. Which is item number 10, my lord, if you lost it.
Item number 10 হচ্ছে MAT
9 and
55 in connection with MAT 55 of 2021 be served within a week by the learned advocate for the appellant therein to the learned advocate appealing for the respondent. Thank you.
Grateful, my lord.
Deeply obliged.
11.
For 1 day accommodation.
Not today.
Take a formal order, not because this is the fifth occasion wherein they have been.
Then that it not today means it goes to the next circuit, because tomorrow we'll be taking up the bail again. Very well. You are for the respondent. The where is he? Escaped.
I think I'm counsel for the union of.
No, he has escaped. Please bring him to pass an order.
Lord, this matter has been listed 18 times. Today is the 5th day of hearing. The only question involved is whether CCS Act can be applied to SSB.
An adjournment is sought by the appellant. Full stop. Accordingly, let the matter stand adjourned till the next circuit. Yes, purpose served. Mr. Jagriti Mishra, Arunanam. Next. 12. Private respondent. Yes, who is for the appellant?
My lord, I'm paying for short pass over.
No. Start the matter.
So, Hon'ble sir is
You are the junior of Mr. Shah. Let him start. Let your junior start. Let your junior start, Mr. Shah. He is not your junior. Let him start. You will pick up. Yes. Let him start. The person who sought for time, is he a junior, Mr. Shah? He has to start the matter, otherwise we will dismiss it for default. Move the matter.
Actually, I have no idea, my lord.
Yes, any other point, Mr. Shah? Yes. Mr. Shah, take over.
We have prepared the MPB reply to the, against the MPB opposition lordship. Today I have affirmed it lordship. The copy is with me lordship that I am starting.
Next circuit, he has to get ready.
This is against the affidavit filed by the state.
Yes.
Respondent numbers 1 to 4.
1 to 4.
In connection with that. Oh, not your.
For the private respondent. I'll take one copy.
Yes.
You are the appellant.
Yes, appellant.
What is the application for?
Application for stay lordship.
Argue the appeal.
Yes,
Prima facie case of the.
There is an order lordship by your lordship, and this is the order 9th of February 2023.
Directive what?
Admitting that there is a leave to file an appeal, your lordship were pleased to file.
Why leave? Because they were not parties to the.
They were not parties to it. Your lordship, my lord, was pleased to grant leave.
Grant leave.
Grant.
What is the challenge about?
Subsequent, there is a subsequent order whereby the petitioner, the appellant has been directed to file their reply, lordship. I have prepared it. This order, this matter is pertaining to, and the impugned order was passed without making the appellant as a necessary.
So the respondents, this is a reply to respondents 1 to 4. 1 to 4 opposition. Have they filed their opposition at all?
Yes, yes.
দেখে নাও তো হ্যাঁ ঠিক আছে yes
Respondents are filed by law.
you are for the state
No, I am for the private respondent.
oh yes
The writ petitioner, the private respondent had filed the writ petition and got the impugned order without making the appellants as a necessary party in a pre-existing, in a collateral proceeding where we have taken out an application and got an order from the honorable single bench, coordinate bench, where a direction was passed upon the DIG Fire Service Authority to look into the irregularities in the recruitment process and file a report. Report was filed and there was an admitted irregularities which was admitted by the DIG Fire Service Authority, and accordingly that list was pending. Suppressing this order and reply and report.
give a notice Mr. Shah, the writ petition, you are not for the writ petitioner, or you are for the writ petition.
Suppressing that findings and the pre-existing order and all.
Let us see that order first.
Order has been passed.
Let us see the impugned order.
Page 174 of the stair.
Please place the impugned order. Page 174.
The writ petitioner is hereafter clearance the hurdle and they got an order, one letter hereunder, and there are intimated that the training would be given to them, and thereafter appointment would be given to them. Date of letter is so and so, which is at page so and so. It is it is in the form of notice. It was the post of auxiliary fire operator and contractual basis for the Alipurduar district under the West Bengal Fire Service Emergency Services. The court directs the Director General of West Bengal Fire Service Emergency Service to start the training within a period of 4 weeks from the date of communication of this order. So and so learned advocate for the state to submit that such direction may be passed by a court so that the appropriate arrangement can be made for the petitioner and the person who came under the notice January so and so. This is the
Who are you?
catch.
Who are you?
We are the writ petitioner. We had challenged the recruitment process because of glaring irregularities which was admitted.
You are the writ petition in the other writ petition.
Other petition.
You have challenged the recruitment process.
Yes,
Unsuccessful candidates.
yes, and they are also some of the candidates that the present writ petitioner who had got the impugned order. They are the party in the.
They were the successful candidates.
Successful candidate, and they are the party in the said writ petition. My writ petition.
In your writ petition, was there any stay order, restraint
No,
order?
there was no stay order, but there was an direction, specific direction that a inquiry to be conducted and a report in form of a affidavit will be filed by DIG. DIG admittedly filed a report admitting the irregularities, and same DIG, but without curing this and without disputing and within curing the said irregularities, the same DIG has been directed to appoint the successful candidate.
These were not mentioned in his writ petition.
No, complete suppression of fact, and not to, that's why I prefer the appeal. We have not been made party even in the said proceeding.
So what is the stage of your writ petition?
Both are pending. Both my writ petition is pending. I simply paid for the analogous hearing of both the writ petition.
In your writ petition, Mr. Shah, was there any restraint order? No restraint
No
order.
restraint order. I have to check it out, but I believe that there is no restraint order.
Yes, Mr. Bhattacharya, they are affected parties, squarely affected.
My lord,
If a direction was given to file a report, there were certain irregularities, alleged irregularities. How can this be directed to proceed?
Regarding alleged irregularities, my lord, the state has filed an affidavit in this present.
No, we are not on the irregularities right now. That is the subject matter of the previous. The question is, they were the necessary parties. Without them, how could this be passed?
My lord, we were not served. Now, if your lordship kindly takes.
We'll
up-
stay the operation of this order or set aside this or direct both the writ petitions to be heard together.
Yes, but one thing, my lord, I'll point it
Without
out.
going to the merits, of course.
Yes, and the point, my lord,
Yes.
the order had, by the impugned order, my lord, the concerned authorities were directed to complete the training of the successful candidates.
Already done.
That has been done, my
You'll get trained again.
lord.
You'll become better operators.
My lord, may I make one humble submission, my lord? We have to participate in the writ petition, my lord. We will participate.
Definitely.
Since it is.
Otherwise, that writ petition will be bad for the same.
No, since 2001, it is pending, still AST number, my lord, they have taken no effort to have that heard. Even this mandamus appeal, my lord, it has been repeatedly mentioned by me. Because the difficulty I am facing, that all of us, my lord, had to leave whatever employment we were.
That we can gather from this order also. Otherwise, the order is correct, perfectly correct.
May I-
Pass rejection upon the learned trial court to analogous hearing with the time bound manlordship.
Time bound.
If it is possible.
Yes, kindly, my lord.
Intra-court appeal, we cannot make it.
That is true. And my lord.
In the next circuit, I'll be coming and the time bound will be definitely not.
My lord will not be sitting a single bench. Possible.
We never know. We never know.
Then we will not.
Thanks to all of your clients.
My lord, very well, my lord. The training has been imparted,
Okay.
the employment has not been given. Let
We'll
us-
stay that. We'll stay that. But
That has not been.
no further action will be taken on this, and we'll dispose of the appeal itself. We'll say that on consent the appeal is itself. Otherwise, it will be no meaningless.
We want to dispose on, my lord.
Very good.
And my lord will kindly, subject to my lord's convenience, my lord direct that the further employment or whatever will be outcome of the pending writ petitions.
No. How? If there is a
Employment if Mr. Bhattacharya, if
authority cannot.
employment is given, we cannot take away. Then we cannot take away your rights.
Ask for an employment, my lord.
What will be subject to the result?
The employment, final employment.
That will be granted only subject to the result.
Yes, my lord.
Yes.
No order is required for that, obviously. Employment may not be granted also if it is set aside, if they win.
The last occasion, my lord, a friend was making that.
On consent of learned counsel for the parties, the appeal itself is taken up for hearing along with the application, comma, in view of the conspectus of the dispute being short. For some next para, the present appellants argue that the learned trial judge acted without jurisdiction in passing the impugned order insofar as the writ petition itself was bad for non-joinder of the present appellants, whose of the present appellants, comma, it is submitted, comma, had turned out unsuccessful in the process of appointment and had challenged in a separate writ petition, comma, the said process, whose of in connection with the said writ petition, comma, a direction was given to file a report and allegedly certain irregularities had transpired in the appointment process.
My lord, sorry, my lord, will kindly not record this.
Allegedly,
No,
yes.
even then, my lord, why am I saying, my lord, state is not here today, but the affidavit of state is here, where it has been clearly stated in the report that no irregularities are.
My submission.
So anyway.
According to my submission.
Next para, thank you. However, comma, it transpires that the said stand is opposed by the state in its opposition. Full stop, next para. Be that as it may, comma, it is argued that since the process of appointment itself stands challenged in the other writ petition, comma, filed by the present appellants, comma, the direction in the present impugned order for the same process to be concluded directly affects the rights of the appellants. So as such, comma, the writ petition bearing WPA 1242 of 2022 was bad for non-joinder of the present appellants. Full stop, next para. Learned counsel appearing for the writ petitioner in WPA 1242 of 2022 stroke respondents in the present appeal, controverts the allegations made by the appellants. First up, it is argued that the appellants, only after becoming unsuccessful, had challenged the said process. First up, next para. Moreover, it is argued that there was no restraint order passed in the other writ petition regarding the appointment process. First up, next para. Upon hearing learned counsel for the parties, even without going into the merits of the allegations and counter allegations pertaining to the appointment process, we are of the opinion that the present appellants were undoubtedly necessary parties in WPA 1242 of 2022, since the outcome of the said writ petition directly affects the fate of the appellant's other writ petition as well as the appellant's rights regarding the appointment process. First up, next para. In such view of the matter, we are of the opinion that the order dated August 10, 2022 ought to be set aside, since WPA 1242 of 2022 was not maintainable, being bad for non-joinder of parties. First up, next para. Accordingly, MAT 74 of 2022 is allowed, thereby setting aside the order dated August 10, 2022, passed in WPA 1242 of 2022, and directing and sending the matter back on remand to be heard by the concerned learned single judge having determination, along with WPA
AST1 2021.
AST,
AST, my lord. Kindly appreciate.
still AST,
Still AST.
along with
21, it is AST.
along with AST1 of 2022 of 2021. Full stop. Next para. Can 2 of 2022 is accordingly disposed of as well. Full stop. It is expected that both the writ petitions are disposed of at the earliest. Full stop. The office is directed to allot a permanent number to AST1 of 2021 at the earliest, preferably before the commencement of the next circuit. First of liberty to the parties to mention the writ petitions for being heard before the appropriate bench having determination in the next circuit.
Great.
My lord, I am grateful not because the order has been set aside, but a closure has.
Appeal has been disposed of. That's why.
It has come to a closure.
Yes. Next.
13 I am for the appellants.
What is the matter?
I'm appealing for the appellant, my lord.
Yes, ma'am.
Yes.
I'm appealing for the appellant.
You are for the appellant.
Before the
Yes.
starts, there is a section. I am for the appellant, my lord.
Yes,
There is
a
a section 5 application. There is a delay of 98 days, my lord. I have already, my lord, on last occasion, the state was served, my lord. My learned friend will, my lord, submit the affidavit of service.
Good service.
Yes.
What is the reason for the delay?
Delay, my lord, lordship will kindly see, my lord, it's a 69 years old person, my lord. Medical difficulties, my lord. Lordship will kindly takes, my lord, paragraph 3-4, my lord, of Can 1.
Can 1 is the section 5?
Yes.
Yes, my lord, Can 1 is section 5.
Can 1 ta kunta go?
Paragraph 4.
Please check. Thank you. We are satisfied at a Can 1 of 2020. We are satisfied regarding the explanation given for the delay in preferring the appeal. Accordingly, Can 1 of 2023 is allowed, thereby condoning the delay in preferring MAT 88 of 2022. full stop, let the appeal be registered duly. Full stop, next para.
Yes.
What about the can 2 you have served also?
Yes.
There is no scope of any stay.
Can 2 has been also served.
There is no scope
There
of
is no
stay.
scope of stay. In respect to that, yes, there is some. Lordship will kindly take the impugned order before Lordship proceeds.
Yes, we
Only
are
one
going
line
in-
order.
Yes, we are looking through that. I mean, no public element, therefore dismissed. What does stay of operation of
Yes,
that means?
only
It revives.
after 12 years. Yes. No, Lordship will kindly take page 88 of my stay application.
If the
Page
state
80.
is not there,
That
Mr.
was the
Chatterjee,
urgency.
if the state is not there, we cannot, allow the appeal. And the appeal
But
could have
I
been
was
disposed of.
all the through I was enjoying the all the way I was enjoying the interim order passed by my Lord Justice Joint Vishwas, my Lord. That will be evident at page 70, man. So since 2011 I was enjoying. Lordship will kindly take page 71, my Lord. Even they have filed a vacating that was also dismissed, man.
Give a notice to the state, we'll take up the appeal for hearing tomorrow.
Grateful, man. Grateful. Grateful. Yes. Grateful. Grateful. Grateful.
Or in view of the extremely short compass of the appeal itself, the appeal itself, lower court records is dispensed with, full stop, since service of the applications have been effected on the state, further service of formal notice is also dispensed with, full stop. Since the papers annexed to the applications as well as the memo are sufficient for deciding the appeal itself, the appeal itself is fixed for hearing tomorrow. At the top of the list, full stop, let a notice in that regard be given to the respondents to the by the learned advocate on record for the appellant. Not tomorrow, day after tomorrow. Day after tomorrow. We'll take it up day after tomorrow.
Grateful, man. Grateful.
Yes. Thank you. Should we keep it on the next circuit?
Lord, as
The learned single judge is probably coming. No, he cannot.
Lordship takes
No,
it
he
there
cannot
after
take us.
tomorrow.
His lordship cannot take us.
Grateful.
Yes.
Item 14, I am for the appellant. Your Lordship.
Who is the application for?
My lord, is the application for? The main writ petition is application for that your appellant has appointed as a primary school teacher in 2010. 2010, they are appointed on the basis of PTTI examination.
You were appointed,
Yes, appellant.
right? Then
On then 2012, on 13/8/2012, the Government of West Bengal School of Education, Department of Elementary Education issued a notification. In the notification, they are described that kindly your lordship come to page.
no, by the impugned order, the learned single judge directed the Secretary West Bengal Board of Primary Education to take steps to declare result of the petitioner of a 1-year bridge course in the light of notification. So that direction was given to the other side. You are the respondent there in the writ petition. Oh, this is the appeal. You are the writ petition. The order was passed in your favor. So this direction was passed direct the Secretary West Bengal.
In that case,
Hmm.
Justice Samakti Chatterjee was direct, not.
Oh, this is not the impugned order.
Impugned order, page number.
What is the memo we can? Last.
25, your lordship. And it should be.
You have annexed that order to seek parity with that. I mean, you say you are also on a similar footing.
Yes, sir. On July, in the circuit bench, your lordship, headed by the Rajabasu Chaudhary, was directed the respondent authority, that is particularly the board, to submit a report.
The final order is dated 4th of November 22. This is the entire order. You've given a notice to the others, to the state. You're appealing for the state. How do you defend this order? Show him a copy of the order. Do you have a copy of the order? We'll take up lock, stock, barrel. We'll remand the matter to the learned single judge. In view of the compass of the appeal being extremely short, comma, we decide to take up the appeal along with the application. In view of appearance of the state, comma, formal service of notice as well as lower court records is be dispensed with. Next para, by the impugned order dated November 4, 2022, comma, the learned single judge merely observed that the learned advocates appearing for the petitioner was heard, and considering the contents and prayer made in the writ petition, comma, the learned single judge was of the view that there was no merit in the writ petition, and accordingly the same was dismissed. We find palpably that the impugned order is devoid of reasons and, comma, as such, comma, should be revisited on merits and be decided upon attribution of proper reasons for going either way. In such view of the matter, comma, MAT 99 of 2022 along with Can 1 of 2022 are allowed, comma, thereby setting aside the order dated November 4, 2022 passed in WPA 805 of 2021 and remanding the matter back to the learned single judge having determination to take up the same matters for being reheard and re-adjudicated on merits, comma, upon attribution of proper reasons. It is expected that the matter shall be listed, comma, subject to the convenience of the concerned bench, comma, before the appropriate learned single judge in the next circuit. Thank you. Yes, two.
Yes.
You are appealing? Yes.
Yes, for the appellate.
Right.
Now, before we takes it up, just one thing, while referring the appeal, two pro forma respondents were not added in the array of respondents. The SJDA and the Fire Services Department. So, in course of the day, I will add those. Fire Services Department in any event is represented by the state. They are served. There is no difficulty. For SJDA, I have also served copies. They don't have any say in this matter. They're just a pro forma respondent.
But we cannot waive it like that. I mean,
They're appearing also. They're appearing also. There is
who is appearing for that? You are.
I am for the SJD.
Oh, very well. Very well.
There.
So we'll grant you the leave to carry out the
add
corrections.
Those parties in course of that.
Yes.
This is my affidavit of service. When the state is served, the essence is returned.
Right.
Siliguri Municipal Corporation.
Yes.
Now, Miller just takes the impugned order. Miller, in my memo of appeal, Miller,
I'm on behalf of the respondent number 1 and 2.
Respondent number 1.
I'm led by Mr. Lanet, senior.
Mr. Mr. Kishore Datta is leading you. Achha. Yes.
Take the Miller, take the risk of doing it without a senior.
Mr. Datta, what reputation you have gained? Mr. Ghosh is saying he's taking the risk of moving the matter despite you being there.
So, I have got a lot of affection for Mr. Ghosh.
All right.
He knows that.
Miller, the impugned order first.
Yes, yes, yes.
That is 21st of August 2023.
Right.
Miller, learned advocate for the Siliguri Municipal Corporation submits
Yes.
that the respondent number 10 does not have any license. The license was cancelled by the Siliguri Municipal Corporation as the license was obtained by fraud. The petitioner's allegation is that
This is license to do what?
license, the reference is to a certificate of enlistment of under the Municipal Corporation Act for running a business.
Achha.
The petitioner's allegation is that without license, the lodge is being run by the respondents number 10 and 11. The police authority has filed a report stating that the Hemlata Guest House and Lodge authorities has not filed any report in prescribed format stating the details of daily customers and boarders at the said guest house regularly before the OC Panitanki town outpost. Therefore, it is found that a guest house is running illegally and nobody knows who are the boarders there, and it is now very dangerous to allow any person to stay in a guest house without knowing him. The petitioner is the sister of the respondent number 10. The petitioner submits that the trade license is obtained in the name of a dead person and she had objected to that. However, I direct the police authority to close the said guest house forthwith and to report me back as to the action taken tomorrow in the morning. Learned advocate for the state is directed to file the report as to compliance of this order. Report filed hereby, or my lord, slightly illegible in my copy, by the police authorities, kept
Today.
on record, list the matter. Subsequently, my lord, that is inconsequential for the purpose of appeal, because 22nd August naturally was, my lord, the compliance which was filed after shutting down of my running business, which was in the nature of a guest house. So, my lord, I am against this order. Now, my lord, would 1 second, my lord, come back to the impugned order. My lord,
Writ petition is still pending, Mr. Ghosh.
Writ petition is pending.
So why not hear out the have the writ petition heard out?
The only exigency is, my lord, my running establishment has been shut down without hearing me.
Oh, this was passed on 21st August.
21st of August. Now, my lord, would kindly see, my lord, in the appearances, the respondent number 8, that is me, I was represented by a set of learned advocates, but no submission of me was recorded. I intended to place all the documents that I had.
What you, because respondent number 10 all along has been submitted.
It has been referred to as respondent number 10, but my respondent number 8 is not, my lord, his presence even has not been noted.
8 is the party who's you are 8.
Yes.
Your license was cancelled.
My license was cancelled.
Achha, your license, if that was already cancelled by the Siliguri Municipal Corporation, how can you run the?
No.
It was recorded in the order.
Yes, that was, without granting an opportunity to place the facts
Even then,
in the documents. Now, Millard would straight away,
without a license, Mr. Ghosh, you cannot run the establishment.
kindly comes at page 144 of my stay application.
Sorry, 144.
144 of my stay application.
Yes.
This is, a permanent certificate of enlistment granted in favor of the petitioners. That is, Sanjeev Shah, Monika Shah, Fauzdar.
Right.
The two appellants herein, proprietors of Hemlata Bhavan. This was, the date of issuance was on 28th of June 2023. And, it was valid till 27th of June 2026. I wanted to place this before the
This was cancelled.
No. The learned single judge, honorable single judge, proceeded on the basis, as appears from the order, that I did not have a license in the first place.
No, it was cancelled.
Yes, it was cancelled.
Lunch is finished. Don't speak unless you are asked to. Yes.
Earlier, it was cancelled by way of an order of the Siliguri Municipal Corporation. Now, Millard, kindly, I'll just address your lordship's query on that. Millard would come at page 28. This is Krishna Rao's order. That will, Millard, give a backdrop to the dispute also.
Yes.
29. If I may just place, Millard, I'll just read it.
No,
out.
just tell me, tell us, Mr. Ghosh, you had challenged the cancellation.
Yes.
And
Millard, the license was initially obtained by petitioner in the writ petition, being my sister.
Yes.
She claims that was obtained by fraud. That was cancelled 3 rounds of writ petitions. On 2 rounds, my license, the order of cancellation was sent back for fresh reconsideration by the corporation. In the 3rd round of litigation, order of cancellation was set aside by Justice Rao. Justice Rao remanded it back for the Siliguri Municipal Corporation to take a decision. Kindly see the observation of Justice Rao. This will also give a backdrop of the dispute. That would be probably that is required to be presented from the end of the appeals. The petitioners have filed the present writ application challenging the order passed by the Commissioner Siliguri Municipal Corporation dated so and so, wherein the trade license issued by the corporation dated so and so was cancelled on the ground that the trade license was issued in the name of dead persons. That is the father, mother, and uncle of the petitioners, and the petitioners are
now, Mr. Ghosh, Mr. Dotto, Mr. Ghosh, Mr. Shah, and all concerned, we are taking up the appeal itself for all practical purposes.
Yes, yes.
Yes, Millard, that can be done. No?
Because otherwise, there is no meaning to hearing the application. This is a short appeal. Yes.
Millard, since your lordship has been pleased to Millard,
pending this, my establishment be allowed to run without creating.
Mr. Dotto is representing whom?
The private
writ petitioner, the complainant.
The equity, Millard, I am agreeable to that.
Will Mr. Dotto agree to that?
Look, may I say one thing, Millard?
Yes.
Since your lordship has been pleased to make this inquiry,
yes.
Please have a look to Millard, page 144. Please have a look to the premises number.
Oh, acha.
Can you look into the premises number?
Yes.
Here, your lordship will find Millard, the premises number is 93 by 147 by 2 by 627 by 2 Raja Rammohan Roy Road.
Yes.
Now, my lord, the trade licenses which were cancelled, those your lordship would find, my lords will find at page 91 and 92. Kindly, my lord, compare
Yes.
the premises numbers.
Mm-hmm.
Page 91, which was for the year 2018-2019.
Hmm.
This was in respect of age by 147 by 13.
Yes.
Same age, page 92, age by 147 by 13.
Right.
Today, my lord, my learned friend's client seems to, my lord, take recourse to page, I mean, the appellant should be allowed to, my lord, run the business based on page 144. Now, 144 is in respect of some other premises, number one.
Achha. Yes.
Number two is, my lord, there are 3 reasoned orders passed pursuant to, my lord, orders passed by this honorable court, my lord, where, my lord, the municipal authorities have held that these certificates of enlistment were obtained by fraud. Now, my lord, the first order, my lord, your lordship.
No, then
would
Mr.
find-
Datta, let us hear Mr. Ghosh first, because he's
Well,
in the midst of argument.
I was just placing, my lord,
Or in that case,
Justice
my lord,
Rao's
could I
order.
make this prayer?
Yes.
Could I make this prayer? If
Yes,
your
Mr.
lordships may kindly permit us 2 or 3 days time to file our affidavit, so that, my lord, in course of this circuit, your lordships may hear out the appeal. Because this is against an interim order.
The last date, Mr. Datta, it won't be possible to for us to hear out the appeal and pass judgment, maybe. Then we'll put it on the next circuit. Because Mr. Ghosh, the stay order will mean the entire appeal is allowed.
I am saying, my lord, without creating an equity, my lord, kindly see Justice Rao's order.
Let us see Justice Rao's order.
That is
Yes.
very important.
Yes.
My lord, page 30, my lord, internal page 2, up to that, my lord, I have placed. Counsel for the petitioner submit that the Commissioner Siliguri Municipal Corporation, while passing the impugned order, has relied upon the partnership deed entered between so and so, but the corporation has not considered the reconstituted deed of partnership executed on 1st April 2017, wherein only 2 partners are there, i.e. Sanjeev Shah and Monica Shah Pozdar. That is, my lord, the 2 appellants before your lordship. Learned counsel for the petitioner further submits that the Commissioner Siliguri Municipal Corporation has also not considered that Sri Sanjeev Shah, who is one of the partners in terms of the reconstituted partnership deed dated so and so, had applied for grant of license. Learned counsel for the petitioner submits that the Commissioner has cancelled the license issued to the petitioner by considering the documents which the petitioners have not relied upon, and as such, the impugned order is required to be set aside and a license is to be revoked. Learned counsel for the Siliguri Municipal Corporation submits that in spite of having knowledge that so and so had expired and the municipal corporation had issued license in the name of dead persons, the petitioners had not informed the same to the corporation, and the petitioners, taking in the benefit of the said license, continued their business. And when the corporation came to know about the said fact and the complaint was made by the sister of the petitioners, the corporation had conducted an inquiry, and after the inquiry, the impugned order was passed. Counsel for the corporation submits that as the license issued in the name of dead persons, the same cannot be revoked, and the petitioners cannot continue with their business in the name of dead persons. Consider the rival submissions. Now, my lord, kindly see the observations of the court. Admittedly, on 31st March 2020, the corporation had issued license in the joint name of these 4 erstwhile partners, but not in the name of Sanjeev Shah, though Sanjeev Shah had made an application for grant of license in terms of the deed of partnership dated 1st April 2017. Now, pursuant to 1st April 2017, my lord, the partnership was reconstituted, wherein these 2 appellants only remained as the partners of the firm.
So you had already made an application for transferring their name.
Your name. Kindly seize the order. That opportunity was granted to me. After going through the record, this court finds that Sanjeev Shah, who is one of the partners, has applied for grant of license, but the corporation in a routine manner had issued the license in the name of 4 persons named above without considering the application filed by the petitioners. And as such, it cannot be said that only the petitioners are responsible for the license issued by the corporation in the name of dead person. In view of the same, the impugned order dated so and so passed by the commissioner so and so is set aside and quashed. The Commissioner Siliguri Municipal Corporation is directed to consider the case of the petitioners afresh in terms of the application filed by Mr. Sanjeev Shah initially, being application number so and so for the year of 1718 and 1819 and subsequently 1920. In all those years, the appellant has applied for a license, but that was not considered in correct perspective. The commissioner's SMC is directed to complete the process by passing a reasoned order and speaking order within a period of 4 weeks from the date of receipt of copy of this order, giving up opportunity to hearing to all the parties.
What happened after this?
Well, kindly seize the date of this order. This is important. 8th of June 2023.
Right.
Now, Millard comes to there, Millard, the private respondent, Mr. Dotto's client, was represented in the writ petition.
Achha, yes.
Despite that, they are aware of this, that the issue of license is under consideration of the SMC in terms of the observations by the Honorable Single.
Mr. Dotto is for the sister.
Yes, for the sister.
Yes, then.
Now, Millard kindly comes to page 20. I'm sorry, Millard. Yes, page 20 of my stay application.
20 is the affidavit.
Yes. See the date of affirmation. 31st of August 2023. The writ petition on the basis of which the Honorable Single Judge passed the impugned order of closure. This writ petition was affirmed on 31st of August 2023.
No, this is the this is your can in the appeal.
Millard?
This is your can in the appeal.
No, Millard, I am sorry, Millard. I wanted to place the writ petition. It is there, Millard. I am extremely sorry.
Yes.
Millard, yes, 62.
But this is 24th March.
I'm sorry, Millard,
62.
62. 62, Millard.
Yes.
24th March 2023.
So previously.
Yes. So that pursuant to Justice Rao's order, when the corporation was in session of the matter, with regard to the license in question,
Achha.
this writ petition was preferred in a absolute Millard malified motives.
Prior.
And Millard, yes, prior. And
Filed prior, moved later.
moved later. And when it was taken up by the Honorable Single Judge, Justice
Yes.
Krishna Rao's order was not even placed or pointed out to the Honorable Single Judge. And on the basis thereof, Millard,
So that process is still going on with
that
the.
process is still going on. They have not yet to pass a final order.
You are for the municipality, must be.
Must.
Why didn't you comply with this order?
No, the opportunity really was given to them. They had come, they had.
To whom? Mr. Ghosh's client or Mr. Dotto's client as? To Mr. Dotto's client as well? When? Let us let him complete. Yes.
Yes. Now Millard could see that after Millard, I have just placed 144. Millard, the other allegations which was Millard referred to in the impugned order, Millard
Yes.
would take page 145 onwards. Millard, the fire safety license was issued in my name. That is valid and subsisting. And Millard, from 147 onwards, Millard would see the log of guests, the customers who are availing the lodging facility there, is being Millard regularly submitted before the concerned police station in compliance of the SABYASACHI Act. And Millard, because that was also an allegation brought against me in the writ petition, though the Honorable
But the
Single
police
Judge-
report was contrary to you.
Yes, contrary to that.
You
but
did not get an opportunity to control.
Never. And Millard, under the SABYASACHI Act, Millard, I am covered by your Lordship's own judgment, where your Lordship has held that regarding the point of delegation. That Millard, I'll just.
No, what is that? What is the context? The proposition there? Just tell me.
Mr. Dotto also appeared there. Millard, this was regarding the closure of a park under the Millard, the Immoral Trafficking Act and the SABYASACHI Act also. So your Lordship has Millard,
Same learned single judge. Same learned single judge. There also.
Yes.
I remember the matter. Yes.
Yes. So Millard, your Lordship has held, after considering a Supreme Court judgment, that further delegation to the magistrate was not permissible either under the Millard, the IT Act or under the SABYASACHI Act. So therefore, the order of closure was Millard set aside.
Anyway, let us not go into that. So you say, as on that date, you have been regularly submitting, you are given no opportunity and you have a license,
Yes.
but you are under the order of Justice Rao, which was
Yes.
not complied with that
Which was
till
not
then.
complied with.
Very
And in such context, there was no reason for the petitioner to press this writ petition and to get an order, Millard.
Despite knowing that that
despite knowing
exercise
that,
is going on.
Yes.
And it was apparently not disclosed also.
Apparently not disclosed.
At least not reflected in the
Yes,
order.
not disclosed. Not disclosed.
So this is your case.
This is my case.
Uh,
At least a case, prima facie case for a state.
Mr. Datta, I'll hear the municipality first, then I'll come to you. Let us hear what the municipality has to say so that you can. Yes. Please take the microphone so that Mr.
If you look at the text of the order passed by Justice Rao.
Yes.
Order is dated 8th June 2023. Lordship.
Right.
Justice Rao delegated back the matter to the commissioner to decide on the merits of the case, and if his client is entitled to a trade license will be given to him to run his business. Now the date of the order was on 8th June. 8th June.
Yes.
Yes, and now kindly comes to page 144. This is the e-license which he has obtained. This is dated 28th June. He did not wait for the commissioner to give him to conclude the hearing and give him a license. He obtained the auto-generated copy. This
That was of the previous one. Oh, this is the new date of.
This is the auto-generated.
No, auto-generated means you have to grant it.
No. This anybody, any trader who feels like conducting a business, he can from his home he can apply for the government of West.
This is not an application. This is a permanent certificate of enlistment.
Yes,
It can be auto-generated.
yes, from the government of West Bengal portal. Anybody can do it.
What?
Yes.
Unbelievable.
What are you saying?
Yes, this is the Lordship kindly comes
Mr.
to
Dhora, do you know what is the implication of what you are saying?
kindly comes to the disclaimer, Lordship.
Have you extended your wings to the court orders also, auto-generated?
No. Kindly come to
Why not?
kindly comes to the disclaimer, Lordship. This document is auto-generated through computer system as per data submitted by the applicant himself in online procedure. It's an online copy. He ought to have waited for the commissioner to conclude the hearing and pass a result.
How can an online certificate be issued by a person in his own name? I apply for permanent certificate of enlistment that is granted automatically.
Yes, Lordship.
Cannot be, Mr.
Yes. This is done by the government of West Bengal. Portal it is if any trader who wants to conduct a business.
Certificate, how can it be issued? Application can be, you can get a copy of the application. Nothing is written here. Disclaimer won't do. It has to be then provisional at least. This is a permanent certificate of enlistment.
Fees has been accepted. It has an expiry date.
What are you submitting, Mr. Dhora?
No.
Cannot be.
This is the thing. It's auto-generated. Anyone can apply from their home, and this printout will come out. This is an online system.
You are appearing for the state also? Yes, you are not for the state.
Now for the corporation.
This is the system. An auto-generated thing. I apply for a license to run an establishment. It is automatically generated. If that is available on the state's website, they did the right thing.
The document is auto-generated to computer system.
You're at a loss of words. So very well, they are obtained. What else? So what about your exercise? Did you comply with Justice Rao's order? Opportunity was not the order. Order was passed.
They had sought for time to produce some additional documents. Till that they have not produced the document. And on the strength of this document, they were carrying on the business. That was just.
How soon can you conclude the hearing on that?
Let them produce all the documents which were.
If they produce the document day after tomorrow, how soon can you do?
They have to do it by this week.
Within a week, you can do that. You have to also have to give a hearing to.
Yes, my lord, we are participating over there.
Yes, obviously, Mr. Datta, you have to. But so very well. Let me hear, Mr. This is all on your part. Yes, Mr. Datta. Suppose that. Let us forget that auto-generated thing for the time being. I mean, it is neither here nor there. But this order of Justice Rao was there. Now,
yes.
Therefore, it's not that these matters were not considered by the learned single judge or not placed before the learned single judge, although you were a party to that, the other thing.
Right.
What is your explanation to this, Mr. Datta?
To be honest, I find that this was not brought to the notice of the Hon'ble single judge.
Apparently, yes.
Because now, so far as the certificate of enlistment at page 144 is concerned, whether it is auto-generated or not, but that is definitely a matter for concern, as the lordships are expressing. Now,
Yes. But we won't rely on that solely, Mr. Doctor.
Document that. Yes,
We won't rely on that solely.
Yes, I'll add to that. I'll add to that.
Yes.
First is, my lord, your lordships have noticed, my lord, there is a difference in the premises number between the one which were cancelled and the one which has been annexed at page 144.
Right.
Now, my lord, it has been said to your lordships that, my lord, it is an auto-generated one, and there is a disclaimer that this has to be verified. Now, apart from that, kindly look into the law relating to, my lord, grant of these certificates of enlistment. My lord, if your lordships may kindly have a look to, my lord, section 141 of the West Bengal Municipal Corporation Act. My lord, my learned junior is there, my lord, he may hand up, my lord, a copy of the West Bengal Municipal Corporation Act.
এই provision under দিয়েছে auto generate. Yes. Yes,
But
Mr.
I am not on the auto-generated part, my lord, I am
No.
on the, my lord, procedural aspect regarding grant of certificate of enlistment. Please have a look at 141 subsection 1.
Yes.
Every person engaged or intending to be engaged in any profession, trade, calling as specified in Schedule 2 and as may be detailed in the guidelines issued by the state government for the purpose in any area within the jurisdiction of the corporation, either by himself or by an agent or representative, shall obtain government certificate of enlistment or provisional certificate of enlistment as the case may be, as per the modalities specified in subsection 2, or get a permanent certificate of enlistment renewed on or before the expiry of the validity period thereof from the commissioner, or in his absence, officer authorized to function as the commissioner upon presentation of application together with such application fee as specified in the guidelines, etc., as may be determined. Then, my lord, the last part is application form for the purpose shall be available either from the municipal office on payment of so and so fees. Then please take, my lord, the proviso. Provided that provisional certificate of enlistment shall not be renewable on or before the completion of the validity period of the provisional certificate of enlistment and the same may be converted into permanent certificate of enlistment. So there is a procedure of provisional and then permanent. Now, in between provisional and permanent, what is to be done is, my lord, in the subsection 2. Notwithstanding anything contained in subsection 1, the application for enlistment of profession, trade, calling may also be submitted through web portals as may be determined by the state government, along with the manner of submission of such applications in the guidelines mentioned in subsection 1. In case of applications under this subsection where any or all necessary statutory clearance remain pending, but I'll harp on this, remain pending, provisional certificate of enlistment be issued for a period of 1 year, and where all statutory licenses are available, permanent certificate of enlistment be issued by the municipality concerned within the time limit as may be determined by the guidelines under subsection 1 on receipt of fees. The recipient of the provisional certificate of enlistment shall obtain all statutory licenses based on this provisional certificate of enlistment on or before the expiry of the validity of the provisional certificate, shall receive the provisional certificate from the municipal office on payment of fees as determined by the guidelines. The manner of issuance of provisional and permanent certificate shall be as such as may be determined by the state government. Therefore, my lord, there is first, my lord, a concept of provisional certificate. If statutory clearances are remaining pending, you have a time for 1 year to get those licenses, and then you get a permanent license. If within that period, where that is to be read into my second submission, if you don't get it, then you again apply for a provisional certificate. That is the second part of subsection 2. Now, my lord, here, my lord, according to us, there is no statutory clearances. Like there is no Shorai certificate, there is no higher certificate, environmental clearance, etc. So, my lord, the procedure as mentioned is first you must have a provisional certificate, get all the statutory clearances, then apply for the permanent certificate. Now, whether or not, my lord, 144, page number 144 has any validity in law or not, my lord, my learned friends, client should first satisfy my lords that this entire procedure has been followed. Otherwise, my lord, as per the act also, this has got no validity, irrespective of the disclaimer, my lord, at page 144 of the stay application. So this is my first limb of submission.
Right.
Second limb of submission, my lord, apropos the prayer of my learned friend that during the pendency of the appeal, my lord, he should be given the an opportunity by the court to, my lord, run the business.
Hmm.
On that also, my lord, Shorai license is required. And if they do not have any Shorai license, then also, my lord, in terms of Shorai Act, my lord, if your lordship may kindly have a look to, my lord, section 5.
Yes.
Lodgers, etc., not to be received in Shorais until registered. After
Right.
1 month after the giving of such notice to register, as by this act provided, the keeper of any Shorai or any other person shall not receive any lodger or allow any person, cattle, etc., etc., to halt or be placed in such Shorai unless the same, until the same, and the name and residence of the keeper thereof shall have been registered by this act provided. So this is the primary requirement to run a Shorai. Now, please have a look to the two orders which have been passed by the Honorable Court, which are under challenge. In respect of the first order, but the first one is 21st of August.
Yes.
First paragraph says, this license was cancelled. Please take the second paragraph. Petitioner's allegation is that without license, the lodge is being run by so and so. Then the third paragraph is important. The police authority has filed a report stating that so and so has not filed any report in the prescribed form stating the details of the daily customers and the boarders at the said guest house regularly before the OC so and so. So, but this is a requirement under the Shorais Act. He has to comply with those. Therefore, today, we stand at a situation. Number one, the certificate of enlistment, which is being relied at page 144, is a suspect document. As per municipality. Number two, according to me, provisions of section 144 has not been complied with. I'm sorry, 141 has not been complied with, because my learned friend's client has not shown that they had applied for provisional given, all certificates, statutory clearances have been obtained, and then this permanent has been given. This is the second point. Third is, the other statutory clearances are not there. And fourth is, even he has violated the Shorai Act as appears. I don't have a copy of the report, whatever is there, noted in the order. I go by that. The police has also said that no details of the has been given.
Right.
And kindly apropos this, only one document, page 163 of the stay application.
Yes.
This is the Shorai license application with Deputy Commissioner on 21st of August 2023.
Right.
And subject to correction, it has not yet been. Yes, we have given our objection subject to correction, but I think he doesn't have a Shorai license as of date.
Right. Yes.
But these are my very
Mr. Shah, you are appearing for whom? Mr. Raja Shah?
I beg to appeal for the Siliguri Development Authority, but we are here not the license giving authority. The municipal corporation is the license giving authority. So
Right.
in fact, there is no strong role of
Right. So let us hear Mr. Ghosh on reply. Yes.
My only one submission is that Mr. Ghosh's client ought to have waited for the commissioner's order at the commissioner, otherwise it will be found him eligible for an access. Then he would have generated this document from the portal.
Right.
But before the commissioner comes to a conclusion,
You should shut out the procedure. I mean, it should not be done like this. How can you permit? It's your portal. This should not be permitted to be done. Oh, yes, you are municipal. Right. Yes, Mr. Ghosh.
Milord 163, which has been shown by Mr. Dotto, Milord, is my application for renewal of the Shorai license.
He says you don't have a Shorai license as of now.
As on date, I don't have. But
So therefore, you cannot run a lodge.
Milord, kindly sees, Milord, page 147 to 162.
Hmm.
Milord, those are all my, Milord, the details which are required to be submitted before the.
Mr. Ghosh, it would be premature to grant a stay. We'll direct affidavits to be filed and direct the appeal along with the application. But stay, we can't grant it this
Even
stage.
assuming at the worst case, I don't have a Sarai's license.
Yes.
Kindly sees the consequences, 14, section 14 of that.
But you have nothing. You have been taking time for regarding the direction of Justice Rao.
That's allegation. That's allegation. Allegation. All documents are with them. How many times since 1718 I'm submitting the documents. It's recorded
Yes.
in the order.
Section 14.
14. Penalty for infringing act or regulations. But I'm running this without a Sarai license. Even then, he shall every such offense liable on conviction before any magistrate a penalty not exceeding 20 rupees and to a further penalty not exceeding 1 rupee a day. Now, the next provision is very important. Conviction for third offense to disqualify persons from keeping Sarai. So if there is a third violation on conviction on the ground that I don't have a Sarai license, my establishment can be closed. Not before that.
But as of date, you don't even have a license as contempt.
I did have a license. It
You
has
did
not
have a
been
license,
at
but
best.
we can at best direct the municipality to give a hearing and conclude it within a week, as you said.
In that event,
Then we will not dispose of the stay application.
in that event, what I will pray for, the entire premises consists of a residential portion also in the top floor, third floor. Only that much of portion be allowed to be operated.
Operated means
The guest house has been shut down. The
Yes.
premises comprises.
there is no injunction regarding that. You have only been directed not to run a guest house.
Shut down the entire establishment, including the entire premises. I mean, kindly see.
For the time being, Mr. Ghosh, you may surreptitiously run it.
Kindly sees, good, bad, indifferent, in violation of law or not, the establishment was running. As on the date of the order was passed.
True, but it was running illegally without a license.
That is a prima facie finding.
No, Justice Rao's order is there. That's an
Yes.
admitted position.
Yes.
Unless that exercise is complete, you don't have a license. It stands in the name of dead persons. As of today also.
Yes.
Whoever is responsible for the delay, Mr. Ghosh. But
Now,
you cannot operate without a license.
without creating any opportunity, any equity in favor of the.
No,
since it
running
was
a lodge without creating an equality, the learned trial judge was right.
And then
It's very risky.
in that event, kindly allow.
We can direct the municipality to give you hearing, both of you, Mr. Datta's client and you, hearing. Within a week, they'll dispose of that and file a report on the next returnable date. We shall put it on the second week of the next circuit, so that that report can be placed, and in that context, this has to be considered. If this exercise is done in the meantime, the Sarai and the other aspects, you will get a new lease of life to that. You can argue those. I will record the arguments, but yes.
Kindly allow me to operate at least open
For
the
this 2
residential
weeks,
portion.
no.
Like
Residential portion, in the garb of that, Mr. Ghosh, there is nothing to prevent you from operating there also, your lodge there also. There is no restriction. There will be no restriction. There has to be a constant vigil, which is not possible.
Records that.
No.
There will be no commercial activities except the residential portion of the
For
premises.
2 weeks, no.
Be allowed to be.
No, Mr. Ghosh. The present application for
Milord,
stay.
may I take your lordship's leave, Milord?
Yes.
May I have your lordship's permission to Milord?
Yes,
Leave, Milord.
absolutely. Yes.
I'm grateful.
The present stay application has been filed in connection with an appeal which has been preferred against 2 successive orders dated August 21, 2023 and August 22, 2023, passed in WPA 704 of 2023. Full stop, next para. By the first order, the police was directed to close the concerned guest house, which was being run by the present appellant, and to report back the matter the next day, full stop. In the next order, it was recorded that a report had been submitted. Full stop. The learned trial judge further went on to observe that the guest house shall not be opened until further order is given by the writ court. Full stop, next para. Learned counsel for the petitioner argues that the premise of the impugned orders was that the license for running the petitioner's boarding house was given in the name of dead persons. Full stop. However, it is argued that there were several previous rounds of litigation comma, which ultimately culminated in an order of
Milord, if I may interrupt, Milord, I'm sorry, Milord. If I may just interrupt.
yes.
Milord, in terms of Milord's observations, Milord can dispose of the appeal. Once for all, because Milord, I'll have the opportunity, if directing the municipal authority, Milord, to decide it, Milord, dispose it of. Milord, then Milord, I will have the opportunity to, Milord, I have to move a vacating application before the appropriate single bench. Otherwise, this will serve no purpose.
Well, I'll dismiss your appeal. We'll dismiss your appeal, but give you that liberty, and then the
Yes,
other.
and directs the SMC to
Very well.
conclude the exercise.
Very
That's all.
Justice Rao's order is at which page?
Milord, Page 29, Milord.
20. কোনখানটা ছাড়লাম সুদেশ? হ্যাঁ, right. Culminated in an order dated June 8, 2023, passed by a learned single judge in WPA 1196 of 2021. Full stop. In the said order, comma, it was observed, comma, inter alia by the learned single judge that admittedly on March 31, 2020, the Siliguri Municipal Corporation had issued license in the joint name of Nomita Saha, comma, Surjo Saha, comma, Subodh Saha, and Uttam Saha, but not in the name of Sanjeev Saha, comma, who is one of the appellants, though Sanjeev Saha had made an application for grant of license in terms of the deed of partnership dated April 1, 2017. Full stop. The said deed of partnership, comma,
Constituted deed of partnership.
no, that was the recording.
Oh.
The said deed of partnership, comma, apparently, comma, was a deed of reconstitution of the partnership, whereby the present appellants became the partners of the firm. Full stop. Next para, the learned single judge went on to observe that Sanjeev Saha, comma, who was one of the partners, had applied for grant of license, but the corporation in a routine manner had issued the license in the name of 4 persons named therein without considering the application filed by the petitioners, and as such, it cannot be said that only the petitioners are responsible for the license issued by the corporation in the name of a dead person. Full stop. In such view of the matter, comma, the order impugned before the learned single judge, comma, whereby the license was cancelled by the, whereby the license was cancelled, comma, was set aside. Full stop. The commissioner, comma, Siliguri Municipal Corporation was directed to consider the case of the petitioners afresh in terms of the application filed by Sanjeev Saha on the dates as mentioned therein. Full stop. Next para. The said exercise has not yet been completed, comma, it is argued, comma, although all the relevant papers are lying with the Siliguri Municipal Corporation. Full stop. It is argued that such aspect of the matter was never considered by the learned single judge while passing the impugned order. Full stop. As of today, comma, it is argued that the petitioner have been submitting the relevant documents regarding the running of the boarding lodge to the police authorities. Full stop. It is further contended that a valid license is subsisting in the name of the petitioners, comma, annexed at page 144 as well as 145 of the present application. Full stop. Next para. Learned senior counsel appearing for the writ petitioner in the court below, comma, one of the respondents herein, comma, argues that the present appellants do not have a Sorai license and other requisite documents for the purpose of running a boarding house. Full stop. It is further alleged that the documents annexed at pages 144 and 145 of the present stay application pertain to a different address. Full stop. Moreover, comma, it is argued that the same is an auto-generated document having no evidentiary value. Full stop. Next para. Learned counsel appearing for the Siliguri Municipal Corporation submits that the system of the concerned web portal, comma, which is maintained by the state government, comma, is that a permanent certificate of enlistment is auto-generated as and when an application for the same is made. Full stop. However, comma, he relies on the disclaimer at the bottom of the said certificate, which shows that the document is auto-generated as per data submitted by the applicant in online procedure, and the authority may verify the documents / credentials from the CE holder, comma, if so deemed fit. Full stop. It is further argued that the appellants themselves had obtained time for filing relevant documents in the hearing before the Siliguri Municipal Corporation, and comma, as such, comma, it is not the fault of the corporation that the hearing could not be concluded pursuant to the direction of the learned single judge. Full stop. Next para. Upon hearing learned counsel for the parties, comma, we are of the opinion that
in page number 163, that was also argued by the senior counsel that it is a fact that they are not having a SORAI license today.
yes, we have recorded that he has taken a point that no SORAI license has been. Upon hearing learned counsel for the parties, comma, we are of the opinion that as of today, comma, the last prevailing order operating in the field, comma, apart from the impugned order, comma, is that dated June 8, 2023, passed by the learned single judge in WPA 1196 of 2021. Full stop. In terms of the said order, comma, the commissioner, comma, Siliguri Municipal Corporation was to complete the process of deciding on the application pending at the behest of the present appellants, comma, for grant of license to the appellants. Full stop. Next para. Ideally, comma, the said process ought to have been completed by now. Full stop. However, comma, there is allegation and counter allegation between the corporation and the appellants as regards the reason for such delay. Full stop. Be that as it may, comma, the purpose of justice would suffice if the corporation gives a hearing to the appellants and the original writ petitioners and decides the said issue at the earliest. Full stop. Upon a fruition, FRUITION, fruition being arrived at on such count, comma, it would be open to the present appellants to make appropriate prayers for running the lodge before the writ court. Full stop. Next para. Insofar as the arguments regarding the appellants not being in possession of any SORAI license, comma, we find that although the appellant's application for renewal of SORAI license is pending, comma, the appellants are justified in arguing that the penalty for contravention of such SORAI license, comma, as per the SORAI's SARAIS, SORAI's Act, comma, 1867, is merely imposition of penalty, full stop, only upon 3 convictions on such count, comma, the persons concerned would be disqualified from keeping SORAIs, full stop. Hence, comma, mere pendency of the appellant's application for SORAI license may not be a bar to the appellants running the lodge, full stop. The predicament here is that the learned single judge, comma, with the order dated June 8, 2023, comma, had set aside the cancellation of license issued in the name of the deceased partners of the partnership firm, comma, who are the erstwhile partners, comma, but the hearing on the issuance of fresh license has not yet been concluded, full stop. Hence, comma, as of today, comma, the situation is that the cancellation of the previous license in the name of the dead persons is not there, whereas the appellants do not have a fresh license to run the lodge, full stop. As observed earlier, comma, the said predicament can be removed by conclusion of hearing and the municipal corporation taking a decision on such count, full stop. However, comma, we do not find any infirmity on the face of the order impugned herein, comma, since the learned single judge was prima facie justified in stopping the running of the lodge, comma, as the now existing license of the said lodge stands in the name of dead persons, and no fresh license has yet been issued to the appellants. Full stop. In such view of the matter, comma, on consent of parties, comma, the writ petition along with the connected application are being disposed of. Full stop. Hence, comma, MAT 151 of 2023 along with Can 1 of 2023 are disposed of without interfering with the impugned orders. Full stop. However, comma, the Siliguri Municipal Corporation shall give a fresh opportunity of hearing to both the appellants and the writ petitioners in the connected writ petition and decide on the pending application of the appellants for issuance of a license in the name of the reconstituted partnership firm and the present appellants. Such exercise, comma, it is expected, comma, shall be concluded within a fortnight. We are giving them a fortnight. Within a fortnight from date. Full stop. A report regarding the outcome of the same shall be placed before the learned single judge, who will take up the writ petition next on the next returnable date. Full stop. Next para. Liberty is granted to the present appellants to apply before the concerned learned single judge who takes up the writ petition for hearing, comma, praying for an order of modification of the orders which are impugned herein and for running the said lodge, comma, in view of the changed circumstances, comma, which will arise upon the Siliguri Municipal Corporation deciding on the pending application of the appellants. Full stop. Next para. It is expected that the writ petition will be disposed of at the earliest. Full stop. The writ petition be placed before the concerned learned single judge having determination to take up the matter on the in the second week of the upcoming circuit circuit of Jalpaiguri. Thank you.
Just one line, liberty.
May I just say one thing?
আচ্ছা, প্রথমেই একটা করে দেবেন, liberty is granted to the appellants to add the omitted parties as per prayer of learned counsel for the appellants during the course of the day.
And service also, my lord, the added parties.
Yes.
Service has been made on the state, Mr. Shah.
Not statement, I am appearing for the Siliguri Jalpaiguri Development Authority. I have also been.
You take copies from your learned friends.
I will, Millard. I'll serve.
May I just add one thing, Lord?
Yes, Mr. Chatterjee.
May I just
add quickly, Mr. Chatterjee.
At the certificate at page 144 will abide by, for certificate of enlistment would abide by the result of the hearing, because if the hearing goes against them, this 144 turns to be nullity.
No,
and it has to be
that will not abide by the hearing, Mr. Chatterjee, because that was pursuant to a previous order of a different court. That will not abide by the hearing. Why should it? Your ground was that they don't have a certificate. No, Mr. Chatterjee, you're mixing up things. Yes, next.
Grateful, Lord.
Thank you. 15.
Lordship, in item number 15, Lordship, Mr. Ujjal Rai is appearing on behalf of the appellant, Lordship. Lordship, he could not come to the court today, Lordship. I was humbly praying for not today, Lordship.
Yes, Mr. Ghosh, praying for time, appellant.
Yes, Millard. 15, Millard, yes.
Very good. On the prayer of the appellant, the matter is adjourned till next circuit.
Grateful, Lordship.
Next circuit.
Grateful.
Yes. Thank you. Yes, next. Yes, Mr.
Lords, I am for the appellant, my lords.
Right.
In this matter, my lordship, I was served with a show cause notice on 1/10/2020 for a period, my lords, pertaining to 2015-2016. Lords, which happens to be, my lords, 5 years RC backward. So I said that because of the corona pandemic and everything, I am not in a position to attend the virtual hearing or to submit any document because I am not that tech savvy and I will not be able to share a document with the revenue authorities. Now, the revenue authorities, they have passed an order challenging which I came before the writ court. Not the order impugned, is the order passed by the writ court. The writ court, only on the ground of limitation, has dismissed my writ petition.
What was the delay?
The delay, the writ court was of the opinion, that even after the passing of the order, there was considerable time because of which the writ. Now, my contention, is that a taxation without a proper representation.
No, Mr. There were other findings also at page 4. That the petitioner filed a reply to the show cause notice nearly 10 months after the same was issued. Even at the adjudication stage, repeated opportunities were granted to the petitioner.
These are all virtual opportunities.
But Mr. Mishra, there is no scope of interference with this order. The discretion was exercised by the single judge.
If I am allowed to submit on merits, the revenue does not get prejudiced. I only want an opportunity to present my documents because I say that because of a government incentive scheme, I am not entitled to the tax that they have demanded against me.
Yes, you are for the authorities.
My lords, actually, the senior is not in Calcutta for medical treatment.
Who is your senior?
Ratan Bhatt.
But Mr. Mishra, stay won't help you. I mean, what is the meaning of stay? Your writ petition was dismissed. Stay of that.
Then what will happen because they will proceed with the demand notice against me.
What is your interim prayer in the application? Let us see.
That is the prayer in my CAN application.
Impugned order, you have asked for a stay of that. You have asked for a stay of the impugned order. It does not mean anything. But the learned single judge, Mr. held several, I mean, so many findings are there. Repeated opportunities were, we are not inclined to interfere with this order.
The only thing is, if I am given an opportunity to produce my documents, then
Writ court exercise discretion. Intra-court appeal, we are more cautious, Mr. Mishra. If this was an original writ petition, we could have considered. Yes, maybe we could have taken a different view. But merely because a different view is possible, we cannot interfere with intra-court in intra-court appeals. Because reasons were given, sufficient reasons were given.
That's all I want today is fairness. I want to deposit the tax if at all it is due.
For that, you also had to be fair. No, you were bypassing the authorities for time and again. I mean.
No.
Even after the lockdown period.
There are judgments to effect that wherein the inception and the conclusion of the taxation proceeding has happened during the corona pandemic. Then more opportunities have been granted. This is the case here.
No, here it was concluded during the corona.
During the corona period.
Oh.
Otherwise, I wouldn't have said that.
Achha. No, the order which you impugned in the writ petition, that was passed when?
No, that was passed on 26/8/2021. Until February 28, 2022, even otherwise a stay was there by the Supreme Court because of the corona pandemic.
Admit করে তাহলে state তো scope নেই এখানে. But you have not made a proper prayer, Mr.
Milords, what can be done, Milords, is that this let a fresh opportunity be given to me.
No, then you'll have to hear out the appeal. He's asking for time in the appeal. We are hearing the application only. If they were present, we could have heard out the.
Let they stay upon the order passed, then we'll try our.
That would not mean anything. There is a question of grant of any stay to that. Your writ petition is revived then.
Then let's kindly admit the opinions.
You should be ready in the matter.
Well, actually, I don't have to use it.
Why don't you have? You shouldn't be in the panel. Are you in the panel at all?
Yeah, I'm.
So your name should be expunged from the panel if you're not ready with a brief. Why should you be so incompetent in you are appearing before a bench of the High Court without a brief? You're on the panel. If you are the learned junior of the chamber of that advocate, I could have understood. That's the thing. We find from the impugned order that a prima facie case has been made out for admission of the appeal, inasmuch as the entire action of the authorities, which was challenged in the writ petition, happened during the corona pandemic, full stop, as such, comma, a lenient view might have been taken with regard to the petitioner's alleged laches in seeking adjournments before the authorities. Full stop, next para. Hence, let the appeal be heard on merits. Full stop. Next para. Insofar as the prayer for stay is concerned, comma, the grant of stay would not inure to the benefit of either party, comma, since by the impugned order the writ petition itself was dismissed. Full stop. However, comma, whatever action is taken pursuant to the decision of the authorities which was impugned in the writ petition shall abide by the outcome of the appeal. Full stop. The appellant shall prepare requisite number of paper books within 8 weeks.
That might not be required because even in the before the writ court there was no affidavit in opposition or anything.
Oh, acha, great. Thale,
Because this means in limine.
very well. In view of all the documents being annexed to the papers filed by the appellant, comma, the filing of paper books and calling for lower court records is dispensed with. Full stop. In view of appearance of the respondents through counsel, comma, service is also dispensed with. Full stop. The appeal be placed before the appropriate bench in the next circuit for hearing. IA Can 1 of 2023 is disposed of with the above observations.
I'm sorry.
We'll take up the single judge matters now. Yes. My learned brother has single in the single bench. Apni ja bolben. Tomorrow we'll continue because there is no tomorrow will
Some precedents be given to the matter. At least 2
mandamus.
There is out of 10 days, 2 days for the civilians is justified.
How many কত পর্যন্ত হলো?
My lord.
16.
কত? 16 16 তাহলে কালকে প্রথমে এটাই কন্টিনিউ করি তাহলে কালকে এই অর্ডারই রেখো
My lord, may I submit item number 19, my lord? It was mentioned by me yesterday. My lord had pleased to direct the matter will come up on Friday. Accordingly, I had
when you take up mention tomorrow. Yes.
Grateful
We'll continue with this tomorrow.
Grateful, man.
Okay, এই অর্ডারই থাকবে I'll take the contempt application. Yes.
Grateful.
Yes.
Please, my lord.
What is the contempt about?
Lord, I am appearing for the alleged contender.
Yes, Mr. Shen. Right.
My lord, may I indicate, even though I was not required to serve, my lord, since I'm seeking urgent orders so as to not aggravate the contempt, I served on all the respondents.
I would like to use an affidavit, my lord, subject to
My
your.
lord,
Yes, let us hear what the contempt is. Yes.
That on 18th August 2023,
Hmm.
Lordship took up this matter. This concerns the Calcutta Stock Exchange.
Hmm.
There was an agreement with the National Stock Exchange to use the trading terminal of National Stock Exchange so that the exchange could remain functional. Lordship considered the matter. My lord, Lordship took up the matter out of turn, considering the urgency, because they'd given a termination notice without complying with the agreement, which they themselves had treated to be valid. And thereafter, the trading would stop. We mentioned the matter on an urgent basis. Lordship was pleased to allow that. My lord, straight away, may I go to the order passed by your Lordship that starts at page 27. That I will place only very limited portions of the order which is relevant for the contempt. My lord, page 27. The first page, may I just read out this portion, my lord? The matter is being taken up out of turn on the ground of extreme urgency pleaded by the petitioners. It is submitted that the transactions of the Calcutta Stock Exchange shall come to a standstill from tomorrow in the event no interim order is passed. My lord, this is the premise. Thereafter, Lordship, may I come straight away to page 34. Initially, Lordship may recall a submission was made that the agreement was not continuing. Thereafter, Lordship, on being further queried by my lords, a submission was made by my learned senior friend, Mr. Jishnu Shah, that no, they treated the agreement to be continuing. In light of the submission, this is what Lordship held. My lord, page 34, the last paragraph. Insofar as the merits of the allegations are concerned, on a prima facie footing, for the purpose of deciding the issuance of an interim relief, the primary impediment in the way of the petitioners is that the agreement between the NSE and the petitioners expired lastly in the year 2021, after having initially expired in 2016, and thereafter being automatically extended till 2021, after which it was never renewed. However, from the conduct of the NSE itself, it transpires that NSE as well as the petitioners treated the contract to have been renewed and to be continuing one even after 2021. Apart from the parties acting in terms of the clauses of the agreement, the impugned notice itself clearly shows that NSE acted on the premise that the agreement was still valid. In fact, the notice itself was stated to be issued within the contemplation of 23B1 of the agreement between the parties. Hence, it is deemed that the agreement persisted between the petitioners and NSE for all practical purposes, inasmuch as NSE and petitioners are concerned. Thereafter, Lordship comes to a finding that there was a valid agreement between the parties. My lord, may I next go to page 36, Lordship? I'll be very short, Lordship. I know Lordship is constrained for time. My lord, the second paragraph at page 36.
Yes.
Clause 23 concerned giving a notice first to cure breach, a 30 days notice to cure breach. If I do not cure, they terminate. That was not done in that case because that notice itself was a termination notice without giving me any chance to cure the breach. Lordship, I am not reading the entire paragraph, Lordship. Thereafter, Lordship, page 37, the second paragraph. Lordship held that the issuance of 30 days was a prerequisite in the form of NSE giving such opportunity to the petitioners to rectify. This was not done. Therefore, page 39, Lordship, may I come to now? The second paragraph. As such, on the prima facie premise, the impugned notice dated such and such is non-compliant to the provisions of the agreement between NSE and the petitioners themselves, as well as arbitrary in nature. Then, my lord, one paragraph later, in view of such matters, petitioners have made out sufficient strong prima facie case for the writ petition to be heard of on merits. Thereafter, Lordship granted a stay on that impugned notice till disposal of the writ petition. Now, Lordship, this is the most important part of the order, page 39, the last paragraph. It is made clear that nothing in this order shall preclude the NSE from complying duly with the provisions of clause 23 of the agreement between NSE and the petitioners hereafter, and issue a fresh notice for termination in accordance with the said clause. Even though Lordship granted us a stay, a specific liberty was given to NSE to comply with section 23, which is giving me a 30 days notice
to cure breach. Now, Lordship, what happened thereafter, my Lord, on the same date, we served, we intimated the fact that the order was passed, my Lord, that's at page 41 on 18th August itself.
Yes.
Now, Lordship, what happened? Well, between 18th August 2023 and 11th September 2023, we continued trading. There has been a total trading of about 5,700 crores. In excess of 5,700 crores, well, as this will be borne out from the records of the stock exchange. Then, Lordship, what happened? Lordship now kindly comes to page 43.
Yes.
Lordship, a very short, I'll explain, Lordship, what is the sum and substance of this notice. This email is issued by the National Stock Exchange at 10:44 on 11th September, 10:44 p.m. at night, saying that from this very moment, all trading will stop. All trading will stop, and from 12th September early morning, there is complete cessation. There were pending trades of several hundred crores, all stuck. The entire stock exchange came to a standstill. Now, Lordship, may I place the notice?
Along with the contempt application, you should have taken out a supplementary affidavit and do it on Monday. I'll keep it on next Monday. In contempt, you cannot go further.
That is, my Lord, my specific prayer is.
They have filed a separate application and they have moved it.
No, Lordship, may I indicate that?
Acha, Mr. Sen, yes.
My Lord, may I?
Let us say, Mr. Sarkar, on that. Yes, I get your point, Mr. Sen. Yes.
Now, my Lord, as far as this notice is concerned, for the quashing of this notice, separately, Lordship, we filed a can. However, what has the issuance of this notice, it has essentially caused a complete blatant contempt on the part of
Mr. Sarkar, our hands are tied in contempt.
Lordship. Now, I'll try and
we can consider taking up the application immediately when I sit in the principal bench. But this I'll have to direct affidavit.
My Lord, may I make one submission?
Yes.
My Lord, especially in a situation like this, where there has been
in contempt.
In contempt.
No.
What order can my Lord pass?
What order can I pass?
Lordship, this
Yes.
Lordship is
give the citation for Mr. Sen.
2007-11 SCC, page 374. I'm just repeating again for Mr. Sen's benefit. It's 2007, volume 11, SCC, page 374. My Lord, in such a situation where there's been a contempt of this nature, where the respondent violates the interim order passed against it, it cannot enjoy the fruits of that interim order. In such a case, Lordship, in contempt jurisdiction, the appropriate order could be subject to what my Lord thinks just, can direct a status quo ante to be maintained immediately, the situation prevailing immediately preceding the issuance of the 11th September email at night. Lordship, may I straight away come to paragraph 27? My Lord, that is at page 386 of the report.
Yes.
Well, may I just place this paragraph?
Please.
Even assuming that there was any scope for bona fide misunderstanding on the part of the respondents, once it was found that the respondent had disobeyed the specific order passed earlier by the court, the High Court should have directed the contemners to undo the wrong committed by them, which was done in clear breach of the order of the court by restoring the status quo ante by cancelling the lottery wrongfully held by them. The learned judge found that the respondent contemners had held the lottery in violation of the court's order, and the results of the said lottery should not be permitted to take effect and should be treated as unlawful and invalid for the purpose of grant of license. The learned single judge, for the purpose of upholding the majesty of law and the sanctity of the solemn order of the court of law, which cannot be violated by the executive authority either deliberately or unwittingly, should have set aside the lottery held and should not have allowed the respondents to gain a wrongful advantage thereby. Lordship, I'm turning the page, paragraph 28. in our opinion, a party to the litigation cannot be allowed to take an unfair advantage by committing breach of an interim order and escape the consequences thereof by pleading misunderstanding and thereafter retaining the said advantage gained in breach of the order of the court and the wrong perpetrated by the respondent contemners in contumacious disregard of the order of the High Court should not be permitted to hold good. In our opinion, the impugned order passed by the High Court is not sustainable in law and should not be allowed to operate as precedent, etc. Lordship. Now, this follows, this judgment of the Supreme Court approves a decision of the full bench of the Madras High Court passed in Lordship a case of Vidyacharan Shukla, where this sort of an order of interim order directing status quo ante was passed by the court in exercise of contempt jurisdiction, because otherwise the whole purpose of the contempt would not be served. In this case, Lordship, what has happened, when there's trade in excess of 5,700 crore in less than a month, Lordship can well gauge the quantum of trade being conducted daily. The trade which was already being conducted has been seized in the middle of the process. That could not be allowed to be completed even. Lordship, therefore, that's the only interim relief, Lordship, I pray for, because the only reason is, that is the reason, Lordship, I've served the respondents and I've come up in contempt on the very first day. Otherwise, Lordship, there is total chaos. The entire stock exchange has come to a standstill. It defeats the purpose and the specific directions given by your Lordship.
What is the page number of that email again, Mr. Shorkar?
My Lord, page 43. Now, my Lord, if I may place that, one or two questions are raised, that also I can answer.
11th September or 14th September?
My Lord, that is the forwarded text from the advocate's Lordship. Will see the forwarded message from Pradhanya Pinto. My Lord will see the date, September 11, 10:44 p.m. Now, Lordship will see what has been held, what has been stated in the notice. Clause 2, will I place the notice, Lordship, if Lordship?
The relevant portion only.
Relevant clause, paragraph 2 of the notice, Lordship.
Yes.
Clause 23 of the agreement provided that the agreement shall remain on force. Now, the last sentence of paragraph 2, no agreement for renewal of the agreement has been executed between NSE and the agreement has ceased to be in force. This is in complete violation of their own submissions before your Lordship. It is in complete violation of what has been held by your Lordship prima facie on the basis of NSE's own submissions. Thankfully, Lordship, now we have everything on YouTube. Lordship may go back. We can show your Lordship that was the specific submission made. That it is that Mr. Shah said that we specifically treated this agreement to be continuing. And therefore, the timestamp has also been given in the contempt petition, Lordship, for Lordship's benefit. But therefore, thereafter, Lordship, clause, paragraph 3 of the email, the agreement was a private contract between the parties. That is also not in consonance with what your Lordship has held, because this trading is enabled by a specific statutory provision in the Securities Contract Regulation Act, which is section 13 capital A of that act. That enables such an agreement to be made, and that agreement is entered into in public interest, in the interest of trade, in the interest of investors. My Lord, that all that has been undone, my Lord, the entire purpose of Lordship's order has been undone. Thereafter, Lordship kindly turns the page to page 44. Paragraph 4, Lordship, may I place? The agreement and the continuation of the arrangement after September 28 pursuant to mutual conduct was a commercial understanding. NSE is not interested in continuing with the agreement. Paragraph 5. We note that as of date, the members of CSE are not trading on the NSE platform. Well, this is contrary to their own records. Well, 5,975 crore, I'm told that is the total quantum of trading. Well, thereafter, we also note that pursuant to a notice dated 9 July 2023, CSE has already informed its members to close any open positions and settle their pay-in and payout obligation. In fact, based on our records, only a few clients of CSE's members currently have open contract. This is also, Lordship, completely...
Let us hear Mr. Shen.
Lordship.
Yes, Mr. Shen.
Lord, the first point is that, Lord, there is a substantive application filed in the writ petition, which was moved before, my Lord, Justice Rajeshri Bharadwaj taking up urgent matters, and that matter has been fixed for hearing tomorrow. That is a substantive application praying for reliefs in respect of the subsequent communication. That is one aspect of the matter. Now, here in contempt, Lord, they first have to prima facie justify that that is an act of contempt. I would like to use an affidavit to show that I have not deliberately and willfully violated the directions of your lordship. And as regards the question of grant of substantive interim order at the first day, when I have not yet got a chance to explain my position whether or not I have committed violation of the order, that is not the precedent that has been cited by my learned friend. Because if your lordship sees, once the judgment of 2007 volume 11 SCC,
yes, there the contempt application had been dismissed substantially.
and contempt application has been dismissed on merit, holding that the government officers have taken a bona fide on their bona fide understanding, have not done this or have not complied with the order.
Mr. Shane, apart from that, what is prima facie? What is your stand on this?
My
It is a blatant, apparently it's a blatant contempt.
No, but Lord, if your lordship kindly sees, with
Yes.
respect, if your lordship's order,
Yes.
the lordship has set aside a termination notice on the grounds which are mentioned there, that it has not been done in
No, it was stayed. It was stayed.
termination notice was stayed. I'm sorry. It was
Yes,
stayed.
yes. Right.
Now page 39, last paragraph, your lordship has given me a right to proceed, preclude the NSC from complying duly with the provision of clause 23 and issue a fresh notice for termination. But if a subsequent action has been taken in terms of the express liberty which is reserved by an order, then kindly consider, my lord, whether it would amount to violation of the order or it would give a fresh cause of action for challenging the subsequent notice which I may have issued. Where, in my great respectful submission, my lord, where is my violation? Which part of the order I have violated? It is that notice has been stayed. I have not done any action on the basis of that notice or overlooking the stay granted of that notice. Thereafter, there is an express liberty granted to me. And I have taken an action in terms of that liberty.
Yes.
Whether that action is right or wrong, your lordship will consider whether it will form the subject matter of an adjudication in a contempt proceeding or a separate substantive proceeding will lie, which they have already invoked. It's not that they have not invoked. So in this manner, my lord, they should not be allowed to take a chance. I could have understood they have come only with a contempt application and pressing hard for an interim order. I would have resisted on the grounds available to me. Now they also knew of their inability to get a substantive order in a contempt application. So they have already invoked the appropriate jurisdiction and they have filed a substantive application.
They can not press that at any point of time, Mr. Shane.
They can. But
Although they have taken a chance, you have an arguable point there. They have taken a chance.
Even in this application,
yes,
when they are moving this application, there is no affidavit that they will not press that. So today, when your lordship is hearing the contempt application, there is already a substantive application on record on the board of the court, and which has been fixed for hearing tomorrow. So knowing well, my lord, that it is just trying to take a chance, my lord, which court I can go faster. They went to the other court today morning.
And is the matter fixed tomorrow, Mr. Shane? You are confident it will be taken up tomorrow?
That's what the order says, my lord.
Achha.
That the matter has been directed to be listed tomorrow. That is what the order
at 10:30. At 10:30, you are right.
10:30. So, my lord, and also another point, my lord, which may not be extremely relevant, but as a matter of information, that the appeal which has been filed against the order also. There is no, I am not saying that. I am only on
no, that is also there. That should be.
Yes, but I am only on the point, my lord, whether at the first day, without giving a chance to show whether there is any deliberate or willful violation, a substantive order.
A different set of advocates are appearing in that. There are a set of people who are appearing there.
My junior was there.
Bishop Justice Bharadwaj tomorrow?
No, Lordship, we were only doing that matter, but Lordship.
No, I was thinking of Mr. Sen. I'll take up this matter tomorrow then.
Malad, in that application, it has been clearly pleaded that because your Lordship was sitting here and there were logistical issues, we had to do something.
No,
and it was subject to that this contempt.
No, I'll wait for the fate of that. If that is not taken up tomorrow, then I'll take up.
Malad, the only Lordship I'll not press that application if need be, Lordship. However, because as I see it, Lordship, in my very humble submission.
One other aspect is there, Mr. Sarkar, as Mr. Sen tried to point out, that here,
Lordship,
there is whether there is a specific violation or there is a question of interpretation. I mean, you can say the letter and spirit has been violated in the sense that the observation was that nothing in this order shall preclude them from complying duly with the provisions of clause 23 of the agreement between the NSE and issue a fresh notice. Now the question is whether they have complied with that provision and issued the fresh notice. So why is it not a fresh cause of action for a separate writ or the challenge you have preferred?
Lordship, may I answer?
I mean, this is a question of interpretation.
Lordship, may I humbly submit? The question of interpretation, as Mr. Sen submits, cannot apply in this case because your Lordship has because Lordship has clearly held that clause 23 means a 30 days notice. In other words, Lordship, if I may substitute the word clause 23 with what is stated in clause 23, then your Lordship's order would read as they are not precluded from issuing a fresh 30 days notice to cure breach and thereafter terminate, because that is what your Lordship's finding is, qua clause 23. Malad, this has been done. This notice has come and this has been terminated, not even at a minute's notice. The notice says that from this very moment, the trading will cease. That is the violation, first violation, Lordship, and clear violation. Had it said that compliance of the provisions of the agreement was required, there could have been a question of interpretation. Lordship here held compliance with clause 23, which is a 30 days prior notice to cure breach. No such notice.
Let it pass. Yes, Ashwin.
Only one more thing, Malad.
Yes,
and Lordship, one last point, Malad, with respect to the interim order and the Supreme Court judgment which I cited, Malad, that relies on Vidyacharan Shukla, which was a case of granting an interim order giving status quo ante. May I just place it only since Mr. Sen mentioned?
Which portion?
Malad, this.
Give me the paragraph.
Lordship, kindly may I hand this over, Lordship, and show that this is relied on in that judgment, Lordship. Paragraph 52 of Vidyacharan Shukla.
No, show me where Vidyacharan has been referred to.
May I show that, Lordship, and then I'll just show that.
First from the Supreme Court judgment. Yes.
Lordship, I'll show the Supreme. Lordship, kindly.
But if it can be taken up tomorrow, Malad, I would have come a bit ready with the judgments on this.
Malad, kindly comes to page 319.
Come back tomorrow, Mr. Sarkar. Come back tomorrow. Come back tomorrow.
Let us also see, Malad, where
tomorrow, if it is not taken up, I'm confident it will not be taken up. I'll pass my orders. Let him come prepared tomorrow. I'll take it up at 3 tomorrow.
Lordship.
Very well,
at the outset, at the time of hearing, it is pointed out by learned counsel appearing for the alleged contender that apart from an appeal having been filed against the parent order, a similar application filed by the petitioners herein before a coordinate bench is pending and is due to be taken up tomorrow at 10:30. Full stop. Hence, it is submitted that the fate of the said application ought to be awaited. Full stop. Next para. Since learned counsel for the alleged contender has a point there, the matter is adjourned till tomorrow when it will be taken up at 3:10 tomorrow. Full stop. Learned counsel it is understood that in the event no substantive order is passed by the coordinate bench tomorrow morning, the contempt application will be taken up for consideration of passing interlocutory orders in connection with the contempt. Mr. Sen, please come prepared on this also.
Yes. Obliged.
Good. Let us come back tomorrow. These I'll keep on record, or you can keep with you.
Lordship, I'll place them.
You will be physically present tomorrow. That's why I asked you whether you have got another set there.
Lordship, no, we do not have, Lordship. I'll have to stay behind and we'll have to.
What will happen there? It will not happen.
This is
it will not happen, Mr. Sen, probably. Mr. Sarkar has got a clue, so now he'll never go back there.
Then my labor goes higher now. I will
No,
have
Mr. Shen, you have got a
Herculean
difficult
task.
hurdle to cross because apparently I'm minded against your client. And at
Yes,
least
I can
regarding
feel
grant of status quo ante till the, I mean, subject to what happens in the contempt ultimately and in the writ petition and in the appeal. Definitely, Mr. Shen, for that only I'm giving you time because technicality goes against Mr. Sarkar, but justice apparently goes in his favor for the time being. Let us come back tomorrow.
Yes, obliged.
Thanks.
Grateful Lordship for
কালকে
giving.
3:10 এরম ভাবে হ্যাঁ উনি তো এতে ওনারা এখানে থাকবেন
Well, I must be grateful Lordship for giving us this indulgence.
you
Grateful.
must be grateful to Mr. Bari who is abusing you probably in his mind.
I'll flee.
Yes. Yes, sir.
Well, in this matter,
My lord, I am appearing on behalf of the state.
As per your lordship's observations, I physically come for this case. Last Friday.
Yes, Mr. Agarwal, what do you say?
My lord, may I make a submission, my lord? In this matter, Mr. Bandopadhyay is leading me, my lord, and he
Yes.
wants to do this matter by physical appearance, my lord. Since he is in Parliament session, my lord, I have issued a letter to Mr. Bari yesterday that I shall pray for adjournment subject to my lord's approval, that it be taken up any day in the next.
Every time, my lord,
Mr. Agarwal, that specific ground was taken on the last occasion also when it was taken, but probably yesterday. And
my lord,
Mr.
in
Bari had no objection if it was taken up in this circuit. He made it very clear. But your prayer was that it would be taken up in the next circuit, to which Mr. Bari objected, for which it is being taken up today. That
My lord,
was the
I do
specific prayer made, that let it go to the next circuit.
Maybe,
which is-
well, maybe I do not know, but what I have been instructed by my learned senior, your lordship knows, my lord, when Mr. Bandopadhyay is
No,
engaged.
you are wanting, Mr. Agarwal, this to be heard when?
Any day, Monday after 24, because 24th there is a function in his
No,
house, my lord.
No, that you had to make an alternate arrangement because yesterday that was refused. Mr. Bari objected specifically to
My lord,
this
Mr.
being
Bari
relegated
is
to the
not
next
affected.
circuit.
Mr. Bari is not affected in any manner. This matter is not happened. Kindly see paragraph 4. He has no locus to file this application. Kindly see
Petitioner does not have any locus, Mr. Agarwal. The writ petitioner does not have any locus.
My lord, that is the specific point.
Mr. Bandopadhyay won't be proud of this subject.
Can
Yes,
you see
Mr.
my
Bari.
paragraph 4? He is not opposing.
What has happened
for
with
my
the-
No,
appointment.
let us hear Mr. Bari. Yes. Since there is an objection, Mr. Agarwal, I'll take up the matter. Yes.
My lord, only one
Lord,
submission.
I am
In that
appearing
case,
for
my
the
lord,
state in this
if
matter.
this, if my lord,
brief, I tell you, Lord.
Yes.
my lord, then
My
let it
lord-
be taken up on Friday, my lord, at least.
No, Friday, not Friday.
My lord, I am appearing for the state in this matter. I am being led by Mr. Rajoshi Datta.
Anyway, yes.
Petitioner is the approved assistant teacher of a.
My lord, before it, can I say that how it is not a, my lord, maintainable?
Mr. Agarwal, your prayer was specifically refused yesterday. It had been prayed on your behalf. Let it be taken up in the next circuit. Mr. Bari had objected. I specifically
It's all
refused.
right, my lord.
One
Let
day
it be
was given to you to get prepared in the matter. If you are not prepared, it's your problem.
My lord, let me make my initial submission that it is
My
not
lord, I am-
maintainable. On maintainability, may I make a submission?
Very well, you will get it.
My lord, I
Why
am
not
being led.
maintainable, Mr. Agarwal?
My lord, kindly come to
My
paragraph
lord, I am
4.
appearing
Let
for
him
the
start.
state.
Yes, why not maintainable, Mr. Agarwal?
Paragraph 4 of the writ petition, kindly come to
Paragraph
4 of
4,
the.
yes. Let us see
Yes.
paragraph.
Well, I will
This is
clarify
again the transfer order of
We'll
myself.
get an answer. We'll get a reply to that.
My lord, I am appearing for the state in this matter. I am being led by Mr. Rajoshi Datta.
Yes. So
My lord, if an adjournment can be granted for just for
refused,
today,
ma'am.
my lord.
Refused.
My lord, has your lordship got my lord paragraph 4?
Not yet. I'm trying to get it.
My lord, at page 5 of Mr.
Yes,
Bari's
obviously. I'm trying to find out a writ petition. So many. Yes, found it. Yes. Please, Mr.
My lord,
Agarwal.
I am reading it out, my lord, that it is
Yes, sir.
submitted. Your petitioner is not at all interested to oppose the action of the respondents for filling up the post of headmistress in the school in question. The grievance of the petitioner is against the prior respondent to manage to get the transfer order from the school service commissioner by ignoring provision of law. As such, your petitioner approached this honorable court, drawing attention to the illegally committed by the school service commission, transferring the prior respondent from such and such school to such a. This is not my. Now, my lord, who is he? He is the assistant headmaster. He says that my appointment he is not opposing. He is opposing only my appointment, my transfer order. But since I've been transferred from one place to this school, and where he is not at all claiming that he would be the headmaster. So, my lord, he cannot have any locus to challenge it. Now, my lord, second point is, well, this is not a public interest litigation that he will challenge and say that this is the illegal appointment. Thirdly, my lord, my third point is, my lord, that my transfer order has been issued according to me in terms of the relevant provisions of law. So, my lord,
no, that is on the merits. That is not on maintainability. So he has to deal with, Mr. Badi has to deal with maintainability on the ground that he has no locus standi.
My lord, there are only 2 points for maintainability. One, that he does not oppose, according to his own statement, that he is not opposing the appointment of the headmaster in the school. And there was no headmaster in the school at the relevant point of time. And I have already joined in terms of the Honorable Appeals Court order.
No, Mr. Agarwal, Mr. Badi's client is a teacher in that school. He is the assistant headmaster. Assistant headmaster. So you have joined, after transfer, you have joined as the headmaster in that school?
Yes, my lord.
Very well. Very well.
And my lord,
yes,
school is not opposing. It is only he being
Very
an assistant.
Mr. Agarwal, I get your point. Let me hear Mr. Badi on the maintainability first. Yes, Mr. Badi, how do you deal with the maintainability first? That was my question also yesterday, probably. I had made the same question to you probably yesterday.
But if your lordships kindly have a look to this order passed by the coordinator, while application for vacating interim order was filed.
This is being moved for the first time, or it was final? You did not get any interim order?
No.
What interim order?
Interim order was
what
not
interim order?
No interim order.
Mr. Agarwal, you have to let him argue. I mean, if you continue interjecting, I'll have to stop your microphone.
I am sorry, my lord.
Yes, Mr. Badi. Please come closer to the microphone so that they can hear you. Yes. Thank you.
I'm the assistant headmaster of the schools. And my lord, along with the president of the managing committee, when that lady, while he was, my lord, the assistant teacher of our schools, thrice she has been transferred. So, my lord, when she was discharging its duty as assistant teacher, she took leave for 1 year.
That was in a different school.
For different schools, and she participated in the selection process of headmistress. She became the headmistress of that particular school, suppose the A schools. After, my lord, joining as a headmistress, your lordship will be surprised to know, within a short period, it not covered 1 year, she made an application for transfer. Under the rules which is express illegal, division bench, 2 division bench, I will place before your lord.
First, you'll have to overcome your locus standi point. Yes. What is your locus standi?
Because of the fact, immediately, I'm the assistant headmaster. I have to work under the headmasters, under his guidance and approvals, at per statutory duty, I have to discharge my function. Now, I, along with the president of the managing committee, made an application before if your lordships kindly have a look, page 34. Page 34. This is the letter dated 8/11/2021. Your lordships got it?
34
Page
years.
34.
Yes.
Is similar. It is the sign by the president. Page 37. The lordships kindly have a look.
37. That's.
Page 37. It is the sign by the assistant headmaster come teacher in charge, along with the president of the managing committee, pointing out illegality, irregularity at a gallows. I pointed out before the president of the West Bengal Board of Secondary Education, before the chairman School Service Commission, before the principal secretary School Service Commission.
No, this was when? After she joined?
No, before that.
In a different school. When?
These present schools. That's why I was drawing attention.
No, I don't get it. You have challenged the transfer order to the present school. Hard transfer order to the present school.
Present.
After she was transferred, you have made these allegations.
No, before that.
Before she came even.
Before she that transfer order, before she joined this school, in which manner she proceeded, that's why I brought the attention of the authority. It cannot be. Everything is illegal. In a lien vacancy, she cannot, my lord, join others.
School is not objecting.
No, school is objecting. Nobody.
You are not the school.
Nobody. I along with the president. Now the school is under the administrator.
Managing committee is a respondent here.
Now the question is, locus.
Yes.
When the illegality at Gallo, my lord, if your lordships kindly have a look, the order passed by the coordinate bench while vacating interim order, your lordship was asking from the very beginning it was stayed. Thereafter, my lord, the page 20, your lordships, my lord, the order dated 20th December 2021, your lordships kindly have a look. Order dated they handed up. It is on the file possibly. No.
This was handed up by you.
My order dated 20th December 2021. Your lordship got it? Order passed by Justice Sarkar.
Just let me check. 20th December?
2021? It is
Must be here, must be here. No, got it also, yes. No, you can put a bundle touch. Yes.
Now your lordships kindly have a look. This point was there. This is an application for vacating interim order dated November 18, 2021. The interim order was continued. Subsequently, my lord,
What was interim order passed? Stay of that transfer.
Stay of that transfer.
Yes.
Passed by the coordinate bench of this court, staying the operation of the recommendation of the School Service Commission, order dated 29th October 2000, filed by Srimati Shanta Mandal. The application has been transferred from a Birpara Girls High School to Sri Guru Vidya Mandir. As the order of the stay was operating, the appointment letter has not been issued to the applicant. The applicant is the respondent number 12 to the writ petition. Mr. Bashu Learned, senior advocate, praised that the interim order so granted must be vacated as the petitioner, who is the teacher in charge of the Sri Guru Vidya Mandir, does not have any locus standi to move the writ petition in her personal capacity. Reliance has also been placed the decision of Manish Shobhat and such and such. According to Mr. Bashu, the petitioner is neither a contender for the post of headmistress nor any legal right of the petitioner has been infringed on account of the transfer. He praised that interim order be vacated and the writ petition has been dismissed on the ground of locus standi alone. Mr. Bashu submits that unless the petitioner had satisfied the court that the petitioner had a legal right to the post, the writ petition should not have been entertained at all in the first place. Mr. Bari Learned advocate appearing for the petitioner submits the writ court has ample power to allow the private individual to bring to the notice of the court illegalities that have been practiced by the state respondents and by the petitioner. According to Mr. Bari, the petitioner, being the teacher in charge of the Sri Guru Vidya Mandir, has a right to point out the irregularities in the transfer of the applicant and her appointment of Sri Guru Vidya Mandir. The applicant had joined her post as a headmistress of Birpara Girls High School upon obtaining a lien from Sri Guru Vidya Mandir, in which the writ petitioner is the teacher in charge. Without any permission from the school where the petitioner had a lien, the case for transfer could not be recommended. He further submits the rules provide that if a teacher does not accept the first offer of the transfer, then she cannot apply for transfer within a period of 2 years. He further relies the decision in a matter of Himani Parya versus State of West Bengal in Kannamba such and such in support of the contention that in any event, the applicant could not have asked for transfer before completing 2 years of the service as a headmistress of Birpara Girls High School. He next realized the decision Bimal Burman versus State of West Bengal, reported 2009, volume 2 CHN 442, where it has been decided the powers of the court under Article 2 of the Constitution of India as wide enough, and any persons in her personal capacity could invoke the jurisdiction of this court if the persons could show breach of mandatory statutory provision. It is also vehemently urged that the transfer application does not maintain any special ground for which the transfer was sought. That Patro submit on behalf of the School Service Commission that the state government approve the case of the transfer of the petition. The application is required to be heard on affidavits. As there are many disputed questions of fact, the court would require to decide the issue, including the location, the basis of the records, and ascertain whether the headmistress recommended for the school where the petitioner is working as a teacher in charge could get the transfer by flouting the law and the rules, where the such person has allegedly practiced fraud, was good for the welfare of the school where the petitioner is working, and whether the petitioner could file the application to protect the interest of the schools, or the matters are required to be decided once all the records are before the court. Under the such circumstances, keeping in point of locus open, let affidavit in opposition be filed within 4 weeks. Let reply thereto if any be listed within 2 weeks thereafter. Liberty to mention after expiry of the aforementioned mentioned period of the available circuit bench. The interim order already passed in the matter is extended for a period of 10 weeks. As the petitioner is already working as the headmistress of Birpara Girls High School, she doesn't suffer any prejudice. The petitioner is directed to serve a copy of the petition upon Mr. Sai in course of this week.
Who was, you are acting as the headmistress?
I am the assistant headmaster of the schools.
Yes.
Now, my lord, what has happened? Thereafter, my lord, time to time it is extended.
The petitioner is already working as the headmistress of Birpara. That's a different.
Thereafter, the checkered history is there.
So Birpara High School is this school, not your school.
My school is the Sri Guru Vidyamandir.
Oh, acha. She is petitioner means the
Birpara. Now, my lord, there are legal battles, several writ petitions, interim
Anyway,
order.
so she is the private respondent is appearing acting as
Birpara Girls High School. From there, now my lord, the interim order sometimes when due to non-service of the copy and non-appearance, interim order was not extended. Subsequently, appeal court, my lord, the passed an order. Ultimately, final disposal of the my lord, your lordship, it was finally disposed of by Justice Gangopathyay, and thereafter, your lordship kindly have a look to this.
What was finally disposed of? This writ petition?
Yes, this is writ petition.
Then it was remanded again by the appellate court.
Yes.
You did not find any other bench, Mr. Body?
No. Not remanded.
I think I'm minded to grant that adjournment to Mr. Vandavadan.
No. Well, thereafter, well, your lordship kindly have a look. And I'll dispose of no.
What is your extreme urgency, Mr. Body?
My extreme urgency is this: not a single day this kind of headmistress be allowed to perform his duty who committed fraud.
No, she has.
Now she's acting by the order of the appeal court, subject to the result of the writ petition and non-equity in favor. So, my lord, I will show the observation of the Supreme Court regarding teaching post. I will show before your lordships. Now the locus standi, now your lordships kindly have a look to this order. Finally disposed of directing CBI inquiry. Although, my lord, there was no prayer in the writ petition for CBI inquiry, but I prayed. I prayed because the entire education's directorate.
Obviously, you prayed.
No.
Prayed PREYED.
Well, entire education directorate.
Yes.
Well, the secretary, ministers, board, presidents, all are in custody because they
So
have.
it was set aside by the appellate court on the ground of
On the
CBI.
ground of non-reasoning order. Only the ground. Your lordships kindly have a look to the order of
See,
the
if you introduce CBI into the picture, then obviously it will be set aside.
Yes, well, the CBI, apart from the CBI, because of there was no prayer in the writ petition. I prayed before the court that there should be an CBI, but there was no prayer in the writ petition. It's the admitted position. Well, how could I know after filing the writ petition, entire education directorate will be in custody? Because the investigation till date it is going on. Racket. There is rampant racket throughout the bank.
This was the start. No.
Start.
Anyway, so
Now-
I'll also look into the division bench order, Mr. Body. Yes.
Division bench order. Your lordships kindly have a look at this.
This is stay order. Is at page.
Yes, CBI was the reason.
Yes.
That was set aside and the court did not go into the merits.
Internal page, your 4, your lordships kindly.
Yes.
We have not gone into the merits of the disputed between the parties. All points are left open to be.
Yes,
extended by the
saw that, yes.
Lordship,
So everything is kept open.
yes, only on the ground of the
CBI.
impugned order not being supported. Only on the ground of impugned order not being supported by good reason.
And the thing is open now.
Order is going set. Yes,
So, but in the process that initial stay order goes.
yes, everything well of now the subject to the result of the writ petitions, it has been, your lordships kindly.
Oh, yeah, no, that portion, sorry, that portion, I'll look into that portion, that she will join.
Yeah, provisionally joined in the new school, such joining would naturally be subject to the result of the writ petitions. Second paragraph. Now for locus, my lord, I shall submit the other judgment. Locus point is judgment. No.
Lucas, you had already cited a judgment before Justice Shorter.
Now, before that, my lord, your lordships kindly have a look to this judgment
Hmm.
of division bench.
Right.
Locus. But this is reported in 2009, volume 2, CHL, page 440.
Yes, yes, this is the judgment, Justice
Yes,
Shankarga.
yes. My lord, your lordships kindly have a look to this. Kindly text trouble. Para 24.
24.
The page number can I remember?
Yes, yes.
This is 2009 to CHN 442.
440.
And paragraph 24, Mr. Bari is relying on para 24.
Para
Yeah.
24.
24, right.
Para 23 onwards, your lordships kindly para 23.
23 onwards, yes.
Pleading, it appears the writ petitioner have raised a point about the breach of statutory provision of the selection process, which framed the recruitment rules for appointment of the headmaster by the West Bengal School Service Commission in terms of the power exercised by them under the West Bengal Service Commission Act, providing minimum eligibility criteria as per academic qualification, namely securing marks, such and such. Such fixation of the minimum academic qualification being an eligibility criteria for headmaster, which will allow the person to appear in the selection process. If it is not properly considered, the person who did not fulfill the aforesaid minimum academic qualification being the eligibility criteria selected by the school, a positive interest to agitate this matter before the writ court when the managing committee failed to discharge their statutory duty obligation considering the aforesaid litigations. In the pleading of the writ petition has set up a positive foundation of the locus standi by pleading their interest and close attachment with the schools, as well as breach of statutory recruitment rule by the School Service Commission. It is settled legal position law. The writ of mandamus could be issued on a breach of mandatory statutory provisions, as in type of the cases the writ court is to enforce, enforce such statutory public duty involving the matter. This point has been considered by the apex court. Now, my lord, several judgments have been. So far as the locus of the writ petitioner to seek a writ mandamus, the earlier conservative view, the persons must be aggrieved or in respect of the selection process, this person must be a party in the selection process, now have got a sea change by identifying the scope of Article 32, Article 226 of the Constitution of India. Whereby it is now settled law, there is no such rigid limitation and or for technicality of maintainability of the writ petition to reach injustice wherever it may exist. Reliance may be placed to the judgment places UP State versus Cooperative Land and Development Bank. The public law concept and the private law ingredients gradually now merged and the distinguishing features have been marginalized. Reliance could be placed in the judgment passed in AIR. But these are the reference has been given. In the instant case, breach of recruitment rules relating to the minimum eligibility qualification of a candidate aspiring the post of headmaster, writ petition cannot be dismissed on the sole ground that the person filed the writ petition has strictly no locus standi. Reliance may be placed in such and such. To show now the legal concept of the locus standi to move a writ court by a person seeking a writ of mandamus has got its change of structural.
Mr. Bari, I have seen it.
Yes.
So you have said that you are closely attached because you are already acting as a president of assistant headmaster and president of the managing committee.
Attention.
Right.
Now, Mali, your lordships kindly, the last portions, para 33, if your lordships kindly have a look. The court of law should be jealous to see the rule of law is established. Function of the writ court accordingly is not countered by any limitations of the prerogative writ alike in English courts in this jurisdiction.
Yes, the irregularity has to be brought to the notice of the court to invoke the power of judicial.
Yes. Now, my lord, the other judgment also in 2007, 2000 volume 7 SCC, page 552. Page 552. এটা জয় স্যারকে দিয়ে আছে না দিয়েছি
এটা কি দিয়েছে আগে না
para my lord the 13 and 14.
Yes, 2000 volume 7 SCC 552 para 13-14.
Para 13 and 14. In the context of the public interest litigation, however, the court in various judgments has given the widest amplitude and meaning to the concept of locus standi. Now it has laid down the public interest litigation could be initiated not only by filing formal petition in the High Court, but even by sending letters to the telegram on the writer.
That is public interest.
No, the court held that the restricted meanings of the aggrieved person and narrow outlook of the specific injury has yielded in favor of the broad and wide construction of the work of the public interest litigation. The court further observed the public spirited citizen having faith in the rule of law are rendering right social and legal service by espousing causes of the public nature. They cannot be ignored and overlooked on a technical and conservatively restrict the rule of locus standi or the absence of the personal loss or injury. There has been a spectacular in takes explanation of the concept locus standi. The concept is much wider. It takes it strict anyone who is not a mere visible. In the light of the expanded concept of the locus standi, also in view of the finding of the Division Bench High Court, the order of the Excise Commission was passed in violation of the law. We do not wish to nip the motion out solely on the ground of the locus standi. If the Excise Commission has no authority to permit a liquor shop owner to the move out the range for which have its business in another range, it would be improper to allow such an order to remain alive, operative in the sole ground. The person who filed the writ petition has strictly no locus standi, so we proceed to consider the contention on merits. Thereafter, my lord, the other 2021-10 SCC, page 717, para 17 and 18. Para 17 and 18.
Which?
You lordship got it?
Page, my lord.
2021-10 SCC, page 717. 717. Para 17 and 18. We also endorse the opinion of D.Y. Chandrachud J. writing for 3 judges bench Food Corporation of India versus Jagadish Balaram Bahira, where the court has noted the responsibility of the courts to guard against the fraudulent appointment, especially when such appointment is obtained by perpetuating fraud upon the authorities. And my lord, 18, fraudulent practice to gain public employment cannot be conducted to be permitted by the court of law. These are the so far locus is concerns. Now, my lord, your lordship, kindly permit me to enter into the merit of the case.
Yes, please.
My lord. Now, my lord, what has happened? Your lordship kindly takes the writ petition. Page 25. Page 25.
Yes.
Is the initial appointment of the respondent number 12, which Mr. Agarwal is appearing. In the year of 2016,
right.
she was appointed as assistant teacher of Aminpur High School. Your lordship got it? From there, she came to the, my lord, to our schools, Sri Guru Vidya Mandir, by way of transfer. Now, my lord, from Sri Guru, she was appointed as a headmistress on, my lord, the 29th day.
Oh, she had been to your school previously.
She was the assistant teacher from, my lord, from Aminpur to my school.
At that point of time, you were there also.
I was there.
So you have some reason for apprehension also because you had seen her.
Yes, because this now, my lord, she became the headmistress of his schools, and she was recommended.
Mr. Bari, can you please just file? Today it won't be over probably. Can you just carry on with your arguments, finish your arguments, but just can you file a very short list of
yes,
just the timeline? She was initially in this school, from then to just the school names and the dates.
Yes, well,
just that. I'll find it in the writ petition in any event.
No, person did not take trouble.
Right.
Three dates are very important.
Yes.
3 dates are very important.
What are the dates?
Yes. No, delay how much? My lord, on 21st February 2006. 21st February 2006.
Yes.
My lord, the respondent number 12 was recommended as assistant teacher in Aminpur High School.
Yes.
On, my lord, 5th July 2016.
Hmm.
She was transferred from that schools to my schools.
Hmm.
On 10th December 2019, 10th December 2019, she participated in the process of headmaster and headmistress selection process. On 19th, she was released on leave from my schools. 19th December 2019. Now, my lord, she joined the Birpara High Schools on 20th December 2019. Birpara Girls High School. My lord, on 22nd December 2020, 22nd December 2020, she transferred Omyopal Chaudhuri Sthiti Vidya Mandir as a headmistress. Omyopal Chaudhuri Sthiti Vidya Mandir as a headmistress. First transfer, general transfer order. But she didn't join there. Now, my lord, on 29th October 2021, she again transferred from Birpara to Sri Guru Vidya Mandir in my schools on the special ground. First, my lord, the general transfer to Omyopal. Now this is the special ground in my schools. Thereafter, my lord, in November 2021, I filed the writ petition, got an stay. Thereafter, the matter was coming from this court.
This last transfer is the impugned transfer.
Yes, last transfer. Now the question of what is the rule says. The rule says there is a provisions of the general transfer, there is a provision of the special category transfers. Now, my lord, in all transfers, minimum 5 years service is required to be obtained in a particular school. Thereafter, my lord, it is continuing. My lord, what they did in the meantime, my lord, what was happening under the rule.
So both in general and special, 5 years is
Yes, your lordships kindly have. Two 2015 rule. Now, your lordships kindly come. Rule 3.
Yes.
Primary condition of the general transfer. An incumbent shall be eligible for general transfer only if or she is confirmed in service and completed 5 years satisfactory service in that particular schools. Lordship got it?
This general transfer.
But twofold submission I am making. One criteria, confirmed service on particular schools. She has joined the Birpara. Birpara, he should, my lord, discharge her duty 5 years at the relevant point of time and confirm service. She has not been confirmed, my specific plea in the petitions. She was not confirmed in Birpara High Schools. Now completed 5 years.
Was she confirmed in Omyopal Chaudhuri?
No, she didn't join.
Oh, she didn't join, right?
Didn't join.
Right.
He was taken, this transfer order was not served upon him.
Right.
Question of serving or not serving, you made an application.
Yes.
Now, my lord, the clause 3, rule 3, clause 3, if you
Yes.
where an incumbent refused to join his or her preferred school after due recommendation by the commission, such incumbent concerns shall not be allowed to submit application for 3 subsequent terms of the general transfer, including inter-regional transfers. So, where is more bar? If the Omyopal, she was given transferred, I joined or non-join, possibly I didn't join there. That gentle lady. So, my lord, she will not be allowed to submit for 3 subsequent years. Now,
Okay, what is the subsequent terms of general transfer? Terms means what is the term?
My lord, the general transfer after
For 3 subsequent terms means 5 plus 3, 5 into 3.
my humble submission will be, your lordship is correct. 3 subsequent as per law. Now, my lord,
What is subsequent terms of general transfer? I'm not acquainted with this.
no,
One term is 5 years.
one term is 5 years. Now it has been reduced. Now it has been reduced to 3 years. Now it has been 3 years. Now,
So
my lord,
this rule 3 5 years has now become 3.
3.
Well, anyway.
Now, my lord, at relevant point, that is a 5 years. Sir. Now, clause 3 and special transfer on special count, clause 4. An incumbent belonging to the following categories may apply for transfer on special grounds.
What was her special ground?
That I do not know. That I do not know.
You know about her better than herself. You're ready with a bamboo as well as whatever.
She filed an application on medical ground. On medical ground. Now, my lord, the medical ground, if the medical ground, then, my lord, what the rule says, when your lordship kindly takes trouble, clause, when the rule 7. Rule 7, if your lordship kindly.
What about rule 4? We'll come to that later.
No, rule 4 is there.
And come with
4-1.
oh, that is the grounds of grounds.
Ground. They see, my lord.
There is no time stipulation there.
No, special ground is time stipulation is there. That judgment, my lord, I shall show before your lordship.
Very well. Let us come to 7.
Now, my lord, the 7. If it is a special ground, 4-7 prescribed, the teacher shall submit an application with sufficient documents for consideration of the managing committee in connection with the transfer on medical ground.
No, this is rule 7. Rule 7.
7. In
Yes,
terms of the clause 4 provides, my lord, special ground transfer.
Right.
If it is a medical, then, my lord, rule 7 provides certain formalities. What is the prescribed procedure? The teacher shall submit application with sufficient document for consideration of the managing committee in connection with the transfer on medical ground. The managing committee may, after examination of the prayer, after receiving the views of the medical practitioner of the committee, forward the prayer of the resolution to the district inspector schools, who will forward after verification of the vacancy as per option submitted by the teacher and non-teaching staff, where he or she may desire to be transferred to the school education department. The school education department may, after proper examination, recommended the prayer to the West Bengal School Service Commission. In case of inter-district reallocation service, the department shall cause of necessary inquiry on vacancy.
This was not done by her.
Nothing. No. Even, well, I will, well, now she has filed an affidavit of opposition. If your lordship kindly takes her affidavit of opposition, your lordship kindly.
No question.
Your lordship got it?
You are respondent number
12.
She's 12, sir.
She's 12.
Page.
Opposition has been filed.
Yes, got it.
Now, Mala, what she says? Mala, your lordship kindly turn. Clause number. Mala, the paragraph 7, clause 10, Roman 10. Para 7, Roman 10.
Yes.
I joined the headmistress of Birpada Girls High School on 20th December 2019 in terms of my release order dated 19th December to issued by Sri Guru Vidya Mandir High School. Your lordship got it? Now, my lord, the para 12. By a letter dated 7th December 2020, I made a prayer before the president of the managing committee, Sri Guru Vidya Mandir High School, through the teacher in charge, for extension of my lien for the next year. That is till 19th December 2021. But the managing committee, Guru Vidya Mandir High School, did not communicate any decision thereon. On the other hand, uploaded the Uchchasri portal. There is a vacancy of the assistant teacher in English. Now, my lord, the para, very important para, our own admissions. Para 14, Roman 14.
Yes.
Upon an application being made for my transfer on special ground, with options Sri Guru Vidya Mandir High School, Siliguri, Ghognamali High School, Siliguri in prescribed format, the state, since being the empowered to consider the same at the relevant point of time, transferred me to Omio Gopal Chaudhary Siliguri and forwarded such transfer order to the board for issuing necessary order. Board issued the letter 22nd December 2022. The lords have got it. 22nd December 2022.
20.
Yes. 22nd December 2020. But the same was neither informed me nor served upon me, as such the said fact came to my notice only upon receipt of the recommendation letter on 20th December 2021 issued by the commission. The submission made on behalf of the writ petitioner in course of hearing, I did not accept the first order transfer is incorrect and misleading since the said offer was not served upon me. As such, the question of refusal doesn't arise. She made an application, it was not served upon her. Because, my lord, I have a choice that I will go to the A schools, not B, not C. To show, my lord, when I came to know the B school was given, I didn't accept. Then the try, my lord, A schools. By the said recommendation letter on 27th, next para, 15, by the said recommendation letter on 28th September 2021, I was recommended for transfer from the existing school, Sri Guru Vidyamandir High School. However, my designation was recorded inadvertently as in teaching place of headmistress. Also, there is an inadvertent mistake in recording the district and police station in this case. All in hurry. All in hurry. So, my lord, it was corrected. Now, my lord, this is the relevant, this is the own admissions that are within a 1 year, no prescribed, nothing else, no medical certificate, no managing committee regulations, no NOC, no release order, no permission, nothing. Now, my lord, affidavit.
She just says the state since being empowered to consider. Only this.
Now, your lordship kindly affidavit in reply.
But you are relying on Rule 7, which does not say state only. I mean, that entire procedure has to be gone.
Now, my lord, your lordship kindly the affidavit in reply. If your lordship kindly, how he has.
এটা একটু আলাদা করে দিতে, এটা ফার্স্ট আলাদা করে দাও, এগুলো একটু আলাদা করব।
This transfer order.
Yes. Reply.
This transfer order, my humble submission would be, was made by the minister in charge. Page 37. Page 37.
Let me find the reply first. Yes, reply.
Page 37.
No, this is reply to.
Reply to respond number 12. Affidavit reply.
Not yet found.
Your lordship got it?
Yes.
Now, your lordship kindly have a look. Page 37.
37.
Transfer of 160. That this while the investigation is going on. Transfer 166 employees government aided sponsored schools have been approved by the HMIC file note sheet number such and such, has advised to issue the recommendation letter for appointing authority for issuance of the transfer order only after assigning destination vacancy. Accordingly, 29 cases were earlier sent to the recommending authority out of 156 assigned vacancy. Now, out of above approved 166 cases, 03 cases are being sent with vacancy for issuance of the
That point of time, Mr. Chatterjee was the
minister in charge. Mr. 2020.
So that justifies this.
Now, your lordships. Now, your lordships, my lord, the list.
Yes.
List. Well, how powerful that our private respondents. List 38. This is the list of 166 candidates. Page 43. Page 43. 156 is the Santa Mandal. Great, powerful, glorious, everything. Your lordships got it. Jalpaiguri, Birpara Girls School, Jalpaiguri, Siliguri, Jalpaiguri. NOC, no. Kalam. 156, last page, page 43.
This NOC is to be.
NOC is required to be. Either NOC, she cannot move. I am the schools. Neither Birpara nor Sri Guru has issued the NOC, nor medical certificate, no NOC, no application has routed through the district inspector school. It should be gone to the department. Nothing.
That is why actually CBO is directed.
Right. Extremely.
Now I get it.
Now, my lord, the 156 without no objection. This is a matter of record.
Yes.
Now, my lord, the very interesting the reply, the opposition of the School Service Commission, if the lordships kindly have a look at this. Opposition of the School Service Commission. They will have an opposition on behalf of the respondent number 6 and 7. What they said.
6 and 7 at the
respondent School Service Commission.
Oh, all right.
Assistant Secretary of Small Central School Service.
Opposition.
Very My lord tactfully avoided the query of the court and the query of the para 4 EFG. Your lordship kindly. Para 4 EFG, your lordship kindly.
EFG, yes.
I say, page 4. I say the above mentioned 2 recommendation letter issued by the commission were issued on the basis of the decision taken by the director of school education. 2 means Mala Omyopal and Mala Birpara. How the 2? Even my lord, the one is not eligible. From Birpara to Omyogopal also is not eligible. What the reply? I say the above mentioned 2 recommendation letter issued by the commission were issued on the basis of the decision taken by the director of school education. Memos issued by the said director. The commission only issued the recommendation letter pursuant to the memos of the director of the school education. Had no role to play with regard to the decision taken of the transfer of the said Shantamondal. However, after said Shantamondal was successful in being recommended and appointed as the headmistress of Birpara Girls School, she has been transferred only once, that is Sri Guru Vidya Mandir. The second recommendation letter issued by commission was only a correction and error of the first recommendation. With regard to the Shantamondal recommended Omyopal Chaudhuri, I say the said recommendation was issued by the commissioner of the school education directly to the West Bengal Board of Secondary Education in terms of the notification issued by the school education department, government of West Bengal, under which the commission had no role to play in terms of the matter. Accordingly, with regard to the said general transfer order dated 22nd 12/2020 issued by the West Bengal Board of Secondary Education on the recommendation of the Commission of School Education, I have no knowledge and offer no comment. Very interesting. This school notification such. G. It is pertinent to mention by an order dated Portion Sundar Tarabda, the Honorable Court was pleased to direct the state response to specify the address. The issue of whether the applicant could have been recommended for transfer within a period of 2 years from joining the post as headmistress within 1 year from refusal of the past offer of transfer. It may be noted that as per Rule 3(1) of the extant rule, West Bengal School Service Commission General Transfer Special Reallocation Rules 2015. As an incumbent shall be eligible for general transfer only if he is confirmed in service and completed 5 years. She admitted confirmed in service, completed 5 years, then she is eligible. Why not illegality at Calcutta? Now, my lord, I shall be only 2-3 judgments. I shall be finishing my in this judgment.
Mr. Ganguly, you are appearing for whom? Safest.
Now, the lordship
Yes.
the reported. This is a headmaster, Godavari Shitanath High School versus Bopita Samatha.
Ms. Sabai, please give the citations for Mr. Agarwal.
This is the 2018 Volume 3 CHN, page 193.
2018.
2018 Volume 3 CHN, page 193.
Yes.
Not audible, man. Well, citation is not audible, man.
2018 Volume 3 CHN, page 193.
193.
193. Para 16. And thereafter 92 to 24. 16. Before that, para 18, only 1 or 2 lines I shall be drawing in lots of kind of para 8.
8. Yes.
Referring to the merits of the appeal, Mr. Ghosh contended that the conduct of the lead petitioner was unworthy, even a bare consideration of her prayer not to speak of any recommendation for a transfer. He highlighted the fact that lead petitioner since her joining July 27, 2000 had discharged duty as a teacher for a few months before she proceeded on leave, and from January 2nd, 2000. Thereafter, she did not resume duty, went on submitting application for leave conduct pretext. When she applied for transfer in July 22, 2000, by approaching the Honorable Minister in charge of School Education Department to the government, the transfer rules have not been seen in the light of the day. Yet Rule 4 was invoked in her cases and recommendation made in terms of the Rule 7 without government seeking the view the applicant as to why they had not taken steps in terms of the Rule 7.2. Our petitioner was also drawn to Rule 3, which obtains orders the none can apply of the transfer under the transfer rule before completing 5 years of service. Now your lordship can be para 16. It would be pertinent at this stage to clear a legal issue arising out of Mr. Rai's interpretation of the rules 3 and 4. The issue is whether a teacher not fulfilling the criteria appearing in Rule 3 can claim a right to be considered for transfer.
Oh, this is that judgment you are saying you will cite that is applicable to special transfer.
Criteria appearing in Rule 3 can claim a right to be considered of a transfer on the premise that he or she fulfills any of the special counts appearing in Rule 4. Now, answering the issue, answering the issue would require reading the rules in Interim. General transfer is defined in Rule 2F, transfer and employment of his school from his present place in posting in his school to another place, same category, vacancy subject and post another school. A conjoint reading of the Rules 3, primary condition of the general.
Let us come to para 21 directly. Although all the paragraphs may be read.
Submission of the application for general transfer by a teacher. The conclusion is
irresistible.
The submission of the application for transfer special count is headed with fulfillment of the primary condition interpreted by Rule 3. Also in terms of Rule 7, a medical count the school upon receipt of an application for transfer on medical count is required to receive that matter have shown here also. Is required to receive the views of a medical practitioner, whereupon the prayer for transfer with an appropriate education is required to be forwarded to the school to the district inspector schools for onward transmission to the school education department. It is only after proper examination of all the papers so received, the school education department may recommend the prayer for transfer to West Bengal.
Sorry.
14 ordinance, it shall be mandatory for the managing committee of the concerned school to issue no objection. Well, that I repeat, people not say to issue no objection certificate to the eligible applicant as well as issue release order to him to join the school to which he has been transferred once a recommendation for transfer is made by the Central Commission. Three factors go against the restriction. First, he had not made any application for general transfer on special ground after the transfer rules are notified in exactly in the state. No.
All the three probably apply to you.
Yes, but no application for transfer was he made direct application to the commissioner or the signature. From the materials that were available in the record, it doesn't appear the repetition on a spouse son has been suffering from any kind of disease spelled out in Rule 4.1. The attempt of Mr. Rai to bring the case of the repetition within the last ordinance in Rule 4.1 to the repetition, assist the proper treatment of a son is one at once in discouragement. The son of the repetition, a young kid of 22 months, was stated to suffer from cold and cough as well as high fever. Most children of such age usually suffer from such a routine, and the repetition of son is no exception. Rule 4.1a cannot be read.
Court was really angry.
Cannot be read broadly so as to include any disease on which the teacher, spouse, and child suffers calling from assistance of the proper treatment. Thereafter, for which transfer could be contemplated. We are inclined to hold the treatment of the disease of the nature found in Rule 4.1a would be the absolute necessity if a teacher seeks to obtain a general transfer on patient. Now, 25. Having held the petitioner was not intended to invoke the provisions of the transfer rule, we now move to look the file that was placed by Mr. Datta. The file hearing number such and such was generated once the petitioner came to the presented. In such file, we found a document generated reference to the file number. It contains a list of the teaching and non-teaching staffs of the different schools who had applied for transfer special count and whose prayers were recommended by the dignitaries. It further procedures to record that all the applications were scrutinized in terms of the transfer rules. Findings were noted against each of them. The list contains the name of 48 candidates. Majority of them were recommended by the transfer Honorable Minister in charge of various departments of the government. Honorable Minister of the State, Honorable Members of the Parliament, Honorable Members of the Legislative Assembly, Secretaries of the Department, Army Officer, Bureau Chairman, Kolkata Municipal Corporation. The name of the petitioners appeared to serial number 16. Curiously, her case was not recommended by anything. Also, since he has repeatedly suffering from high cholesterol, triglyceride, uric acid, sugar, etc., it was observed in the notes he had no genuine special count. Despite the same, the petition name came to be recommended. For the purpose of the decision of the present appeal, we need to embrace the Honorable Minister in charge.
This was a different minister in charge.
No.
Same.
Now, other matter, I do not know whether it has been reported or not. This is the, I can give the reference. This is Himani Padya. Himani Padya versus the state of West Bengal. That division bench.
Give me the paragraphs, Mr. Wari.
Para 15, 17, 23, 20. Para 15, the rules have been explained. Para 17.
Because otherwise we cannot conclude. We have only 3 days.
I'm giving the parallel also standing. 17, 20, 28.
19, 20.
33, 34?
Here, was the person comes and joined.
Hmm.
So discharging whether she will coming back or whether some mercy should be given. The court should know. And in this case, the packets were still there before I should sit there, I have been there. Only one matter I have taken distraction was there. So, example of illegality, what are there? It is admitted by the petitioner by the respondent 12 itself. The same made an application. There is no program, no complaints, no rule, everything was done. Only Mr. Agarwal point is.
My last citation I could not follow. My last citation.
Last citation, Mr. Agarwal, that is an unreported judgment. Please take down. It was dated. It was a division bench judgment of Justice Dipankar Datta. The date was July 31st of July 2018.
July 2018.
And the name is Himani Parya. Himani Himani Parya is Parya. Parya. Versus State of West Bengal.
Himani Parya. Parya.
And if Mr. Agarwal you are in difficulty, Mr. Rai will help you out.
I will find out.
With his croaking voice, because he must be so busy in Calcutta.
No, my lord, I am appearing in this matter.
She can make under the rule within the time of 1 year. Let us show this application made in the prescribed form.
Let us show any of the compliance of the rules.
Any of the complaints of the rules.
Yes.
Any of the complaints.
Mr. Datta, you are appearing for whom?
My lord, I am assisting Mr. Ray.
You are assisting Mr. Rai. Mr. And Mr. Rai is appearing for?
State, my lord.
Yes, my lord.
Oh, he's leading you. Then you are safe. Mr. Agarwal, you are at the receiving end now for the time being. Come back tomorrow.
My lord, tomorrow matter is before my lord Chatterjee.
I'll close arguments, Mr. Agarwal. You cannot avoid court.
I'm not demanding.
I've got the taste of blood. So no.
Only day after tomorrow. Only day after tomorrow. Because
Day
tomorrow
after
matter is
tomorrow?
already fixed. Yes, my lord.
Day
At
after
3 p.m.
tomorrow. Today we are on 19th.
21.
Day after tomorrow.
My
Yesterday when the matter was called on for hearing, an adjournment had been sought on the ground of learned senior counsel appearing for the respondent number 12.
It was on Friday probably.
Friday.
Oh, sorry. Thank you. When the matter was last called on for hearing, an adjournment was sought on the ground of learned senior counsel appearing for the respondent number 12 till the next circuit in view of non-availability of said learned senior counsel. However, such prayer was opposed by learned counsel for the petitioner in view of the urgency pleaded to the effect that the respondent number 12 is allegedly functioning as a teacher in the concerned school,
Headmistress.
as a headmistress in the concerned school, which would be detrimental to the interest of the said school according to the petitioner. Next para, in such scenario, the matter had been adjourned till today. When the matter is called on for hearing, an adjournment is sought on behalf of the state. However, since the matter was fixed today, such prayer was refused and the matter was taken up for hearing. However, subsequently, learned counsel for the state joined the hearing. Heard in part, for further hearing. Day after tomorrow, Mr. Agarwal.
My lord.
the matter shall be, no, but day after tomorrow it won't be finished. Mr. Rai, you have to submit something on this. I mean, substantial arguments.
No, my lord, I don't think so.
Then I'll keep it day after tomorrow for Mr. Agarwal to argue basically.
Well, I'll maximum argue 5 minutes. If I'm
Very
called
well.
upon, my lord, because
Very well. For further hearing, day after tomorrow.
My lord, deeply obliged.
very grateful.
Yes.
My lord, only prayer was that, my lord, this school service commission.
No, Mr. Badi, if you want to cite some other judgment, then just give a previous notice to Mr. Agarwal so that he can deal with that also on the next day. Give a notice to Mr. Agarwal that he will be citing that judgment.
And my lord, let him serve a copy of the affidavit by school service commission. I have not a copy of that. I have not been served. What stand they have taken?
I don't know. Thank you.
My lord,
Very grateful. Very grateful.
Yes, Mr. Agarwal.
my lord, may I pray for your lordship, my lord, to kindly direct Mr. Bari to supply a copy of the affidavit furnished by the school service commission.
Ask from the School Service Commission. Yes, exactly, sir. Whatever copy you have not got, Mr. Agarwal, just send your clerk to Mr. Rai so that he can give you those copies at his own expenses.
Mine.
But that is not one, but if I have it.
That is school service commission, not Mr. Rai's client.
No, even then. Why? Mr. Rai will give for school service. He is responsible. Ultimately, the state is responsible for all the wrongdoings.
I can seek from Mr. Bari also.
No, these are innocent faces I see on the screen. At least the bottom two faces are innocent.
And my lord, I am also not conversant with this law and rules your lordship knows. But
let us, yes.
Deeply obliged.
Bottom to the car মুখ ছিল আমার ছিল
তোমার নাম
bottom two faces তো